removed. And then, of course, the sense that we've gotten from the defense is that basically nothing to see here. And also that they're saying essentially that there was a coup, that these hand-picked members of Ken Paxton's office got together and decided that they wanted to get rid of him. And that
Senator Alvarado, I believe you are delivering the prayer this morning.
Good morning. In the name of the Father, Son, and Holy Spirit, amen. Heavenly Father, in this sacred chamber, we come together as servants of the great state of Texas, united by the privilege of serving our fellow Texans and serving you, Lord. As we near the end of these proceedings, let us take a moment to reflect on the weight of our task and express our gratitude for the trust placed in us. We recognize the solemn responsibility that accompanies our positions, and we pray for the guidance and wisdom needed to make decisions that honor the best interests of the state of Texas. As we stand here today, representing different communities and backgrounds, we are thankful for the strength that comes from our differences. It is through unity and collaboration that we find common ground, work together harmoniously, and uphold the values that define this great state. We are grateful for the opportunity to serve, for the chance to make a difference, and for the trust that has been bestowed upon us. May your grace shine upon this chamber, lighting our path as we navigate the challenge before us with humility and dedication. With your presence, Lord, as our guiding light, we are confident that we will meet this challenge with unity, integrity, and a shared commitment to the people of Texas. In your name, we offer this prayer. Amen.
Amen. You may be seated.
Okay, so we are watching things unfold there in the chamber. We just heard from Senator Alvarado talking about delivering a prayer, talking about doing this with unity and integrity. We are expecting closing arguments to begin any moment. Each side has... Okay, we're going to take a listen. Okay, so, Bud, what are you expecting to hear this morning from both sides?
Well, you know, considering the senators that I just named, who are the swing votes, two of them have a law enforcement
Good morning,
history.
everyone.
Phil Kagan from Weatherford.
In the gallery and those who are watching online. Before I begin, I have a few remarks to make. I first want to thank our clerk, Patsy Spa, and her entire team, and Austin, our bailiff, and all his team for their work during the trial. I've had questions, who are these people behind me? They've never been introduced. This is Darrell Davila, my chief of staff, former prosecutor, strong legal background. This is Chris Turner, my legal counsel, strong legal background, working for governors before this, and Lola Fender, our deputy chief counsel. They've done tremendous work, and of course, Judge Lana Myers, who served as a prosecutor on a criminal court in Dallas and on the 5th Court of Appeals. I would not have been able to worked through these last 2 weeks without them. As I said on day one, I've never been to law school, I've never taken a course, but we prepared for the last 3 months to do the very best job that we could to present a fair trial, which I think we have done to both parties during this time. We've read thousands of pages of documents of history of legal proceedings, and I even took a little bit of a judge boot camp along the way. So we've done the very best we can, and in a very short period of time, the trial will be in the hands of 30 members of the Senate who will vote. This impeachment trial, for only the third time of a statewide impeachment in the history of Texas, has been closely monitored, either through the media or through people watching online each day. I want to take a few minutes to go over a few of the key rules and to explain about what is to happen, because this is an unusual proceeding, not a normal trial. And I want to be sure the media reports it correctly and that the public understands everything we do will be in total transparency throughout this process. First of all, we talked about the rules a lot in here. The rules were written and voted on by the members of the court. The final vote was 25-3. And these rules set out the framework for what has happened and what is about to happen. Let me highlight a few of the rules that we often get the most questions on. Pursuant to the rules written and adopted by the senators, Senator Angela Paxton cannot vote because of a spousal conflict. That's in Rule 31. However, the members kept the threshold to convict on any article at 2/3 of 31 members. That means it still requires 21 votes to convict, even though only 30 senators will cast a vote. It only takes a conviction on one article of the 16 articles to remove the Attorney General from office. Like any jury, the senators will deliberate in private, but under Rule 28, the senators will cast their vote in open court on the Senate floor without debate, one article at a time, after each member has finished their deliberations. All 16 articles will be voted on. I want to point out that under Rule 28, it provides that an article of impeachment is not divisible. What does that mean? That means the senators must consider each allegation in each article and determine whether the managers have proved each allegation in an article beyond a reasonable doubt before they can consider whether an article warrants removal from office. Then and only then may an article be sustained. For example, if an article has 3 allegations in it and only 2 are proven beyond a reasonable doubt in the mind of a senator, then a member shall not vote to sustain that article. Members, under the rules you adopted, I will read jury charges as written in Rule 27 after the conclusion of the final arguments. As I said in my remarks on opening day, your decision must be based only and only on the facts and evidence presented here in this chamber. You are the sole judges of the credibility of the witnesses. Evidence consists of the testimony of the witnesses and the materials admitted into evidence during this trial. Statements by attorneys in this trial are not evidence. Questions asked by attorneys are not evidence. I have no idea of how long the jury is going to deliberate. It could be hours, it could be days. Once they have notified me that all members are ready to vote, we will alert the media for a time certain when the members will come to the floor to cast their votes. And we will post that on the impeachment page of the state website. We will try to give the media and the public ample time to be ready for that time certain, at least 30 minutes notice. I know you are interested in the outcome of the trial, so check in on the website from time to time. No evidence whatsoever, members, outside this chamber shall be considered for any purpose. Nothing that I have said as presiding officer and judge, or that I have done, or how I have ruled, shall be considered as an opinion on facts or the case, and my words and actions should not influence your vote, one way or the other. I do not have the vote. You have the vote. The fact that the House of Representatives has preferred articles of impeachment to the Senate gives no inference of guilt. Like any defendant, the Attorney General is not required to prove his innocence or produce any evidence at all. The Attorney General is presumed to be innocent until proven otherwise. Even if a member believes the House managers have proven every element of an article beyond a reasonable doubt, the member may only sustain the article if they also believe Attorney General Paxton should be removed from office based on that article. The Senate jurors will begin deliberations today after final arguments, and they will continue as long as it takes. For the public, in some respects, understand this is like 16 trials in one. This is not a normal trial. They have to decide on 16 separate articles. Unlike a normal jury, the senators will not arrive at a group decision. When each member has come to their individual decision, they will come to the floor and vote one by one on each article. They will not have their phones with them during deliberations. They will not talk to staff during deliberations, legal counsel, or anyone else, members, only to each other during deliberations. They will be allowed, if necessary, depending on how long deliberations go, to sleep outside the Capitol. But under strict rules, members, you shall have no communications with anyone. You may not look at television, you may not look at your phone, unless it's a call from a family member, and they should not discuss anything. It should only be for a family personal issue. You can tell your kids good night, or your wife or your husband, but you shall not read any news, look at any news, go online, open up your computers. Before retiring to deliberate today, after closing arguments, each juror will be given a copy of the articles of impeachment. They will also be provided with all the exhibits that have been admitted into evidence. Both sides will have 1 hour for final arguments. The House Board of Managers, having the burden of proof, has the right to open and close final argument. They may divide their hour into any time segments as they wish for open and close. That means the House Board of Managers will argue first and last, but only for that total of 1 hour. The Attorney General's legal counsel will also have 1 hour for final arguments. Once again, after closing arguments by both sides, I will read the charge as you have written in your rules to the jury, and you will begin deliberation. I will now read the articles of impeachment. Article number 1, disregard of official duty, protection of charitable organization. While holding office as Attorney General, Warren Kenneth Paxton violated the duties of his office by failing to act as a public protector of charitable organizations as required by Chapter 123 Property Code. Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Mitty Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation in an effort to benefit Paul. Article number 2, disregard of official duty, abuse of the opinion process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to issue written legal opinions under Subchapter C, Chapter 402 Government Code. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of a Senate committee to serve as a straw requester. Furthermore, Paxton directed employees of his office to reverse their legal conclusion for the benefit of Paul. Article number 3, disregard of official duty, abuse of the open records process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. Article number 4. And both parties had asked me to read these articles before their closing arguments. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information of benefit to Nate Paul. Article number 5, disregard of official duty. Engagement of CAMIC. While holding office as Attorney General, Warren Kenneth Paxton misused his official power by violating the laws governing the appointment of prosecuting attorneys pro tem. Specifically, Paxton engaged Brandon Kamick, a licensed attorney, to conduct an investigation into a baseless complaint, during which Kamick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. While holding office as Attorney General, Article 6, disregard of official duty, termination of whistleblowers, Warren Kenneth Paxton violated the duty of his office by terminating and taking adverse personal action against employees of his office in violation of this state's whistleblower law, Chapter 554 Government Code. Specifically, Paxton terminated employees of his office who made good faith reports of his unlawful actions to law enforcement authorities. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice in their future employment. Article 7, misapplication of public resources, whistleblower investigation and report. While holding office as Attorney General, Warren Kenneth Paxton misused public resources entrusted to him. Specifically, Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints made by employees who Paxton had terminated, and to create and publish a lengthy written report containing false or misleading information or statements in Paxton's defense. Article number 8, disregard of official duty, settlement agreement. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by concealing his wrongful acts in connection with whistleblower complaints made by employees whom Paxton had terminated. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Article number 9, constitutional bribery, Paul's employment of mistress. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul's employment of a woman with whom Paxton was having an extramarital affair. Paul received favorable legal assistance from or specialized access to the office of the Attorney General. Constitutional bribery, Paul's providing renovations to Paxton's home. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Paul received favorable legal assistance from or specialized access to the office of the Attorney General. Article 15, false statements in official records, whistleblower response. While holding office as Attorney General, Warren Kenneth Paxton made false or misleading statements in official records to mislead both the public and public officials. Specifically, Paxton made or caused to be made multiple false or misleading statements in the lengthy written report issued by his office in the response of whistleblower allegations. Article 16, conspiracy and attempted conspiracy. While holding office as Attorney General, Warren Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more articles. Article 17, misappropriation of public resources. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by causing employees of his office to perform services to his benefit and the benefit of others. Article 18, dereliction of duty. While holding office as Attorney General, Warren Kenneth Paxton violated the Texas Constitution, his oaths of office, statutes, and public policy against public officials acting contrary to the public interest by engaging in acts described by one or more articles. Article 19, unfitness for office while holding office as Attorney General Warren Kenneth Paxton engaged in misconduct, private or public, of such character as to indicate his unfitness for office as shown by the acts described in one or more articles. Abuse of public trust, Article 20, while holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of the Attorney General into scandal and disrepute to the prejudice of public confidence in the government of the state, as shown by the acts of described in one or more articles. Members, would both parties come forward for a moment?
Okay, so you can see they're calling lawyers for both sides up to the dais. We're waiting for closing arguments to begin. We just heard Lieutenant Governor Dan Patrick read the 16 articles of impeachment and also explain how the voting will work. Bud, talk to us, walk us through what Dan Patrick explained.
Well, of course, he read off the articles of impeachment, and he left a few out. If you were trying to count, he left out the ones related to the securities violation. That's still in court. It'll be tried in court, and so the Senate is holding those in abeyance. So at the end of this trial, at the end of this voting, Warren Paxton is still impeached until those articles are disposed of. The Senate can vote to dismiss them at the end of the day, or vote to continue with them as the Senate chooses. So what we'll do when they go to voting is each senator will vote on written pieces of paper. They'll draw those pieces of paper, read their vote, and then they'll poll the jury and ask each senator to repeat how they voted. And we'll do that 16 times on each article.
Wow, when you think about it, that's just an amazing scene. As Lieutenant Governor Patrick described, this is not a normal trial. You can see right there is suspended Attorney General Ken Paxton seated in the Senate chambers. It's the first time we have seen him in the chambers since day one. The rules only require that he be there for the opening of proceedings. So presumably he will stay around to hear the closing arguments and to hear how each side is going to wrap this up. Stephanie, talk to us about what you expect to hear in these closing arguments.
Well, I expect the state obviously to highlight the things that they feel have proved to the senators that this is not somebody that's worthy of continuing public trust, somebody that's not capable of carrying out their oath of office. They're going to highlight probably the witnesses who came forth, call them courageous for coming forward to share that information, to be whistleblowers. We're going to hear the defense say, hey, it's close, but not good, maybe not good enough to convict my client. Them having him here too is very smart. Just like in a criminal jury trial, you want people who hold your client's fate in their hands to look your client in the eye to see, like, this is a person that it's an honor for me to represent. I represent not only them, but the rule of law. You want him to be seen as human. That way they're going to be making this decision about his career, and as we all know, could possibly affect any criminal prosecution that happens.
Okay, so let's take a listen.
The House managers have decided to open for approximately 10 minutes, and then the defense will speak for their 60 minutes, and the House will come back for the remaining time. I will give each, as they get to near the end of their hour time, I will give each side a 10-minute warning, a 5-minute warning, and a 1-minute warning. And I've told them that I'm not going to cut them off in mid-sentence, but they'll have to wrap up when I say their time is up. Mr. Murr?
Mr. President, members of the Senate sitting as Court of Impeachment, over the last 2 weeks, the Senate has faithfully carried out its constitutional duty to listen to the evidence. The framers of our Constitution placed a heavy and solemn responsibility on this chamber. The House did not come here lightly. We discovered unprecedented abuse in the Texas Attorney General's office by Mr. Paxton. As elected officials, we take an oath to protect the citizens of this state and the sacred public trust. The Constitution charges us with policing our own. If we don't keep public officials from abusing the capacity of their offices, then frankly, no one can. Mr. Paxton's attorneys like to remind everyone that he was elected by 4.2 million voters, but they have blindly ignored the fact that he has ultimately ended up serving one person, himself. Mr. Bangert explained Mr. Paxton's abuse of office in perhaps the most succinct way, and I'll direct you to your screen.
I was deeply concerned that the name and authority and power of our office had been, in my view, hijacked to serve the interests of an individual against the interests of the broader public.
With the help of Jeff Mateer, Ken Paxton was able to build an exceptional executive management team. Mr. Paxton's top advisors were thrilled to go work for him. They came to the office because they believed in him and what he stood for. They were unabashedly conservative, hardworking experts in their fields with rock-ribbed principles. He had hired the best and brightest to help run his office. Mr. Mateer explained at the beginning of trial that these advisors were committed to the rule of law and to conservative governance. In this trial, you have heard from 8 of Mr. Paxton's top and at one time most trusted advisors. There have been several discussions about what the evidence is, but of course their testimony is evidence. Mr. Paxton's advisors were excited about what the office was doing for Texas. They circled around Mr. Paxton and worked diligently to advance the promises that he had made to voters. The travesty is that Mr. Paxton's desire to deliver results for Nate Paul eventually tore the office apart. It metastasized and overwhelmed the office. When it came to Nate Paul, Ken Paxton abandoned and betrayed his trust in knowledgeable staff, his conservative principles, and his commitment to family values, the law, and his oath of office. He repeatedly demanded that his top deputies act as Nate Paul's personal lawyers and not the state's lawyers. He gave the keys to the office. His lawyers have come in here and tried to normalize his behavior. They're not denying that Ken Paxton did any of the acts alleged. Instead, they want you to believe there was nothing wrong with Mr. Paxton ignoring his senior staff's repeated warnings about Nate Paul. Hall of Fame Texas Ranger David Maxwell did not mince words. Your screen, please.
My evaluation of the allegations made by Nate Paul is that they were absolutely ludicrous, without merit, no probable cause, not even reasonable belief that a crime had been committed. The nature of the allegations that he was making were against the FBI an investigator with the Texas State Security Board, 2 U.S. attorneys, the senior federal magistrate, Mark Lane, and others who were involved in the chain of the signing and execution of the search warrants on his business, his place of storage, and also his home.
Now, it is clear that Mr. Paxton's judgment was completely clouded by his distrust of law enforcement. But his failed judgment does not excuse his intentional abuse of office. Mr. Paxton wants you to find that even though Nate Paul's story was ludicrous, that it was completely fine for him to hire a 5-year practicing attorney as an outside attorney to do Mr. Paul's bidding. He wants you to find that it was completely okay for Mr. Paxton and Nate Paul's lawyer to direct Mr. Kamek to issue grand jury subpoenas against judges, court clerks, police officers, and the spouse of a lawyer involved in a civil lawsuit with Nate Paul. They even want you to believe that going and getting a grand jury subpoena isn't really a big deal. This suggestion is absurd. The ability to issue a grand jury subpoena is a substantial power wielded by our government, and allowing a private citizen to take that power to attack enemies is truly shocking. And Mr. Paxton has admitted that he does not know much about criminal law. When he asked for money from this chamber to settle the lawsuit filed by staff members he wrongfully terminated, he wouldn't even answer a senator's question about the hiring of Mr. Kamek, and instead deflected to a staff member that he said was better qualified to answer. But when it came to Nate Paul and his requests, all of a sudden Mr. Paxton knew best. He refused to reply on the expertise of his staff. He balked at their warnings. And then he hid his actions when he went around them in his attempts to move forward in helping Nate Paul. And he is continuing to claim he knows best. He is sitting here today saying that he was completely entitled to do what he did and that these witnesses were some part of some deep state conspiracy. But once again, Mr. Paxton's claims are divorced from reality. The fact that every action complained of would have benefited Nate Paul is not mere happenstance. As Mr. Paxton's counsel has said, there are no coincidences in Austin. Now let's be clear about what happened here. Mr. Paxton enjoyed the power of his office. He enjoyed his relationship with Nate Paul. It facilitated the life Mr. Paxton wanted. And Mr. Paxton willingly and blindly wielded the power he loved so as to maintain the relationship he needed. This is wrong. The power of the office of Attorney General cannot and should not be handed over to a private citizen to use to attack their perceived enemies. Mr. Paxton claims that he wants the truth, but he hasn't even bothered to be here for the whole trial. He came on the first day, he left at lunch, and now he's here for closing. Clearly, he thinks that he might just get away with this. Had he been here, he could have seen the hundreds of exhibits and the thousands of pages that have been presented to you with 13 witnesses over 7 days that the House have meticulously laid before you. Mr. Paxton put the risk of the citizens of Texas, of the businesses of Texas, and the lives of law enforcement at stake. As the state's top cop, this conduct is and was inexcusable. His actions are precisely the type of grave official wrongs that our Supreme Court has explained merit impeachment. He may claim to be one of us, but unlike the public servants here today, he has no regard for the principles of honor and integrity. He has betrayed us and the people of Texas, And if he's given the opportunity, he will continue to abuse the power given to him. Mr. President, I yield the rest of my time for my closing.
Mr. Busby?
Got to get set up here, Your Honor.
We'll start the clock when he begins speaking. House, you have 50 minutes and 35 seconds remaining.
May it please the court. Here we are in the Senate chamber in the most historic trial that's been had in this state in the last 100 years on this evidence. There is shame here, and the shame sits right there that they would bring this case in this chamber with no evidence. I am proud to represent Attorney General Ken Paxton. If this can happen to him, it can happen to anyone. Now, you heard when we started this case, you heard in the media that the evidence is 10 times worse than the public knows, but what a farce that was. What a farce that was. What we have seen instead is a bunch of supposition, mights, maybes, could have been. That's what we've seen in this trial. The very first witness they brought to you, the very first witness they brought to you, it's not working, crumbled under oath. Do you remember? Do you remember Jeff Mateer? Crumbled under oath. So what is this case about? It's about nothing. It's about nothing. Think about it. They failed to gather all the evidence. They failed to review their own evidence. They failed to talk to all the witnesses. Think about this. Brent Webster, the first assistant, did they bring him here? Did they even bother to ask him a question? They didn't even ask him a question. He is the man who reviewed and documented every single thing that occurred. They didn't even call him. You know why they didn't call him? Because he puts to bed all of their foolishness and silliness. They didn't take any sworn testimony. They let witnesses assume and speculate. They failed to even understand the law. And they couldn't even write the articles correctly. Look at the articles that the judge just read to you. They use words pro tem. Their own witnesses admit there was no attorney pro tem. They use words like the Attorney General failed to protect charities. That is not the Attorney General's job. And let me make sure we're clear about something here. When the House Board of Managers brought this case, they made an assumption. They assumed that this man would quit. They assumed that this man would run and hide. They assumed that Attorney General Ken Paxton would resign. Well, guess what? He did not resign. He is proud and is ready to go back to work. And after this is over, I expect he will go back to work. He has been a rock. He has been a rock, and that office, the Office of Attorney General, has accomplished more than any Attorney General's office in the country. You heard it from the witness stand. Biden's policies come to die in Texas because Attorney General Ken Paxton. Now let's talk about the burden of proof. We've heard about the burden of proof here and there. Is this working? Can I have 1 minute? Can we get this working?
Yes, I've been informed that the PowerPoint connection to your screens stopped as soon as he began his...
There are no coincidences in Austin.
We will stop the clock here for a moment.
We're going to take just a moment. Can we get this going, please? I need it for the senators to see the screens.
Okay, so we're listening to Tony Busby. They're dealing with some technical difficulties there as he's giving his closing argument. And right now he is saying that that basically they have not proved this case, that if this can happen to Ken Paxton, this can happen to anyone. They're talking about, he's arguing that they allowed witnesses to come in and assume and speculate, and he's talking about how they, presumably meaning the House Board of Managers, assumed that Attorney General Ken Paxton would resign, and he's saying that he is proud and ready to go back to work. Stephanie, what do you think about what we're hearing so far?
I think that he's using the playbook 101 for defending a criminal client, defending a client. The state has not met their burden.
We're ready.
We always go there.
Do you want the screen to catch up to where you are?
Yes, sir.
Okay.
They thought he would quit. They thought they could bring a bunch of people, 15 people, not put under oath, with a bunch of supposition and guesses and mights and maybes, and they thought he would quit. The Texas Tribune, the Dallas Morning News, the Houston Chronicle, they thought he would quit. He did not quit. He did not quit. And he will not quit. Let's talk about the burden of proof. That is super important here. And I want you, senators, please, to look at your screen and look at the burden of proof. Beyond a reasonable doubt. Beyond a reasonable doubt. That means that you have no doubts that are reasonable. No doubts. That is an incredibly high burden. Can you imagine if we were in any criminal court in the United States that this case would not have already been dismissed based on what we've heard from this witness stand? This case would not even, we would not be in final argument. This case would be over. But this is not a criminal trial. This is a political trial. I would suggest to you this is a political witch hunt. I would suggest to you that this trial has displayed for the country to see a partisan fight within the Republican Party. Let's just call it for what it is. That's what we're seeing here. It's being played out on TVs across the country. There is a battle for power. Because there's no doubt that these folks did not prove a case. They didn't prove a preponderance. They didn't prove anything other than they don't like Ken Paxton. Remember this fella, Greg Cox. You remember that guy? Greg Cox. Maybe, potentially, possibly, might have, perhaps, conceivably, could be. He thought he testified that the Attorney General's office was so corrupt, they're involved in organized crime, but you know what? I want to go work there. What a joke. What a joke. I had text from my former Marine Corps buddies that said that guy is a joke. To come in here in the Senate of Texas and to get on the stand, and these people sponsored this guy. What a joke he was. And in my view, that's exactly what their entire case has been, a joke. Much ado about nothing. The burdens of proof. Look at the burdens of proof, senators. Beyond a reasonable doubt. Now, if you decided this case from the Houston Chronicle, the Texas Tribune, Texas Monthly, the Dallas Morning News, oh my goodness gracious, Ken Paxton's guilty. But there ain't no evidence to support it. The only evidence we have in this case is they don't like Ken Paxton. And there is no doubt there have been hundreds upon hundreds upon hundreds of articles about Ken Paxton, how bad Ken Paxton is. Everybody has heard it, and guess what? The voters heard it too, and guess what? Ken Paxton won, hands down, resounding victory. He beat the latest in line for the Bushes. Let it be known, let it be clear now. The Bush era in Texas ends today. We thought it had ended in the primary when Ken Paxton beat George P. Bush 68-32. Well, we thought it was over. It wasn't. Well, now we have an impeachment. It ends today. They can go back to Maine. This is Texas. This case has been nothing more than assumptions. And you know what my dad used to tell me? Assumptions make an ass out of you and me. And that's been this entire case. It's all built on assumptions and jumping to conclusions. Think about it. House repairs were paid for by Nate Paul. You know how sad this is? I had to come here on behalf of the Attorney General of the state of Texas and disprove their case because he had already been convicted in the press. And now we know. I had to prove it to young Drew Wicker. That young man believed, I heard a stray comment. And I jumped to a conclusion that the house repairs were paid for by Nate Paul. We all know now that was wrong. We all know now that was wrong, but that was in more than 100 articles across our country, smearing this man's name, smearing his wife's name, smearing a member of this body's name. And we all saw it when we put this young man under oath and showed him the documents. Guess what? Didn't happen. Wasn't true. And that is indicative of their entire case. We should not be in a position to where we have to come in here and prove our innocence, but we did. We did. The referral from the DA's office had nothing to do with banks. All of his top lieutenants had no idea there was a second referral. You know why they didn't know? Because the referral went directly to Mr. Kamek. They didn't know about the direct referral from the DA's office. And you remember Margaret Moore? She came in here and tried to pretend like she didn't know anything about it because she wasn't supervising her staff. Her staff knew all about it. Her top lieutenant knew all about it. They assumed the Kamek contract was never executed, but now we all have seen that Ken Paxton, in fact, signed that contract. They assumed that Laura Olson's job was not legitimate, but now we have seen her employment contract. We've seen her application. We've seen that she's still working for world-class properties and still doing real work. They assumed that Wicker, young man Wicker, delivered a secret package in the middle of the night in a dark alley. Never happened. But if you were to watch the news, and read the newspaper, oh my goodness, that happened. Even a Texas Ranger, think about this for a minute. You have a guy, 6'6", wears a hat, cloaked with the authority of the state, comes in here and says to these folks, I heard from 5 or 6 people that Drew Wickard delivered a secret package in the dark of night in an alleyway on behalf of Nate Paul. Totally false. When he was asked, who told you that? Ranger? I can't even give you one name who told me that. Totally false. I asked the young man directly, did you ever deliver anything at night? Did you ever deliver anything that had anything to do with public records? No. Never. Didn't happen. Look at the position these people had put this man in and his wife. Prove your innocence, Attorney General. You've been convicted in the press. Prove your innocence now. If it can happen to him, it can happen to anyone. Foreclosures were stopped. There was a press statement that multiple foreclosures were stopped because of some informal guidance. Now we know that's false too. Presumed false. And these people got up here and used words like conspiracy, crimes, bribery, all kinds of really loaded words, and all were false. And this young man, Vassar, who cried on the stand in front of all of you because he had been called a rogue employee, at the very time he was called a rogue employee, he was joking and laughing and poking fun and calling his new boss, Brent Webster, a jerk. But when he came in here at the urging of these people, he cried. He cried because he had been called a rogue employee. What is a rogue employee? A rogue employee is somebody that doesn't do what the boss says. You don't do what the boss says? Let me tell you something. When I was a captain in the United States Marine Corps, and my staff sergeant didn't do what I told him to do, he can register his disagreement, but when the rubber meets the road and I tell him, this is what we're going to do, he does it or he resigns. What he doesn't do, what he should not do, what he should never do is go behind my back, cook up bar complaints, cook up a bunch of foolishness and go to the authorities. That's not how it's supposed to work. This guy, Mr. Vassar came here, cried on the stand about being a rogue employee, but really the truth is at the same time he was called a rogue employee, he was laughing and joking about it. What foolishness is this? It's been 3 years since these so-called whistleblowers. Now think about what a whistleblower means. That means that you have to have evidence of a crime, and they admitted they had no evidence of a crime. And what have we heard from the FBI with regard to Attorney General Ken Paxton? Crickets. Nothing. Nothing. If you don't think that the Biden administration and its FBI and Department of Justice would not love to indict Ken Paxton, then you're not paying attention. They've done nothing. You know why they've done nothing? Because there's nothing to do. This man did his job, and he should still be doing his job. Staffers were not only wrong on their assumptions, they were wrong on the law. Can you believe that they didn't realize that the only person in that office that can actually have the authority to sign an outside counsel contract was Ken Paxton himself, and anybody else was designated. He's the only one that can do that. They didn't like that. This is a situation where the tail is wagging the dog. Imagine if one of your staff members at some point decided that, you know what, I don't think my boss has authority. I know more than the boss, so I'm going to be in charge now. That is not how it works. 4.2 million people decided who the Attorney General would be. They didn't elect Jeff Mateer, Ryan Vassar, Bangert, none of those people. Those are political appointees serving at the pleasure of the Attorney General, just as every one of your staffs are as well. They even had the nerve to come here in front of you and say, well, I believed that when Ken Paxton was in Ohio doing his job and trying to put together a group of attorney generals in a case against Google, well, he's out of the state, now we're in charge. That is not how it works. That is not how it works. Let's cook up a bar complaint against Ken Paxton. Let's allocate $50,000 to hire an outside lawyer by the name of Johnny Sutton without any approval or telling the boss. They figured out real quickly, once they talked to Maxwell, that, you know what, we don't have anything. We need to beef this up. We don't have anything. And even though it's been 3 years, they still don't have anything. And 17 lawyers over there working since May at $500 an hour for each of them. Hundreds of thousands of dollars wasted, taxpayer money wasted, and they still don't have anything. Now, how did this happen? Well, they made some assumptions, and then they figured out they had no evidence, and it was too late to turn back. Recall that one of the witnesses, Mr. Mateer, Mr. Bangert, said, well, once we went to the FBI, we were signing our death warrant. Rightly so. You go to the authorities with no evidence and accuse your boss of a crime, and there has been no crime, and there's been no evidence of any crime, and it's all a bunch of supposition and guesswork. Rightly so. And so they took a long walk on a short pier. The House managers did the same. The House managers did the same. They, in a 4-hour hearing, decided to impeach the Attorney General of the state of Texas, and then they spent months and months trying to collect evidence to support it, and they did not. They failed. And then the lobbyists got involved. The text of support. TLR, yeah, we were against Ken Paxton. We spent $6 million against Ken Paxton. We couldn't beat him at the ballot box. Maybe we can beat him. Maybe we can beat him in an impeachment trial. George P. Bush decided, let me re-up my law license because maybe I can be the Attorney General now. I couldn't beat him in a fair fight. Maybe I can beat him here. And every one of these so-called whistleblowers, which are nothing but disgruntled ex-staffers, they all hired the same lawyer who just happens to be in the Ashcroft law firm, who just happens to be a protege of the Bush regime. The Bush era ends today in the state of Texas. Have you ever met a lawyer that works for 3 years for free, who's a former U.S. attorney, who's doing legitimate work? Legitimate work? I want to focus the allegations, as best as I can tell, of what Nate Paul provided to our Attorney General are in 3 buckets: campaign donation, house renovations, and Olson job. Let's focus on the first one. The allegation is there was some sort of quid pro quo. You have to have a quid pro quo for bribery. They're throwing this word bribery around. That has a lot of meaning. In this case, it has none. And let's focus on the person who supposedly bribed our Attorney General. This pain in the butt. This described pain in the butt, Nate Paul. Entitled, insistent, overbearing, manipulative, pushy, threatening, presumptuous, brash, assertive, forceful, militant, but he really believed that he had been abused by the federal authorities. And let me ask you a question. Do we really believe that the federal authorities do not sometimes abuse people? Do we believe that? Do we believe that the FBI is always on the up and up? Do we really believe that the Department of Justice is always out to do the right thing? Or can we all agree that sometimes they pick and they choose who they go after? And when the federal government comes after you, you better buckle down. This guy thought he had been targeted by the FBI. And the only thing that this man did was, let's find out the truth. Let's see if that's really true. That's all he did. Because he knows a little bit about people coming after you with no evidence. He can identify with that. Heck, we see it here. The very reason I'm standing here. He was come after by a group of misinformed, ill-advised people with no evidence. That's what Nate. Now, do I know whether that search warrant was altered? We will never know. We'll never know. Nate Paul thought it was. We'll never know. And to suggest that the keys of the Attorney General's office were turned over to Nate Paul, look at his correspondence. He was madder than a hornet's nest with the Attorney General's office. You're not doing your job. You have a conflict of interest. You guys are negligent. You're grossly negligent. He was mad. He was pissed because the Attorney General's office would not do what he wanted them to do. He wanted them to investigate. If you look at the correspondence from Nate Paul, senators, and you compare it to what you just heard from Mr. Murr here, you're going to see two different stories. Nate Paul was very unhappy with the Attorney General's office. That does not sound like somebody who had the keys to the office. He kept accusing the Attorney General's office of not being neutral. He accused the Attorney General's office of having bias. He accused the Attorney General's office of being in the bag for the Mitty Foundation. He accused the Attorney General's office of employing people that were against his interests. It does not sound like somebody who's running the Attorney General's office. There was one person running the Attorney General's office, and that man is sitting right there, and that is the man that should be running the Attorney General's office at the end of this day. But I urge you to look at the correspondence and compare it with what you've heard, not only from these people, but in the media. Nate Paul was very, very upset and very, very unhappy with the Attorney General's office. So much so that he threatened to sue. That he sent a letter and said, hold all of your correspondence because I am going to sue you guys for your negligence, for your bias. When you look at the documents and you compare it to the arguments, you see a much different picture. Now, the allegation, the first bucket is a campaign donation of $25,000 made in October of 2018. Everything that you have heard in this case was in 2020. So think about that for a minute. Their entire case, a campaign donation, a bribe, if you will, 2 years prior. Complete ridiculousness. Especially when you look at all the other people that Nate Paul gave money to, and especially when you look at the percentage just in the year 2018 of the donations received by Attorney General Ken Paxton. This man is a fundraiser. There is a reason that he raises money politically, because the people like what he does. The people like Ken Paxton. We know that a campaign donation as a basis for bribery is complete hogwash. Imagine if a campaign donation were considered to be a bribe 2 years before the acts complained of. Line up. We're going to be doing a lot of impeachments in the city of Austin. That bucket has no validity. That bucket is empty. And let's look at the buckets of what Ken Paxton supposedly did for Nate Paul: foreclosure guidance, CAMIC retention, public records, and MIDI intervention. But what you heard from the young man who spent more time with Ken Paxton than anybody, sometimes 24/7, 365 days a year, is there was never an agreement at all. He never agreed to do anything for Nate Paul and never got a darn thing from Nate Paul, with the exception of a lunch. A lunch. A lunch that was public, on a patio, for everybody to see. Most of the time, you would think, when people are doing something untoward, they want to hide it. These were public lunches for everybody to see. And if a lunch is a bribe, then boy howdy, we got a problem here, do we not? That holds no water. Let's look at Article 1. It fails just in its language. These people don't even know the role of the Attorney General's office. It is not a public protector of charities. It's a protector of the public's interest in charities. And we know that previously, Greg Abbott, as the Attorney General, had sued the MIDI Foundation, has a long and sordid history. But it's not just a history of problems. There is a recent history, starting in 2019, and I urge you to look at the evidence, at the memo that was submitted, at the memo that every one of Ken Paxton's subordinates reviewed before they all signed off on the intervention. This was not Ken Paxton causing anybody to do anything. This was subordinates who reviewed the evidence provided and decided we need to intervene. And it goes on and on. People punching their spouse, people being indicted for this and that, all kinds of problems. And the most important problem, the thing I think that the subordinates were really concerned about, is this charity that was only worth $15 million total is investing $3 million into a speculative land deal. The bottom line is, and what's so ironic and what's so egregious is that every single person who signed off on the intervention in the first article of impeachment came here and testified that that's somehow wrong, but they were involved in it. Utter hypocrisy. They not only signed off on the intervention, which only lasted 3 months, but they also signed off on an investigation of the MIDI Foundation. That article fails. Period. Did they prove anything beyond a reasonable doubt with regard to that article? The only thing that we've seen beyond a reasonable doubt in that article is the MIDI Foundation has major problems, and that the AG's office intervened, and now the MIDI Foundation stands to make millions upon millions upon millions of dollars on their speculative investment. Man, I wish I could get an investment like that. $3 million investment, they stand to make almost $20 million. That hurts really good, doesn't it? So we know the intervention is hogwash. Let's go to the written legal opinions under 402, Article 2. Well, it fails on its face. because there was no written legal opinion, period. You heard our Lieutenant Governor charge you and explain to you that they have to prove what is in the article. They cannot prove this article because there was never a written legal opinion, period. That article is over. But, I mean, it's over. You can see it. This is informal guidance. This is not a legal opinion, period. But let's go a little further. They tried to drag Senator Hughes into this foolishness and put his name in this article. For what reason, I don't know, and act like having a straw requester was somehow wrong. And we all know, the people that work in the state's business in this city know that straw requesters are common. Every one of the House Board of Managers has been a, quote, straw requester at one point or another. We know that. And to put that in a public article, to somehow besmirch Senator Hughes is foolishness. But what was in Ken Paxton's mind when he was looking for this informal guidance? Well, if we want to know, we can look at his texts. His text sent directly to Mr. Bangert, who was working on the informal opinion. Look what he says. I think that it will impact people's lives in a good way if we do this right. Hundreds of people will be protected from harm and maybe devastation. These are real-time texts. This is not 3 years later with a bunch of cooked-up foolishness. This is the real-time thoughts of our Attorney General as to what he was thinking with regard to the informal guidance. And did you hear Drew Wicker? When he was asked about that, he said he knew a little bit about it. General Paxton says, we may prevent a grandmother from being thrown out of her home. And now they've turned this upside down. They've cooked it up and made it look somehow bad. And you know what's most ironic is the president of the time, at the time, Donald Trump, a month later issued the same guidance. And we know, of course, Nate Paul put his entities in bankruptcy and there was never any foreclosures anyway. This is what we have to do. We have to get up here and prove our innocence. How wrong is that? And did you hear the financial guy from the bank get up here and talk about they didn't lose a penny? That they not only didn't lose a penny, they made a fortune. That bucket's empty. Let's talk about the abuse of the open records process. Well, we've seen that is bull. We've seen that the abuse of misuse of official information, that was bull. Remember what you heard, that there was a secret delivery in the dark of night and a sealed package with top secret information. The problem with all that was all that information had already been released. It was already public. It was already public. And then when young Drew was asked, did you checked out for the general a packet that had a CD in it? Was that what you gave to Nate Paul's? No, not at all. Total baloney. Never delivered any open records to Nate Paul, never delivered anything secret. That bucket's empty. Article 5, the retention of Kamek. They say he was a prosecutor pro tem. Well, that crumbled on the stand, did it not? You have to vote on the language of the articles. That should be 30-0. There was never a prosecutor pro tem. Game over. But we still have to prove our innocence. So ridiculous. The office of the district attorney made a referral. Mindy Monford, I want you to please pay particular attention to her affidavit. She was one of the subordinates of the elected DA, and she made it very clear that it was her idea to do the referral. And you know what she said? I didn't think it was appropriate to send it to the Texas Rangers. I didn't think it was appropriate to send it to the FBI, so I referred it to the Attorney General's office. But guess what? It went to a Texas Ranger and a former U.S. Attorney, and they didn't want to fool with it. That's what you call a punt. We don't want to do it, let's punt it. And then they tried to pretend like they weren't involved, even though Kamek didn't know how to do a grand jury subpoena, so he had to rely upon the DA's office to do it. They were intimately involved. They were actively involved. They were helping him get the subpoenas, and they never said, this is wrong. In fact, they thought, I'm glad you're doing it because I don't want to be investigating the people that I have to work with. And then when it was over, they tried to wash their hands of it all. With all due respect, typical politician. And then lied about it. Margaret Moore sent a letter that she made sure it was in the press that she didn't have anything to do with this at all. We all know that's not true. And she didn't even mention that there had been a second referral that was referred directly from the DA's office directly to this young man, Brandon Kamek. And that's the reason he sent the subpoenas that the DA's office helped him to issue. And they want to blame that on Ken Paxton, who had no idea about it. Kamek admitted, I never told him what it was my idea to issue subpoenas, and I never told him who they were going to be issued to. And Ken Paxton could not figure out why the devil will Maxwell and Penley not do their jobs. Ken Paxton had a chance to investigate the feds. He wanted to investigate the feds. He wanted to, because he had seen how they operate. Picking and choosing who they convict or who they charge. Weaponizing the FBI, abusing their authority. He had an opportunity. He could not understand why his subordinates would not do their jobs. Instead of fighting about it, he got outside counsel. And this young man, Mr. Kamek, who had a signed contract from the Attorney General of the state of Texas, was dealing with somebody the Texas Ranger had decided in his mind on a Google search. Think about this. Imagine, I hope Dave Maxwell never Googles me. He had decided before he even looked at it that Nate Paul was a criminal. My God. If that's how criminal work is done, that your top cop in the AG's office, based on a Google search, decides somebody's a criminal, therefore I'm not going to investigate his allegation of wrongdoing of the feds, we got a problem. We got a problem. He decided on a Google search that he wasn't going to do a darn thing. He was never going to investigate his old outfit, the Texas Rangers. He was never going to do that. He's in the Hall of Fame, for God's sake. And Penley's not going to investigate the feds because that's where he spent most of his career. And Ken Paxton said, look, there's an allegation. Let's look into it. And the only thing he ever said was, just find the truth. So look at the points of view. You look through the prism. Ken Paxton's prism is sometimes the feds screw up. Kamek's point of view as a criminal defense lawyer is sometimes those who are making allegations are wrong and screw up. Maxwell and Penley, the feds never do anything wrong, the Texas Rangers never do anything wrong, and anybody that says they do, they're a criminal. God, that's fear. That's terrifying. That should terrify every one of you. And so he issued subpoenas, and he thought he was a special prosecutor. He was outside counsel, special prosecutor, whatever he was, he had the authority of the AG's office only to investigate. To investigate. And that's what the young man was doing. And he made it very clear in his testimony. He was young, inexperienced, sincere, and energetic. And he was asked point blank, did you think this was baseless? He said, heck no. I thought it was persuasive. I thought it was convincing. And I was excited to be involved in it. Because if what was being alleged were true, that would be a, quote, big deal. The only thing that Ken Paxton ever told that young man is seek the truth. That's what I suggest to you. Seek the truth. Nate Paul got nothing. Nothing. It's a darn shame that we have to come and prove that, but we did. And these whistleblowers, so-called whistleblowers, in order to be a whistleblower, let this sink in order to be a whistleblower, you have to have a good faith belief that a crime has occurred. In order to have a good faith belief that a crime has occurred, you have to have evidence. And you heard Mr. Vassar admit when he went to the FBI, he had none. He had some guesses, he had some maybes, he had none. And if these folks would have done their job, you wouldn't have had to spend the last 2 weeks of your time doing their job. And you can tell from the text, of these so-called whistleblowers, which what they really are is disgruntled ex-staffers. They were combative, they were insubordinate, they called their brand new boss a joke. How long would somebody on your staff last if they were texting their colleagues calling you a joke? You would fire them on the spot. He is a joke. We all know that when you bring in a new chief of staff, when you have a disagreement with your chief of staff and you bring in somebody else, that chief of staff is going to make sure that she or he brings in their own people. That's the way it works in politics, political appointees. And when you come in and you talk to your subordinates and they say, I won't work with you, what happens then? They leave. Nobody was ever mistreated. Nobody was ever talked down to. They were treated with respect. That's not what Brent Webster, the new first assistant, got in return. What he got in return is screams, shouts, hollers, and talking behind his back and calling him a joke. And then they joked about being fired. They were so torn up that they were joking amongst themselves, calling themselves the Cool Kids Club. The investigative report, I encourage you to read it. It's very lengthy. That's Article 7. It is documented and detailed. It explains everything that happened. It's a full investigation and it's pretty darn good. And it lays out in great detail the events. And it's been unrebutted. They had a chance to bring Brent Webster, who was one of the authors of that report, who made sure that everything was documented. It's lengthy. It has exhibit after exhibit. It demonstrates that they did, in fact, take the Attorney General's name off of the letterhead. It's there in black and white, the emails back and forth when they did that. It's in that report. Now they say the report is false. And they throw around bribery. We know why they included this, don't we? Because it captures headlines. It captures headlines. And you know why they mention Laura Olson? Because it captures headlines. And they want to shame people. They want to shame people. They want to be morally superior to us all. There's no reason to have done that to this family. There's no reason to have done that to this family. This woman got a job. She got it on her own merit, and she continues to work even today. She's getting checks from her job here in Austin even today. She has an apartment. She pays for her own apartment. That bucket is empty. I'm not going to spend too much time on this, but let me say, I'm certainly not perfect, and I'm going to assume that all of you feel the same. because we all have sinned and fallen short. The only person that cannot be forgiven is somebody who's so cynical that they don't ask for forgiveness. If this impeachment is based on a marital impropriety, then line up. Line up. We're going to be doing a lot of impeaching in this city. You should be ashamed of yourselves. Ashamed of yourselves. Bribery. They convinced Drew Wicker, based on a stray comment, that Nate Paul was paying for the renovations. It took me about 20 minutes to disprove it. They never asked for any of those documents. They never even asked. They never even talked to Kevin Wood, the contractor. They didn't even bother. They assumed it was true, and I had to come here on behalf of my client and disprove it. How wrong is that? And that was the most serious allegation. It wasn't just against the Attorney General of our state, but it was against a senator in our state. Did you see young Wicker's face on the stand when I disproved it? I had to disprove it even to the general's body man. And let me tell you, the press reports that again. I'm going to be lining up a lot of lawsuits because that is absolute defamation. Because now we all know it's absolutely untrue. And that was the entire basis of this case. Supposition, and it can happen to you. Not even going to go through it. No burner phones, no secret email address, no promise to help Nate, no agreement with Nate. Nothing. Nothing. You should be ashamed of what you've done here. We showed you the transaction from front to back. Now, there was some suggestion that, well, he decided to pay because he knew they went to the FBI. Total baloney. The documents show something completely different. I urge you to look at Mateer's text and look at the text to Chip Loper on the pavement. Look at the USAA docs that show that he was fighting with his insurance company trying to get paid for these very renovations and repairs that we have in evidence now. Every bucket of what General Paxton supposedly received, every bucket of what Nate Paul supposedly received, empty. Empty. So, what do they do now? Well, you settle a lawsuit. A lawsuit was brought against the Attorney General office, and you went to the legislature, which is what you're required to do, to get it funded. And the reason we decided to settle it, the reason they were begging to settle the case is because they didn't know what the Supreme Court was going to do. And Ken Paxton delegated that to one of his subordinates and said, hey, settle it if you think it's appropriate. And that was put before the legislature, and the legislature says, no, we're not going to pay it. And they were begging. The very people that came here to testify were the very people begging to get paid. It makes me mad.
You have 10 minutes remaining in your time.
So the Hail Mary, that's Roger Staubach, remember him? The Hail Mary is, well, let's just throw in a bunch of malarkey at the end. Conspiracy, although there's no agreement and no furtherance of a conspiracy. Misappropriation, never happened. Dereliction of duty. Boy, when you're accused as a Marine officer of being derelict of duty, that's bad. Let's throw it unfit for office, abuse of the public. There's no evidence to support any of the articles. That means there's no evidence to support any of these articles. These are thrown in later because as you deliberate, there's going to be somebody say, okay, you're right. There's no proof of that, but we got this article. We'll use this to get him. We got to get him. We got to get him. Don't do that. That's not based on evidence. And that ain't the way it works. Just throw it at the wall and hope something sticks. That ain't the way it works in court, and that should not be the way it works in a historic impeachment proceeding. It holds no water. So why are we here? We're here because Dade Phelan got his feelings hurt. He was so drunk handling the House business, knowing full well that they had no evidence to support an impeachment and they hadn't done their homework. When Ken Paxton says, hey man, you embarrassed the devil out of yourself, you should resign, they sped up the process and impeached this man. You've seen the video, it's all over the internet. You know, my favorite author said, justice limps along, but gets there all the same. We should have never had to do any of this, because this case is a case about nothing. It's a case about nothing. And people are watching. It's not just these people. There are thousands upon thousands of people watching at home who will sit in judgment, who have watched the evidence, who have been shown what has been alleged and what has actually been proven, and have seen that they don't match up. For me, as a son of a butcher and the son of a woman who worked in our high school cafeteria, who had the gift from God to go to Texas A&M and then go into our United States Marine Corps, and then be able to become a lawyer, a member of the bar of our state, to be called to defend the sitting Attorney General of the state of Texas is a great honor. And it's a great honor to stand here in front of you. I know in the fiber of my being that all of this foolishness that they've accused this man of is false. But the only question I have in my mind is whether there is courage in this room, to vote the way you know the evidence requires. I think there is. I hope there is. I pray there is. I'm asking you to agree with the 4.2 million Texans who put this man in office as Attorney General, to put this man back to work and vote not guilty.
Thank you. Morning. I had planned on 30 minutes, but I have 5. So I guess there really are no coincidences in Austin. It may or may not surprise you that I'm going to go in a different way from my colleague, Mr. Busby, who's a fine lawyer. But I'm not going to yell at you. I'm not going to scream at you. I'm not going to point my finger and shake my fist. I just think, first off, no offense, but you're politicians. Y'all can probably get that faux rage quicker than most mammals. It's a skill set you got. I'm not going to attack my colleagues on the other side. I don't think they are good lawyers. I think they are great lawyers. They are living legends. But here's the point about that. Mr. DeGuerin, it is DeGuerin, Mr. Hardin, Miss Epley, Mr. Donnelly, some of the greatest lawyers in Texas literally could not put together a cogent case that could convince anyone that these
things occurred beyond a reasonable doubt. These aren't second chair misdemeanor prosecutors. They were the best of the best. They did the best they could. But the evidence simply wasn't there. And my friends on the committee, here's a pro tip. If you're doing this investigation that will literally cost millions and millions of dollars and take weeks and weeks out of our senators' lives, you know, one person you might have talked to, me. I've been representing Ken Paxton for 8 years. Do you think they could have called me and said, hey, Dan, we got a problem with Paxton. What about this dark night? What about this kitchen cabinets? What about this Brandon Kamek? I was literally, sorry, I said I wasn't going to scream, but I was literally having lunch with Mr. Donnelly when this was going on. Do you think? Before we wrote that check, he could have said, hey, Cogdill, buddy, let's talk. They didn't do that. I'm not the world's greatest lawyer, but I'm pretty easy to find. The fact that they wouldn't literally pick up the phone and call me, that's a clue that they were more invested in the conclusion that they wanted than they were invested into the investigation. How much time, Your Honor? 1.5 minutes. I would make a joke about my personal life, but I won't. Can I see the picture of Brandon Kamek? One of the things that's really harder than it looks when you are a criminal defense lawyer is to argue to a jury. I need the picture, not the statement. There we go. Thank you. And thank you, Eric, for everything. One of the things that's harder than it looks is trying to explain to a jury what reasonable doubt looks like. That, ladies and gentlemen, is what reasonable doubt looks like in this case.
1 minute left.
Mr. Kamek told you this wasn't a baseless investigation. This was a legitimate investigation. Look, I respect David Maxwell. I've known him for a long time. But with respect to that legacy, his milk carton has expired. It's over. When he gets up there and looks you in a straight face and says it's a crime to investigate whether or not something is a crime, come on. We were born at night, but not last night. That is dumber than a bucket of hair for a Texas Ranger to say it's a crime to investigate the legality of the search. By the way, that's how my friends Mr. DeGuerin and Mr. Hartney and I make a living. It's not a crime. It's not. But Kamek said, not a crime, legitimate. I believed in it. I thought that was something there. Paxton never asked me to lie, cheat, or steal. And I was doing the best that I could. That is game, set, match. I think that's the phrase. I don't play tennis. It's game over. The whole case was around this illegal relationship with Mr. Paul and Mr. Wynn, who they didn't call, and my friend Ken Paxton.
Mr. Cogdill, you're going to have to wrap up. I'm sorry.
Let me just say this. It was an honor to be here. Never thought I would. Thank you. But this is not about me. It's not about Ken Paxton. It's about whether or not you have a reasonable doubt. I suspect he did some things that you probably didn't like. I get that. I understand that. But that's not the issue. The issue is whether the proof is there that is so convincing that it convinces you beyond a reasonable doubt, the same standard of proof that's in a death penalty case. It's not. It's not. It's not. 2 words. 2 words. Not guilty. Thank you.
Mr. Myers, he went over about a minute, so I'll give you an additional minute. You have 51 minutes. Yes, would you remove your easels? And we're not going to take a long break. They have a chance to come right back up, but I will give you 5 minutes while they're taking down the stretch, but do not leave the chamber.
As you just heard, Lieutenant Governor Dan Patrick, who is serving as the judge in the Ken Paxton impeachment trial, giving the senators, the jury there, a quick break. We just heard from the prosecutors making their closing arguments for about 10 minutes and the defense for about their 60 minutes. We've got more closing arguments we're expecting from the prosecutors as well, but they're taking a quick break for a moment. Boy, what a morning.
Yeah, they'll get their longer period of time next after the break, after they come back from the break, and then the defense will get to go back up and give another 10 minutes before they wrap up, and they actually give the jury the opportunity to deliberate behind closed doors in closed session. Interesting this morning to watch these proceedings again for the first time since day one of this impeachment trial. We saw Ken Paxton in the chambers listening to the proceedings this morning, and he's expecting, I think, a big day, and I think he's obviously hoping for a favorable verdict. Yeah, so far at this point, what we've heard from when it comes to the prosecution, they've accused him of using and wielding and blindly using his power to help himself and not the people that he was elected by. It made mention of the fact, too, the prosecution did, that he did not show up until today. And, he said he used the office, Paxton did, the prosecution said, to serve himself, and that he loved the power that he was able to wield. Now, then you heard from the defense closing arguments that said, no, this is all basically a joke, that they didn't have anything, and they've proved that already, and then they outlined one by one as far as what that was. Obviously, you don't want to read too much into what we're seeing right now, but you see smiles on the face of Tony Buzbee and Ken Paxton there, and a lot was made about the fact that the defense rested with still time on the clock that they could have used, but they rested early, but they used pretty much every minute of the hour they were allotted for their closing argument. So Tanya Iser has been covering this closely. She's watched every single minute of this impeachment trial, along with political and legal experts. She's standing by with those people right now. Okay, so we want to hear what you all thought.
Well, it was quite an interesting closing there from Dan Cogdill and Tony Buzbee. You know, Dan Cogdill ending with 2 words, not guilty, and then Tony Buzbee saying, you should be ashamed of what you have done here, attacking the House impeachment managers and also these 8 whistleblowers, many of who came to testify during this case. Bud and Stephanie, I just want to get y'all's reaction to what we heard in these closings so far. Stephanie?
Well, Buzbee argued from the defense attorney playbook, telling and reiterating that he's proud to represent his client. Both he and Mr. Cogdill emphasized that that's something that you want to do. You want to let people know that, yes, I'm hired, but I have a choice about whether I take this case or not, and I took it, and I'm proud to represent the AG. Him also saying that this case is about nothing and reiterating that they have no burden. The defense has no burden, but they came there and they, in their opinion, they have disproven everything. The other side should be ashamed that they have put our state, we're on a big stage, and this has essentially been an embarrassment, and that he hopes that nobody ever has to experience this again. He brings the general public, draws them in.
Of course, nobody will experience this because we're not subject to being impeached.
Right,
so this is not something. He put everybody else on trial. The Texas Rangers. He said his milk carton is expired.
Okay, so Tony Buzbee framed this as a fight within the Republican Party. He talked about how that the Bush era ends today. He also, talked about the Biden administration and the DOJ, and that if they'd had the evidence to indict Ken Paxton on these allegations, that they would have done so. And then he goes on, Tony Buzbee goes on to talk about how Ken Paxton knows a little bit about people coming after you with no evidence as an explanation explanation for why he wanted to hire Brandon Kammack. Go ahead.
Tanya, he talked about the Texas Ranger, his milk carton has expired, the Bush era in Texas is over, Biden's FBI and Department of Justice, and Dade Phelan was so drunk. Those are all the people he accused in this wrap-up. He left off a couple of the boogeymen that he's been discussing. I don't think we heard him mention Karl Rove, Dick Weakley, but he just has sent this cavalcade of attacks on law enforcement. Two of the key swing votes are a former Fort Worth Police Captain, Phil King, and a former Texas game warden, Pete Flores. I don't know how they're going to feel about this broadside attack on law enforcement.
How do you think it plays, Stephanie?
Well, I think that too is from the 101 playbook. You want people, again, in the attempt to draw everybody in onto your side, you want to show them, like, look, these are people, he's the top cop. Okay, he's representing the top cop in the state of Texas. So he wants people to see, look, you're right. You're right to question the government. You're right to question law enforcement. My client was one of the good cops. He did nothing wrong. We've got to eradicate these bad cops, not only in our state, but we need to eradicate them, countrywide. So I think that's smart. I mean, at the end of the day, that is the opponent that he's up against.
He also made a direct appeal to Senator Hughes, mentioning him, but Senator Hughes voted against the motions before the trial. Go ahead.
Well, let's go back to Mark Istook. He has a question he'd like to ask.
Well, I'm just curious, for those of us that don't watch jury trials, on the weekly, in a traditional jury trial, you are appealing to a jury who hopefully comes in unbiased. But we know in this situation, you've got politics at play, you've got political alliances, and certainly a lot has been made in the media about, folks maybe potentially having their mind made up before this even began. How does that strategy play differently in this case? It's not a criminal trial. You've got the politics behind the scenes. I just wonder how much that affects what we just saw today.
Well, I think everyone had their minds made up. I mean, this is not a jury that is totally new to the case or strange to the case. This is not some change of venue situation. They all have been reading about this for years. They have strong feelings about it. They saw some of the evidence. I doubt it pushed anybody either way. They're influenced by politics, by the voters in their district. What they see is some of them will be on the ballot in March. I don't know that this changed any minds.
Okay, we're going to send this back to Mark and Kara.
Now, interesting to get that perspective because, you can scroll on Twitter and you can see already the political arguments being made that, some of the state senators who are the jurors in this case are worried about how this plays in their home districts. Will they get primaried as a result of how they vote in this case?
Well, and you've also seen some different political leaders in the state tweeting out, hey, make sure you call your representative and tell them what you feel about this. So there are going to be, people I guarantee you have been calling them and sort of weighing in and saying, hey, this is how I want you to vote. We've got Teresa Woodard. She's actually down live in Austin this morning. She has been right outside there and has some interesting perspective for us. Okay, Teresa, we have Natalie Haddad, who's actually inside the chamber. What are your thoughts? What have you been hearing now that they've taken this break?
Are you, okay, apologies. I thought you were talking to Natalie Haddad. Yeah, we're standing by because I can see here that Dan Patrick has gone back to the dais, and so we do think that the closing arguments are going to resume quickly. But just, to tell you sort of the wrap-up of what we heard from the defense, they were basically trying to make the case that this was not proved beyond a reasonable doubt. They called the case a joke multiple times. But I do think it was interesting when you consider the politics here. It felt as if Tony Busby, the defense attorney, was sort of weaving a little bit of a conspiracy thread, a conspiracy theory thread throughout his closing argument. He talked about the Bush dynasty being responsible for this, the FBI, the DOJ. He really did attack law enforcement, which I think is an interesting, it's just an interesting message to deliver to senators, and I'm not sure exactly how that's going to land with some of them, but the politics can't be divorced from this case clearly. As you've been saying this morning, you do wonder if some of these people have come in today with their mind already made up, and does the closing argument really seal the deal at all? We will see soon, because deliberations will begin as soon as the House as soon as the prosecution delivers their closing arguments, which are beginning now. Let's take a listen.
When I gave the opening statement on behalf of the House managers, we told you that we wanted you to hear from the witnesses and see the documents. And so we're going to continue to do this. On your screen, we're going to start with Article 1. Now, we don't have enough time to go through every piece of paper that was introduced at trial and every word that was uttered under oath. But we suggest that you look at these key exhibits related to Article 1. To summarize, the Texas Attorney General wields astonishing power and is required to use that power to protect charities. In fact, the Fifth Circuit Court of Appeals has called it the public protector of charities. But instead of protecting the Mitty Foundation, Paxton forced his office into the Mitty lawsuit over the objections of the Charitable Trust Division solely to help Nate Paul and his companies. Mr. Paxton's obsession with helping Nate Paul manifested itself in the Mitty litigation, when he demanded his deputies try to halt the lawsuit and force the charity to accept Mr. Paul's lowball settlement offer. Mr. Paxton claimed that the office needed to intervene to save the Mitty Foundation from excessive attorney's fees. But in reality, his actions harmed the charity by causing it to respond to frivolous motions and demands. Instead of protecting charities, Mr. Paxton harmed the Mitty Foundation only because he wanted to help Nate Paul. Now, in addition to exhibits, you heard testimony proving evidence in Article 1. Here's just one of the highlights from Mr. Bangert.
He directed us to intervene. It was clear to me the intervention would benefit world-class holdings in Nate Paul.
Article 2, same thing, trying to be compressed on time, but I want to give you a highlight of some of the exhibits that we want to direct you to. You can write these down and look at them later during deliberations. To summarize, Mr. Paxton abused his office, forcing his employees to draft the midnight opinion to help Nate Paul avoid impending foreclosure sales. He became involved in the drafting of an opinion for the first time ever. He covered up his misdeeds by creating a straw requester, a Senate chairman, to hide the fact that he had no valid requester as required by Chapter 402 of the Government Code. The letter was clearly a 402 opinion, and the Office of Attorney General knew that. Why else go to all the trouble to find an authorized requester? It doesn't make sense. Even though the Attorney General's office had been promoted as Texas is open for business during COVID, and Governor Abbott's emergency COVID order had expressly permitted real estate transactions to continue without limitation, Mr. Paxton forced his employees to stop foreclosure sales based on the phony claim that COVID made these outdoor sales on the courthouse steps dangerous. To accomplish this purpose, he forced his employees to reverse their legal conclusions, and they told you that, so that Nate Paul could benefit from a legal opinion published at 1 o'clock on a Sunday morning. The very next day, Nate Paul attempted to use the opinion letter to halt foreclosures in his properties. On your screen is Exhibit 657. Articles 3 and 4. Same thing. We have listed some of the top exhibits that we suggest you look at when you deliberate. To summarize, Mr. Paxton does not dispute that the law enforcement exception is designed to protect victims, law enforcement, informants, and practices. It is also undisputed that Mr. Paxton directed his employees to act contrary to the law enforcement exception and release confidential information related to an ongoing investigation. It is not a coincidence that Nate Paul had pending lawsuits concerning the open records request and the AG's no position opinion endorsed disclosing sealed documents. It is not a coincidence that even though there are over 40,000 open records rulings each year, that Nate's request is the first and the only time that Mr. Paxton ever cared about anything in the Open Records Division. Now, after his advisors warned him repeatedly not to release law enforcement records relating to an ongoing investigation, Mr. Paxton insisted that the office issued the no position letter. The House has also established that Mr. Paxton provided Nate Paul with confidential information. It would be impossible for Nate Paul to know the specific details of who signed the sealed probable cause affidavit in connection with the application for the search warrant without being improperly provided that information by Paxton. In May, Mr. Paxton obtained a copy of the DPS file. That information was in there. He had the file for 7 to 10 days. The DPS file was in a manila envelope. It was testified it was 1/4 inch or less in thickness. According to Mr. Wicker, in May or June of 2020, he handed off a manila envelope to Nate Paul at Nate Paul's office. In a meeting on August 5th, 2020, with Penley and Maxwell, Nate Paul and his lawyer presented a presentation titled Operation Longhorn, revealing that he knew the identity of the affiant and the probable cause affidavit that still remains sealed. There was also witness testimony explaining that Mr. Paxton asked that the information related to the ongoing law enforcement investigation be released. Listen to Mr. Vassar.
Was there a clear clash here between what the judicial system had decided somebody that should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking potentially harmful and dangerous to other people? If disclosed.
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
And still more.
What did the Attorney General say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened to Mr. Paul. He felt that Mr. Paul was being railroaded by the FBI and by DPS. And General Paxton said that he didn't trust law enforcement. He asked us to find a way to release the information that had been requested to be withheld.
So despite his staff telling him you can't release this type of information, despite Mr. Paxton's claim that the decision did not release any documents, the no position letter, that opinion, still created precedent that could help Nate Paul and could help others obtain confidential information. Listen to Mr. Banger about precedent.
If our office refuses to take a position on an issue like that and the court sees that, that is a strong signal, I believe, to the court. And I've been a lawyer for over a decade, I'm probably getting close to 2. That's a strong signal to the court about the Attorney General's view of that file, that we would have gone out of our way to render a vastly uncharacteristic decision.
Let's talk about Article 5. Here's a summary of some of the key exhibits that we direct you to in your deliberations. Highlights: Mr. Paxton secretly signed a contract to hire Brandon Kamak, a 5-year lawyer with no prosecutorial experience, to commence a criminal investigation into Nate Paul's enemies. Mr. Paxton hired Kamak September 4th, 2020, and unbeknownst to his deputies, fully executed the contract 3 weeks later on September 28th. Paxton alone supervised Kamak's work, in which Nate Paul and his attorney Michael Wynn directed. Paxton thought it would be a good idea for Kamak to obtain grand jury subpoenas that would have allowed Nate Paul to get the private email and telephone records of law enforcement agents who investigated Nate Paul, lenders, and opposing counsel. Now, pursuant to the Texas Code of Criminal Procedure, Article 20A, I ask you to write that down. Texas Code of Criminal Procedure, Article 20, big capital A. The ability to obtain grand jury subpoenas is a prosecutorial act. It is not a tool available to outside counsel hired by the Office of Attorney General who has not been appointed an attorney pro tem. Now, let's talk about what that is. An attorney pro tem is appointed when a DA recuses herself, and it is a formal process in which that district attorney goes to the court and asks for permission to be recused. Kamak was not an attorney pro tem, but Paxton still permitted Kamak to obtain grand jury subpoenas just like he was. Thus, Paxton was illegally attempting to use Kamak as an attorney pro tem when under the law, which this legislature writes, says that cannot be. Paxton communicated with Kamak using only private encrypted communications like Signal and Proton Mail and extra phones. The two talked several times a week, and Kamak updated him about his work as a special prosecutor. Let's talk about that real quick. Even though Mr. Paxton called Kamak a special prosecutor, a term, special prosecutor, didn't exist. He clearly wasn't one. A special prosecutor is when a DA appoints someone to assist with their cases. And that person is not on the payroll at the district attorney's office, but is sworn in by the district attorney and becomes an assistant DA and a special prosecutor. The DA continues to supervise the handling of their case. Kamak was not sworn in and was not supervised by the Travis County District Attorney's Office. Let's listen to the testimony of former DA Margaret Moore.
In what way? It is astonishingly untruthful. There is no way that anyone could interpret the facts as my appointing Mr. Kamak as a special prosecutor. I couldn't pick him out of a lineup today. I don't know him.
So he wasn't a special prosecutor and he wasn't an attorney pro tem. Let's hear from
by that time, the 29th, because the next day is when we go to the FBI and DOJ. By that time, I concluded that Mr. Paxton was engaged in conduct that was immoral, unethical, and I had a good faith belief that it was illegal.
This entire investigation by Mr. Kamak was illegal. Let's listen to Ranger Maxwell.
Now, would you agree with me, Ranger, that despite your concern or belief or hope that Mr. Wynn or Mr. Paul would say something incriminating or say something that would cause them exposure criminally, neither Mr. Wynn nor Mr. Paul ever asked you to do anything illegal?
Yes, they asked me to interfere with a federal investigation, which is absolutely illegal. It's also obstruction of justice.
Show me, Ranger. In the first hour or the second 2 hours on the investigation or the interview of July 21st or August 5th, you've got the transcript there for both of those.
Counselor, you were showing me the evidence right here. This is a map of how he wanted the investigation to be done and to have the AG's office follow how this was to be investigated, along with targeting 6 individuals.
Where they say you reviewed the transcripts of the July 12th interview and you have reviewed the transcripts of the August 5th interview. Show me the language where in either one of those interviews, Ranger, that they ask you to commit a crime?
They're not in the interviews, Counselor. They are in the document you're looking at right now. He lists 6 people as a person of interest to be targeted in this investigation.
Where does it end?
It's an Operation Longhorn.
What crime is Mr. Wynn or Mr. Paul asking you to commit by tendering this PowerPoint to you?
They entered the PowerPoint and gave it to us to map out how they felt our investigation that they wanted to be created should go.
What crime is committed, Ranger, by them asking you to investigate the legality of a search warrant? What crime is that?
In my professional opinion, to create this investigation and follow through it would be obstruction of justice and interfering with a federal investigation.
And finally, I ask you also to recall testimony of Mr. McCarty.
And did you learn or see subpoenas, the grand jury subpoenas, that had been issued to players in the Mitty Foundation case?
I saw a criminal grand jury subpoena that had been issued to a bank.
What was your reaction to that?
I was stunned.
What do you mean? Explain it.
I saw a criminal grand jury subpoena directed to a bank that was clearly seeking information that would have aided world-class Nate Paul's efforts against the Mitty Foundation.
Why is that bad?
Well, it's one thing is it's lawyer ethics 101, so that was the first thing that came to my mind. We are weaponizing the criminal process to aid a civil litigant, and that is a big no-no.
Ethics 101. And Mr. Paxton has not disputed the testimony of Mr. McCarty. Now, Brent Webster, on behalf of Mr. Paxton, misled the Senate Finance Committee by stating that he had proof that Mr. Kamek was an attorney pro tem because he was allegedly being supervised by the Travis County DA's office. I remind you of this testimony.
I want to talk about the appointment of special prosecutors, and I don't know if you or the general need to answer this. Is it rare for your office to appoint a special prosecutor?
So is this a general question about special prosecutors? Is that
just at the AG's office in general?
Okay, yeah. I'm happy to address that. So
I would actually rather if General Paxton would address it, but if
he knows this like backwards and forwards. He was a prosecutor, so he knows this issue very well.
Well, I'm wondering who hired Brandon Kamek. Was that you?
So if I can address that.
Sure.
So our office entered into a contract for with Brandon Kamek to be outside counsel. And so he was serving as outside counsel for the AG's office. Now, I have, through the process of, I started, as you know, in October after this happened, I have interviewed ADAs from Travis County, and I've seen documents from Travis County that prove the fact that the Travis County DA's office made Brandon Kamek a special prosecutor. We did not make Brandon Kamek a special prosecutor. That was within the purview of the Travis County DA's office. So the special prosecutor word gets confusing at times because there's two types. One type of prosecutor is a pro tem prosecutor, and a pro tem prosecutor can only be put in place when a DA's office recuses themselves from a case. And that's not what happened with the Brandon Kamek situation. We hired him to be outside counsel. That contract was signed by the general. And then he went to go work because he was hired on to assist the Travis County DA's office. And the news glosses this over. No one ever goes and looks at the Travis County DA's office's files. They don't give really deep interviews on these things. But the fact is, he went and said, I'm the guy that's going to be the outside counsel for the AG's office, and I'm here to assist on your investigation. And then through that process, he worked with them to get grand jury subpoenas, and that's how he became a special prosecutor.
And I'm aware of the difference. I actually wrote the legislation that determined on pro tem who could actually be appointed. So yes, I'm familiar with this.
This body knows the law. On September 29th of 2020, Jeff Mateer was leading a Zoom meeting about opioid litigation when he received an urgent message that there was an emergency. Mateer knew that it was something important. He learned that an individual representing himself as a special prosecutor for the Office of the Attorney General and Nate Paul's personal attorney had served a grand jury subpoena on a bank seeking information relating to Nate Paul and his activities. This was a crisis moment. Mateer called Bangert, Brickman, and other deputies who were in meetings at the Capitol. They assembled, shared the grand jury subpoena from the bank, and they were stunned and outraged. They realized that Mr. Paxton was using criminal grand jury subpoenas to aid Nate Paul's civil lawsuit against the Mitty Foundation. In that room, Bangert, Mays, McCarty, Penley, Vassar, and Brickman for the first time started to share from their puzzle pieces what their office was doing to benefit Nate Paul, not realizing how it all connected. The puzzle pieces came together that day, and they realized they had a massive problem. Concerns of bribery were raised. Mr. Paxton had allowed Nate Paul to infect the office at the highest level. Despite all their efforts, Mr. Paxton's senior staff realized they could not stop him. They believed that he had committed crimes and abused his office, and that he had attempted to involve them. They knew they had no choice but to report them. Mr. Paxton's counsel has argued with each witness, save one, claiming that they should have spoken to Ken Paxton before they went to the FBI. However, this line of questioning ignored the months and months of warnings, conversations, and pleas from senior staff, imploring that Mr. Paxton stop asking his office to do work for Nate Paul. Here's a video.
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
Let's hear what Ranger Maxwell had to say.
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
And Mr. Mateer?
I felt like we had been trying to protect Mr. Paxton. On several occasions, I'd gone to him, and really he was my boss. He'd become a friend. I cared for him. I cared for Senator Paxton, and I wanted him, I think in one of the memos I say, come clean. I wanted to help him.
And Mr. Penley?
I told him that I was trying to be a loyal subordinate and a friend, and I still considered myself a friend even up to that very day. And I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it. I explained all the practical investigation difficulties, that we shouldn't be trying to investigate the feds, and there were many things we couldn't investigate. We didn't have the power. We didn't have a way to get at those sealed search warrants.
That's the testimony that you've heard during this trial. And Mr. Paxton's response was swift, vicious, and wrongful. He followed the classic playbook of guilty: deflect, deceive, and demonize. Articles 6, 7, 8, and 15 detail Mr. Paxton's attempts to misuse state resources to conceal his bad conduct by lying and smearing the otherwise stellar reputations of his loyal staff. Again, we list out some of the exhibits that we would direct you to during your deliberations. Please write them down if you can. He used state resources to issue an internal OAG report before this last election that contained blatantly false statements and personal smears against the whistleblowers. Let me remind you of what Mr. Brickman said.
In this report, if I asked you just to take three or four examples of things that you disagree with, have I asked you to do that?
Yes.
All right. What I wanted to ask you is, in this report, how would you describe your reaction to it as accuracy as in terms of what happened in these matters involving Nate Paul?
I would call this report a whitewash full of lies.
Now, if I may, let's just go over to page 5 and do this real quickly. If I ask you to pick 4 or 5 samples, can you just do that for me? And would you look on page 5 and see as to the first claim? What is untrue about that claim?
It says, on 2 prior occasions involving Nate Paul's interests, the Open Records Division sided with the government agency against disclosing to Nate Paul. That is not true. There was an Open Records decision that took no opinion as to the release of the documents.
Oh, this number 2 here, where it says A.G. Paxton's involvement is consistent with his predecessors and in line with his required duties and legal obligations as Attorney General of Texas. Most relevant here, the position taken by the AG in this litigation was adverse to Nate Paul and in support of a higher settlement amount to be paid by Nate Paul to the Mitty Foundation, as opposed to the prospect of continued and costly litigation that would disproportionately benefit the charity's court-appointed receiver and his lawyer. All right, the third claim. This informal guidance letter regarding foreclosure sales written by Bangert was made in response to requests for disaster counsel advice from Texas Senator Brian Hughes during the height of the pandemic and not for the benefit of Nate Paul. Is that a true or untrue statement? Is that a true or untrue statement?
It is an untrue statement. The foreclosure opinion was for Nate Paul's benefit.
Can we go to page 6, please? Look at the top. Kamak legally and properly exercised authority delegated to him by both A.G. Paxton and the TCDAO. Kamak was designated as outside counsel for OAG by A.G. Paxton, and he was also knowingly appointed as a special prosecutor by the Travis County DA's office. Is that a true or untrue statement?
It is false.
Mr. Paxton did not examine or cross-examine a single thing said by Blake Brickman. Every word he said is unrefuted. Let's look at a quick timeline. I want to remind you that the whistleblowers were all constructively terminated within 45 days of making their report to the Trump FBI. Mr. Paxton last attempted to silence the whistleblowers with his request to the taxpayers that the taxpayers pay $3.3 million in hush money. Even when he was specifically asked to justify the use of the money, he declined and refused. And that is why we are here. Mr. Paxton refuses to take any responsibility for abusing the esteemed office that he holds. Let's look at Articles 9 and 10. In exchange for abusing his office to help Nate Paul, Mr. Paxton reaped tangible benefits. What we know is that Nate Paul gave Mr. Paxton's mistress a job so that she could move from San Antonio to Austin to be closer, provided free Uber rides to her apartment. And Nate Paul provided free renovations to Mr. Paxton's Austin home until he was caught. And I'll show you that in just a minute. Look at this next chart. It has a lot of data on it, but just look at the colors for me. This chart is a demonstrative based on Exhibit 700. Exhibit 700. Marked in orange are trips to and from Ms. Olson's residence, which is shown as Exhibit 699. Marked in blue are trips to Nate Paul's residence. Exhibit 700 shows that Nate Paul set up an Uber account for Dave P. The account facilitated a covert means for Paxton to maintain his affair. The ride chart in this exhibit contains the latitude and longitude for each pickup and drop-off for Dave P. Focus on the rides between July 30th, 2020 and October 2nd, 2020, when the rides suddenly stopped. October 2nd. Next, I show you this Uber exhibit also shows that the rides are paid for with a credit card linked to Nate Paul's billing address in Austin and not Ken Paxton's in Collin County. Not Ken Paxton's in Collin County. Next, I show you Exhibit 699, which shows that Laura Olson was hired by World Class Property Company July 6th, 2020, and reports to Nate Paul. Let's talk about a timeline that's really important. You've seen a lot of documents, but let's take a moment. I want to show you this timeline. It's important. This shows when Paxton found out about the whistleblower report to the FBI and the actions that he took immediately after that. Now, Penley emails Kamek to tell him to cease and desist at 9:18 on September 30th, 9:18 in the morning. At 10:35 that morning, Kamek forwards the email to Paxton's Proton mail address. Kamek relentlessly calls Paxton that morning as well. Only 4 hours later, Paxton decides to pay the Cupertino builders for renovation work completed in July. Completed in July, but we're paying them now, September 30th. He returns to Austin and arrives at the airport at 10 p.m. At 10:57 p.m., Dave P. takes an Uber to Nate Paul's house. Dave P. was picked up 1 block from Paxton's residence. The next day, October 1st, that was the 30th, the next day, October 1st, Cupertino Builders creates an invoice for Paxton at 7:50 p.m. The records show that this invoice was never sent to Mr. Paxton. That night, October 1st, Dave P. takes his last ride to the Pearl Lantana Apartments, where Laura Olson lives. We tried to call her as a witness. The court announced that she was present but unavailable to testify. Next, this is an invoice from Nate Paul's guy, Raj, never sent to Paxton. He created it after it was due, and the metadata tells us so. The metadata tells us it was created on October 1, yet Mr. Paxton decided to make payment on September 30th for work that had been completed in July. This is Exhibit 703. These are emails. Why does Nate Paul need to know the schedule for the renovations at the Paxton's home in Austin? Why does Nate Paul need 20 photos of the new flooring in the Paxton's home in Austin? Mr. Wicker testified that he heard Kevin Wood tell Mr. Paxton, "I will have to check with Nate," at least 3 times. Kevin Wood, who avoided being served multiple times with subpoenas in this matter. There are no coincidences in Austin. Nate Paul was paying for these home renovations until it all got found out. Articles 16 through 20. They charge that Mr. Paxton and Nate Paul's scheme to use the powers of the Office of Attorney General constituted dereliction of duty, made him unfit for office, and abused the public trust. These articles ask the Senate to do exactly what Mr. Paxton's counsel is begging you not to do: to look at the entirety of Mr. Paxton's conduct. And when the Senate does so, there is no reasonable doubt that Mr. Paxton committed the acts set forth in these articles, and that these acts were an abuse of office and a breach of public trust. The witnesses have explained to you that Mr. Paxton conspired with Nate Paul and others to harass and intimidate their perceived enemies. While Mr. Paxton's attorney suggests that there must be some type of overtly stated agreement if people are going to conspire, he also knows there are no coincidences in Austin. Mr. Paxton was using an inordinate amount of the OAG's resources for Nate Paul. Listen in.
Well, when the Attorney General kept raising Nate Paul issues of the ones that we've gone through so far and later in the future, do you have any idea how much time or resources that were devoted to dealing with Nate Paul instead of real concerns?
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
The burden of proof in this case is beyond a reasonable doubt. But what does that mean? It means exactly what the words say. Is there doubt? And is it reasonable? Even though this isn't a criminal trial, every day in this country, criminal defendants are convicted of crimes beyond a reasonable doubt with much less evidence than you have seen in this trial. We admitted over 3,000 pages of documents and 7 days worth of testimony, and that will all be accessible to you in your deliberations. When we first started our case, it might have been unclear what all the evidence was. And that doubt was reasonable since Mr. Paxton was presumed innocent. But as more evidence came in, the picture became clearer and the doubt faded. The puzzle pieces came together. The law does not require that we exclude all doubt. When we have shown you enough evidence that you can see what the puzzle is showing, that you know what the picture is, then we have met our burden. Now, Mr. Paxton's counsel would urge you that we have to put every piece in the puzzle there for it to be a picture, but that is not what our burden is. The burden is satisfied. Is it a coincidence that Paxton ordered his people to intervene in the Mitty lawsuit when they had already waived intervention? Is it a coincidence that Nate Paul used the midnight opinion to stop a foreclosure sale 1 day after the opinion was issued? Is it a coincidence that while discussing the Paxton home renovations, Mr. Paxton's contractor told him at least 3 times, "I will have to check with Nate"? Is it a coincidence that Nate Paul gave Ken Paxton's mistress, Laura Olson, a job while Mr. Paxton was doing Nate's bidding? Is it a coincidence that within 45 days of reporting to the Trump FBI, every whistleblower was terminated or constructively discharged? My counsel talked about $25,000 campaign contribution from Nate Paul in 2018. And he told you that Mr. Paxton is a fundraising machine. Well, in our world, that is a good campaign donor. That is a donor that you have a race. The next year you pick up the phone and you call. There should be a campaign donation in 2019. Where is that? There should be a campaign donation in 2020. That is a good donor. Is it a coincidence that there is no longer campaign contributions? There are no coincidences in Austin. Members of the jury, this is the most important choice you have ever faced. In 100 years, it's probably the only vote that anyone will ever talk about in your careers. It will also decide what Texas politics look like, not just to the way cynical people outside this chamber think, but this is about what does public service mean. Public service. To Mr. Paxton, it meant serving himself and his friend Nate Paul. Mr. Paul brought incredible wealth and a lavish lifestyle to the partnership. And Mr. Paxton brought the incredible power of the state. And the defense here isn't that he didn't do it. It's that it doesn't matter because he won the election. You know, Mr. Kinghorn, summed it up in his testimony yesterday. The office of the Attorney General of the state of Texas is Mr. Paxton's law firm, and he is the firm's only client. He directs it to serve himself, not the people of Texas. If you vote to condone that, then high office will simply be the most profitable choice for any self-serving crook, and it won't even have to be hidden. You're here despite political pressure because you believe that public service is a calling that you put people first. You have everything in common with the whistleblowers, each a faithful servant who has spent years fighting for their values with great integrity. Look at what Mr. Paxton did to them. Think of Ranger Maxwell. In September of 2020, he was a Hall of Fame hero with 40 years of experience, a man of honor above reproach. 1 month later, that lifetime of service meant nothing. When he was an obstacle to Mr. Paxton, he was suddenly a liar, a rogue, a liability that had to be fired. We say we back the blue in this building, but Mr. Paxton tossed him out with the others like the garbage. If you don't hold Mr. Paxton accountable, that could happen to any of us. Your entire legacy could be erased and rewritten on the whim of whoever wins the next election. That is a godless, rudderless morality, and it cannot be the new normal for Texas. We must have a shared standard of integrity, honesty, and service that transcends any election. Your vote will set that standard.
Mr. Mayor, you have 10 minutes left.
At the beginning of trial, we watched all of you place your hand on Sam Houston's Bible and take your oath. Sam Houston's Bible. At that time, I reminded you that Sam Houston told Texans, do right and risk the consequences. Now is your time to do right. Mr. President. Mr. Leach is next.
Mr. Leach, you have about 9 minutes.
Thank you, Lieutenant Governor, distinguished members of the Senate, my fellow House members, General Paxton, and to the people of Texas. Let's be very clear. None of us want to be here today. I don't, and I'm confident that you don't either. But here we are with a heavy and historic moment in front of us. I stand before you today humbly on behalf of the House Board of Managers to offer a few brief closing remarks. These remarks have not been reviewed by anyone. I didn't go to dinner with TLR last night. George P. Bush didn't have his speechwriter draft this for me. Karl Rove's not sitting in my office right now. This is me, and me alone. 10 days ago, as these proceedings commenced, I watched each of you, I sat right over here, and I watched each of you, senators, place your hand one by one on Sam Houston's Bible, swearing to impartially render a verdict based on the law and the evidence. And as Chairman Murr has just articulately outlined for you, the House Board of Managers believe that that evidence meets the high standard of beyond a reasonable doubt. And as strong as we believe the evidence to be, make no mistake, this is not an easy vote for you. It's not. It shouldn't be, and I trust that it's not. It wasn't for me. This will, if you're like me, be
the hardest vote, the most difficult vote, the heaviest vote that you will ever cast in your time in the legislature. This proceeding, we've had a lot of discussion about whether this proceeding is civil or criminal in nature, and as we've learned, it's been a unique mix of both. But it's also very personal. The vote that each of you will cast, I should say the 16 votes that each of you will cast, will be very personal, and they should be. We should treat the heaviness and the historic nature of this moment with the weight that it deserves. Members, senators, I certainly have done so. In voting to impeach General Ken Paxton, my dear friend, a political mentor, a brother in Christ, and a once trusted advisor, this has not just been a hard vote, this has been one of the most difficult things I've ever had to do in my life. Mr. Busby, you said in your closing that we're here because we hate Ken Paxton, and you could not be more wrong. I have loved Ken Paxton for a long time. I've done life with Ken Paxton. We've traveled together, attend church together, attended countless Cowboys and Baylor football games together. Heck, we're both former Baylor student body presidents.
You have 5 minutes.
I've block walked for Ken. I've donated to Ken, supported Ken. I've asked others to do the same. The first bill that I ever passed in the legislature in 2013, the only bill I passed that session, was sponsored by then Senator Ken Paxton. Which is one of the reasons that this is so difficult for me and many of our House members, and I know for many of you, it will be as well. Over the years, Ken and I have spent hours on the phone together. We've texted, we've called. For the first years after he was elected Attorney General, when he took office, I had an open door to the Attorney General's office. I could go up to the 8th floor anytime and visit with my friend. We talked politics and policy. We talked life. Members, I know, as I look across this floor, many of you had the same. But a few years ago, those calls stopped and that open door was closed. And I became increasingly concerned and alarmed at what I saw.
Your Honor, he's testifying, and this is not proper. This is not based on any of the evidence in this case. It's improper.
Mr. Busby, this is closing argument.
I understand what it is, but I'm just saying he's talking about personal things that were not put into evidence.
Mr. Busby and Mr. Leach, the jury will decide what is evidence. Okay.
Thank you, Lieutenant Governor. Members, senators, this has been, the point is, I know it's not lost on you, senators, this is difficult for me, it's been difficult for many of us, and I know it will be difficult for you, and it should be. While the law and the evidence is clear, this is a personal vote for you, and it should be. But make no mistake, we shouldn't have to be here. I, like many of you, in response to those concerns, attempted to get answers, to have conversations, to schedule meetings. I called General Paxton in front of our committee 12 times this session, and not once did he appear in front of our committee for answers. And with all due respect to my friend, Mr. Cogdell, we do not, as legislators, have to go through private counsel to have access to a statewide official. Senator Huffman, if you wanted to meet and have Comptroller Hager come in front of your committee, you don't have to go to his private counsel. Senator Creighton, you don't have to contact Mike Marath's private lawyer for him to come in front of your committee. Not once did he come answer questions in public or in private, which is largely one of the reasons that we're here today, because the people of Texas deserve answers, and the legislature, the Senate and the House expected to get those answers. Members, in closing, I see some of the whistleblowers are here in the gallery this morning. These are men and women of high esteem, character, conservative to the core. And you courageously spoke out, knowing the consequences and taking the risk, much like all of us have had to do and will have to do with this vote. I want you to know that the House has seen you and heard you. Mr. Maxwell, I see you. You deserve more than to be ridiculed and mocked on the floor of the Texas Senate. We hear you and we see you. The House has, and I'm confident that the Senate will as well. In closing, one of my favorite quotes is a quote of Martin Luther King. He says that, quote, cowardice asks the question, is it safe? Expedience asks the question, is it politic? And vanity asks the question, is it popular? But conscience asks the question, is it right? And there comes a time for each of us. There will come a time for you, I believe this is it, not to ask yourself what is safe or popular or politic, but what is right. And I believe that it is right, as painful as it might be, for us and for you to vote to sustain the articles of impeachment commended to you by the Texas House of Representatives. It's an honor to serve with each of you. I pray God's grace and favor and his wisdom and discernment over you as you deliberate and vote on this historic matter. May God bless you, senators, and may God bless the people of Texas. Thank you.
Thank you, Mr. Leach. Thank you, councilors from both sides. Under the rules passed by the Senate, written and passed by the Senate 25-3, Rule 27 says that I shall give you the following instruction to the Senate jurors before deliberations begin. And as a reminder to everyone who may have tuned in late, we have no idea how long deliberations will take, but we will try to notify you once every member has decided they are ready to come to the floor and vote. And we will alert the media, and we will put it up on the website 30 minutes or a little bit more so that you can be aware of when the senators will be back on the floor to vote individually on all 16 articles. These are the instructions as you have written. Sustaining an article of impeachment means that the impeached officer is removed from office for the term the officer was last elected. You are instructed that the rules adopted by the Court of Impeachment establish that the burden of proof rests on the House Board of Managers to prove an article of impeachment beyond a reasonable doubt. You are to determine if the allegation in each article presented to you has been proven beyond a reasonable doubt. And if so, shall the article of impeachment be sustained, which would result in removal from office? The final question to be put to you after each article is, shall this article of impeachment be sustained? Members, we will adjourn for this day very shortly. You will go to deliberate. I want to repeat that if the deliberations last until the night, when you leave here, you're not to talk to anyone about this trial. You're not to talk or watch anything on television about this trial. Go online and surf any news. You have serious work to do. And I believe that you will do it in a serious and responsible fashion. I'm going to order you to work to at least 8 tonight in deliberations. You can work longer if you wish. To be back here, if you have not come to a decision today on all 16 articles, to come back tomorrow morning at 9 a.m. and work until 8 tomorrow night. If a decision is still not reached, to be here at noon on Sunday. And if a decision is not reached by late Sunday night, I may take the option of sequestering you in the building. We all have slept overnight in our office once or twice. I know I have. Take as much time as you need to come to the decision that you believe is the right decision. God bless all of you. Thank you for your service to Texas. We stand adjourned.
Okay, so you just heard the instructions from Lieutenant Governor Dan Patrick, and at this point, closing arguments have been finished. from both the prosecution and defense. And as you heard, they will now go into deliberations, and these deliberations are closed. We will have no idea what they are saying and what's being said. They will not vote until they actually come back, and that will be done in open. Now, when we talked to Teresa and when we talked to Tanya Iser earlier, they both agreed that they didn't think this would go throughout the weekend based on a number of different factors. 7 senators being seen eating dinner together last night, that people kind of have an idea of how they're going to vote already.
I think it's going to be interesting to find out on the other side of this just how these 16 articles of impeachment go down inside that session. Obviously, it's closed right now, but I imagine we'll hear when it's all said and done how those discussions went and really who had their mind made up ahead of time and who really struggled with this deliberation. And again, you've got 16 of these articles, so they could return, one of them in Ken Paxton's favor. All 16 of them, none of them. It's going to be interesting to see how this plays out.
Just have to have one.
Yeah, but I do think the calculation of, are these jurors, Texas state senators, really ready after 2 weeks of this to put a bow on this, wrap this up, get back to their home districts, get back to their lives? I imagine quite a few, if not all of them, are more than ready to.
Well, Teresa Woodard has been in Austin, and she's right outside the chamber, excuse me. Teresa, okay, so we heard the instructions. I know we spoke to you earlier, just kind of putting a bow on what you thought of the closing arguments. So now that it's all said and done, what are you seeing and what's happening around you outside?
Yeah, well, I think, first of all, you could really feel the gravity of what is happening based on just sort of the ending of those closing arguments when you heard Jeff Leach, who is, of course, a state representative from Allen, from Collin County, deep red Collin County, a tried and true conservative. He said he is a dear friend. He loves Ken Paxton. He was one of the ones who voted to impeach in the House, and he was the last one. He's the last voice that senators will have in their minds when they go into those deliberations, telling them basically, this is the hardest vote that you will ever take. I know because I took it too, but telling them he believes it is the right thing to do. You also could feel the gravity when Dan Patrick was saying, if you don't come to a conclusion tonight, if you don't come to a conclusion on Sunday, we may decide to sequester you here. Maybe you'll have to sleep in your office. As you were just saying, Mark and Kara, it's really unclear how long this is going to go. Do we think that potentially they want to be home with their families for the weekend? Sure. But after hearing the closing arguments and just how procedural the prosecution was, sort of going through surgically and reminding them, here's this article and here's the evidence we believe proves it. I don't know. Does that change anybody? Does it persuade anybody? I'm not sure. The thing I think is very interesting is when you compare the styles of how the defense closed versus how the prosecution closed. The defense was about style. It was sort of about performance. It was appealing to maybe some of the extreme thoughts that some people might have, that the FBI can't be trusted, that the DOJ is being weaponized. And then when you came to the House and the prosecutor's closing, there was very little hyperbole. It was very much, this is what we're accusing, and here's the evidence we've laid out. One interesting point to make is you might be able to hear people talking around me, and sure, there are a lot of people inside the Senate watching this go down, but people come to the state capitol and continue just to take tours and to walk around. And so we've seen, just a little while ago, there was a couple taking wedding pictures right out here in the rotunda. So daily life continues for visitors who come to the Capitol, and they may not even realize exactly what's going on, that they are here on a day when Texas history is being made. No matter what the outcome of this, we are seeing history happen right now.
Teresa, I saw on Twitter pictures of that couple that was taking some wedding photos in the Capitol Rotunda. Yeah. It kind of makes you wonder, is that a good omen or a bad omen if you're getting your wedding photos there during an impeachment trial? But we kind of alluded to this before, and I wanted to get your perspective. You're there in Austin. Obviously, you've covered the state legislature time and time again, and maybe you have some insight into this. But this is not your typical jury trial where you've got 12 of your peers that are chosen, and they're supposed to be unbiased and really only hear the information presented there. Yeah. The political considerations here have to be weighing on each and every state senator who's acting as a juror in this situation. How much of a factor do you think that's going to be when this is all said and done?
It's a huge factor. You cannot divorce politics from what's happening. You cannot pretend that when these senators go home, the constituents in their district are going to have a feeling one way or the other. So you cannot remove that from the process. But I do think, and I know I'm repeating myself here, that might be why we saw State Representative Jeff Leach, a hyper-conservative member of the state legislature, as the final voice. He basically was saying to some of these other Republicans who may be trying to decide, should I do this or should I not? Does my political future depend on this? He basically was trying to say, I did it. It's the brave thing to do. It's the right thing to do, in his opinion.
All right, Teresa Woodard, we appreciate your insight and update. And I know we'll be checking back in with you later today once we do perhaps anticipate getting a verdict in. Let's go to Tanya Iser right now, who has heard every single minute of this impeachment trial. She's joined by her political and legal analyst to give us some insight. Okay, Tanya, when we heard at the very end, those last couple of minutes, you heard the prosecution sort of jump in, and they wanted the judge, Lieutenant Governor Dan Patrick, to sort of intervene there at the very end, feeling that his closing argument was more like a character witness.
Right. Obviously, that indicates how effective what Representative Leach was doing. I mean, here you have a representative from Collin County, thundering in this Senate chamber, calling for the removal of Ken Paxton. And he said, none of us want to be here today. I don't. And so I want to bring in Bud Kennedy and Stephanie Alvarado, both of whom have been also watching this trial. I want to get your reactions. Stephanie, I want to start with you as a legal analyst. What you thought about what you heard from Andrew Murr and Representative Leach?
Well, I think what Teresa said is right. Their approach was completely different. Not as much passion, more methodical, but when you feel like the law is on your side, that's usually in the evidence, that's the theme that you will continue to portray. And so that's why he felt he was going to stand up and he's going to lay out all of the evidence, especially the key evidence, since the senators will be able to take the exhibits back with them. He wanted them to key in on what they feel was the strongest bits of evidence that they have. I love his theme when he first did opening close, when he said that Paxton was elected by 4.2 million, but he was only serving one himself. I mean, I think that that's a theme that he kept going. He talked about all the different exhibits with respect to the house renovations, all of the things that benefited him, doing things that he wasn't even allowed to do, as far as like electing a special prosecutor, appointing a special prosecutor. He did to purely benefit his friend, is what the evidence they feel shows. So I think as far as them, I agree with you, them saving Jeff Leach until the end was not by accident. That was completely calculated, and it was the right thing to do, because this is about politics, and it is pitting members of the party against each other.
Absolutely, Bud.
Well, I think the difference in the two arguments, I think in Busby and Murr, was the difference in using buckshot and a sniper rifle. Busby had all these different targets. Murr just went through the articles, ticked through and said, you know this, you know this, you heard this, you heard this, let's hear it again. You heard this, you know this. He went through everything. We got to hear the reference to Austin Kinghorn's testimony, saying the Attorney General's office is Ken Paxton's law offices, and he's the only client. It was as if the people of Texas didn't even exist. He was the witness who didn't even know what the oath was, that he was supposed to swear an oath to the people of Texas. And then when Murr talked about the godless, rudderless morality involved, that has to appeal. I think the senators know how they're going to vote. I said that because they've probably already had their consultants write their statements that are ready to publish. So I don't really think they're going to take very long. I think they're going to go out for a while and look like they're doing a lot of deliberation. But I think they really know what they're planning.
Well, we also saw both sides use different methods of conveying their message in terms of what the House Board of Managers did. They were playing selective clips, and we're going to bring up a picture here in a second that shows what the defense was doing was they were putting up pictures throughout. That's one showing Rusty Hardin, and they had some other ones showing Bible verses throughout. That's kind of what the tactic was. How effective, Stephanie, do you think it was, in particular, I want to go with the Board of Managers, playing these clips of what witnesses said?
Since they don't have I'm assuming they don't have the benefit of a court reporter, that's pretty common, and it is effective when you're worried about whether people are going to mishear or understand testimony that was given. It's always good to have it exactly read back to the jury, so that they can say, okay, well, that's what the person swore to and said under oath. So that was great strategy-wise. That was wonderful. Lawyers use that every day. The only difference is they use it through the benefit of a court reporter by having them read back the record.
I thought it was extremely effective. And go ahead.
I just want to say, I think showing cartoons in the Senate is a little juvenile, and I think that some of this was something you might do in a court of law. Some of the behavior by Mr. Busby was something you might do at a normal court, but I don't think it plays well with the 31 senators. And at the end, when he interrupted Leach, I mean, in football they call that icing the kicker. It's just like trying to interrupt and trying to knock him off. You saw how effective he was.
The other thing I noticed was, throughout the defense had used this, there are no coincidences in Austin phrase, but we saw the prosecutors turn that on its head and actually use that against Ken Paxton, recounting it's no coincidences related to how the renovations were handled, no coincidences related to the hiring of Laura Olson, no coincidences in terms of the way that what happened to the whistleblowers, just up and down the line. I mean, how effective do you think that the way they used that was, Stephanie?
That's very common. It was very effective, and that happens a lot too. That's a risk you take when you use a catchphrase like that for a theme when you're trying a case. You could very well have it turned around and used against you, and good prosecutors will do that. I mean, it's happened to me before. And
Tony Busby's original use of it, his opening statement, was based on a falsehood. He was saying that because Ken Paxton tweeted about Dade Phelan's slurring his words, then right then Dade Phelan said, okay, let's indict, let's impeach Ken Paxton. Well, no, the House had been investigating for 2 months. Even the timeline that day, the committee was already moving on it before Paxton tweeted that. Paxton tweeted that knowing what was coming. So, Busby, everybody in the Senate knows that was baloney.
And then the other thing we heard, and I thought this was effective also, was when Representative Murr quoted from this, talking about what Sam Houston had said, talking about do right and risk consequences, and now is your time to do right. What did you think about that, Bud?
Oh gosh, Sam Houston gets quoted so much by everybody. We forget that he got thrown out as president because he wouldn't go along with secession. So the whole idea of it, Sam Houston's Bible, it's overworked at the Capitol, but it's still effective to the people in the Senate chamber.
Okay. Well, I appreciate you guys joining me. We're going to send it back to Mark and Kara.
Okay, great insight, Tanya and the rest of the team. Thank you for that. As we know that the senators are now headed to closed session, they will be deliberating, and there is no time limit, although we did hear Lieutenant Governor Dan Patrick kind of issue some recommendations, wanted them to go till at least 8 o'clock tonight if they did not have a decision, and he talked about if they have to go into the weekend, Saturday and Sunday as well. Once they're done, they will submit a written vote. The clerk of the court will then read the votes, then announce a tally. Then Dan Patrick, again, who is serving as the judge in this case, he will individually poll the senators, and they'll do that for all 16 of these articles of impeachment.
There are two outcomes. So if he is found guilty, he's immediately removed from office. The House Board of Managers can then move to disqualify him from holding future state office. If that happens, each side will get 15 minutes to debate. Then senators will vote. A 2/3 threshold must be met for Paxton to be barred from future state office. If he is acquitted on all articles, Paxton can return to his office.
Of course, we are sitting here waiting to find out what happens, and we will get back in when the votes are being counted. So definitely keep it here on WFAA. We have no idea how long this will take, if we're talking 1 hour or 20 hours.
Well, you can make sure that you can watch Tanya Iser, our investigative reporter, and our team of experts on our streaming app, WFAA Plus, on Apple TV, Roku, and Amazon Fire. If you are at work, on the go, you can always tune in on our YouTube page and at WFAA.com. Right now, we'll send it back to GMA3.
Okay, folks, we are back. We've been kind of doing double duty both on the live stream and live on TV, so we can kind of settle into a more relaxed format. I want to just kind of get reactions from you guys. I mean, I personally, during Representative Leach and Representative Murr's closings, I had goosebumps at a couple of points. I mean, I thought it was so powerful.
Well, I said the other day that I didn't think the prosecution was bringing all the energy and emotion that they brought in the House when the House passed impeachment with 60 Republicans voting for it. I think they did rally some of that again in this closing. And I think Representative Murr, with his folksy West Texas junction, it was kind of a duel of I'm just a country lawyer, but you could tell who was really a country lawyer. And I thought that his delivery was very deliberate and direct and believable. And Tony Buzbee is worth every penny. There's no question about it. He puts on a show. He puts on a spectacle. He puts doubt in everybody's mind. But I'm not sure that he was able to push his client over the top. I still think it's one vote difference. I think it's 20-10 or 21-9, and we'll see.
And we will. I think it's likely that we'll see that today, one way or the other. Yeah. Stephanie?
Yeah, I thought both sides did a great job. I mean, we knew stylistically it was going to be very different because they are such different types of lawyers. Tony Buzbee, dynamic. I was telling you, Tanya, several times, an hour for a lawyer to argue is a lawyer's dream. I mean, we normally, anybody can tell you in state court we don't get that time. In federal court, I'm sure they get even less time. It was probably a dream for him to be able to argue that long. So he was going to give it all that he got. He put in there, I don't think it was any accident that he mentioned several times he was a former Marine.
6 times.
Yeah, he knows who he's talking to. He knows that, there are people, there are veterans out there. Those are the people who vote, conservative people. He wants to bring a chord with those people, strike a chord with them, let them know that he's one of them. A few people were wondering, and I know we talked off camera about why the Attorney General is actually there, like physically there. I also think that was a good move on his part as well, on the defense team's part. Personalize your client, show that he's proud to be there. He's proud to be defended by these 2 fine attorneys. That he's wanting to everybody to see that, yes, I'm here. I want these people that are going to have to vote against me to look me in the eye and tell me that this is what's happening.
Do you think it was good for Buzbee to only leave Dan Cogdell a couple of minutes? Dan Cogdell was barely up long enough to say this was dumber than a bucket of hair.
Yeah, I kind of wondered what the strategy of that is. Dan is a big hired gun as well. Good lawyer, represented people in complex litigation, white collar crimes, things like that. I don't know. I kind of wondered what his strategy was with that too. Just a different stylistically. Maybe Tony was thinking, Mr. Buzbee was thinking, hey, if I turn some people off, let's get somebody like you who's a little bit more low key, who might appeal.
Good cop, bad cop.
Good cop, bad cop thing. Kind of different ends of the spectrum. So good compliments to each other.
I thought Cogdell even felt like he was a little short, but obviously he was brought up to kind of soften the blow. We need to mention, for those who don't know, Tony Buzbee is a candidate for Houston City Council, and so he certainly used this time effectively to remind everybody about his working class upbringing, his Marine background. Did he mention that he's an Aggie?
He did mention that.
I think he did.
Yeah, he did.
Well, he's a son of a butcher. That's Buzbee, son of a butcher, son of a cafeteria worker, and of course a captain in the Marine Corps.
Right, and he didn't say, and a candidate for your city council is the part he left out.
And he ended by saying, "I'm asking you to put this man back to work and vote not guilty."
Right.
But he definitely framed it as they didn't prove anything, nothing to see here, and this is all a conspiracy. I mean, that's kind of the bottom line of what he was saying.
Well, and one of the key things there is that he referred to Biden's FBI and Department of Justice, and then Murr came right back and said that when the whistleblowers quit, they reported it to the Trump FBI, and he made a point to say that it was the Trump FBI. They didn't go to the Democrats in Washington; it was the Republicans.
Stephanie, you have been a special prosecutor, right?
Yes, ma'am.
To be a special prosecutor, you have to be appointed, right?
Yes.
So Mr. Kamek was never appointed, and you would have to be appointed by the DA's office, right?
That's right.
So there'd be a piece of paper if he was, there'd be something, some record of that.
Evidence of that, correct.
And that never happened. And contrary to what they played a clip from a hearing, either in the Texas Senate or the Texas House, I forget which one, where that claim was made, but that was not the case. He was never appointed to be a special prosecutor, although he presented himself as one. But it was interesting, they described getting grand jury subpoenas as a prosecutorial act. Walk us through the problem with Brandon Kamek getting those subpoenas. What's the issue there?
Well, obviously, when you start to do things like that, you are invading the purview and the province of the prosecuting authority in the county where you're trying to conduct this criminal investigation. The other problem is if you, as a lawyer, as the special prosecutor, are going to be the one doing that and in any way are thinking about going out on service of that subpoena or talking to witnesses, you are in fact putting yourself in jeopardy of making yourself a fact witness to whatever it is that you may find out. So as lawyers, we're taught, let your investigator do that. That is not, stay in your lane, for lack of a better phrase. Let your investigator do that. That way, if somebody has to testify about anything that happened on that fact-finding mission, they'll be able to do that. You as a lawyer, if you do that, then there you are.
On the west side of San Antonio, you'll find a hidden gem. It looks like a record store, but it's much more. Since 1966, Del Bravo Records has been a part of our local cultura.
They had a dream. My dad loved music. To have made a business out of music is
a juror. She's counted basically as present in terms of the vote totals. In other words, which is why you have to have the numbers that you have to have, the 21, but not for the purposes of deliberations. All right, so next one. Okay, so somebody's asking, okay, so yesterday there was an email exchange that, email document evidence during, I think it was the last witness that it was Dutko was trying to get in. It was an email exchange with, it was Dorfman was on the stand, the guy that's like the deputy first assistant, and there was some kind of email exchange. They wanted to get in, and it seemed like they wanted to get it in to impeach him on something he had said, and no, they did not get it in. I do not know what that email exchange was. It seemed like, just based on the context, that it had something to do with settlement negotiations, but they never got it in, and I very much wanted to know what that was, but I do not know at this point what it was. Okay, so I'm going to keep going through these questions. So kind of a political question, so I'm going to let you answer it, Bernadine. This person's questions regarding the verdict. Throughout the week, y'all have been often pondered, will the jurors make their decision based on the law or politics? My question is this: if the senators allow politics to overrule the rule of law and they acquit Paxton because of politics, what happens to the rule of law in Texas?
I want to immediately say no, but obviously it's going to be a political decision among some of them. But as far as the rule of law, it doesn't change the rule of law. But you know what, and you can help me with this, but the rule of law is primarily on interpretation and or whatever. I know it's strictly, but in terms of politics, this is politics.
This has always been a political proceeding. Yeah,
it's political. So I would say that politically it's going to have a lot of ramifications and discussions and whatever. But in terms of the actual law, I wouldn't think so. No.
I don't think so either. I mean, it's just like any other typical criminal trial, any other kind of trial. You can always ask for jury nullification. I mean, there's parameters around doing that, but jurors do that all the time. Jurors, being they're supposed to, and they're charged. In the jury charge, they're told that they are the arbiters of the facts. Arbiters of the facts, and they are supposed to apply the law as it is written to the facts, but sometimes they don't do that. Yeah. And once they do that, you can't really invade the province of the jury. That's the way our system is set up. So I don't think that this case is going to be the death knell for the rule of law in Texas. But yes, it's definitely politics. And it's definitely going to be what prevails.
A number of Paxton supporters have already said that they're going to primary those who vote to sustain the orders, that there would be some significant ramifications behind how they vote.
Well, which is going to segue into the next question. This person says, I heard Bud Kennedy say the Texas Republican Party is divided into 5 factions. What are those factions? And so Bud gave me the answer, because I definitely don't know the answer to this. Okay, the 5 factions, according to Bud Kennedy, are Trump Christians. They believe in Christian rule. The second one is Faith and Values Christians. They believe in electing Christians who model good witness. He's got much better handwriting than mine. Trump Patriots, that's the militias, gun groups, something rights, and then probably gun rights. I don't know, some kind of rights. Business Republicans and Defense Republicans. So that, according to Bud, is his assessment of the 5 factions of the Republican Party. Let's see, okay, I'm going to keep going through these questions. somebody says, I'm aware a lot of this is politics. However, isn't it against their duties to ignore evidence? Well, the reality is this is politics. I mean, this is not your typical, it's not a criminal trial. It's not a civil trial. It is what it is, you know?
Well, and then too, obviously we have to trust the reason that they give us for reaching their decision. But if you look at the charge that Patrick told them, look at the evidence, look at what you have, and not to base on your personal and all of that. But I don't think that anybody believes that that's going to happen.
Well, I live in the real world, so, you know. Okay, so, Jay is going to play a story that explains articles of impeachment and how this works, I think, because that'll help answer some of the questions you guys have out there.
The Texas House of Representatives charged Ken Paxton with 20 offenses. Each one of these is called an article of impeachment. It's now up, though, to the Texas Senate to try Paxton on these allegations. Senators immediately set aside 4 of the charges, and we'll get to those here in just a moment. It might be easiest, though, to put these charges into 4 buckets, maybe. The first 5 involve a real estate developer in Austin named Nate Paul. He was a friend and financial donor to Ken Paxton. Well, the first charge here accuses Paxton of improperly getting the state involved in a private lawsuit that Nate Paul had with a charity when prosecutors say it had nothing to do with the taxpayers of Texas. Paxton is also accused of issuing official legal rulings to prevent the foreclosure of some of Nate Paul's properties, and then blocking public information requests, protecting Nate Paul's records in the Texas Department of Public Safety. Article 4 of the impeachment says that Paxton misused official information, giving Nate Paul government documents that had not been made public. And the last one here in this set says Paxton misused his power by appointing a private attorney as special prosecutor to investigate things for Nate Paul. Now the second set, Articles 6 through 10. Paxton's top staff, his own deputies that he handpicked, they finally blew the whistle on him. They reported Paxton for accepting bribes and tampering with government documents to help Nate Paul. Another of the impeachment articles is for Paxton, though, retaliating against those whistleblowers and firing them all. Then, to clear his own name, House investigators say Paxton conducted a bogus investigation into those complaints from the whistleblowers and then published a report with false information in it. Paxton then tried to privately settle the whistleblower lawsuit and asked state lawmakers to pay $3.3 million of taxpayer funds to pay off his former deputies. Article 9 here alleges bribery. Prosecutors say that Paxton gave Nate Paul favorable treatment as Attorney General when Paul hired the woman with whom Paxton was having an extramarital affair. Prosecutors say Paxton took another bribe from Nate Paul, letting Paul renovate Paxton's home in exchange for more special access to the Attorney General's office. So that's the first half. The next 4 articles here, 11, 12, 13, and 14, these were the ones all set aside by the state Senate. These 4 are related to Paxton's criminal charges for securities fraud that go back to 2008. Now the final group here, Articles 15 through 20. These are broader. Article 15 says Paxton lied in his office's report about the whistleblower allegations. The next one alleges conspiracy, that Paxton worked with others to commit these acts. Prosecutors say Paxton also, quote, misused his official powers by having state employees do things that benefited Paxton personally. This one says Paxton violated the state constitution and his oath of office. Article 19 here says Paxton is unfit for public office. And then the last one accuses Paxton of bringing scandal to the state government. Paxton says all these allegations will be easily disproven. That's what the impeachment trial is now for in the state Senate. Keep in mind, this is not a legal trial, it's a political one. If state senators find Paxton guilty, he will be removed from office. If they acquit Paxton, he will return to work as Texas Attorney General. I'm Jason Whiteley.
Okay, so this is a graphic that shows a criminal versus a political trial. Obviously, the court, the Texas Senate, the judge, the presiding officer, of course, in this case it was Lieutenant Governor Dan Patrick, the jury being the members of the Texas Senate, and the prosecutors, the House Board of Managers, and that's what we've seen play out over the last 2 weeks. Okay, so I'm going to keep working my way through these questions because I promised folks that we would answer them, or we would try the best we can. So Bernadine, I'm going to go to you. And I don't know, Stephanie, you can try this one too. If General Paxton is acquitted, will the actions that he took be legal and ethical for future AGs and politicians in Texas? What kind of message does it send? I think that's basically what the person's asking.
Well, the only reason I'm struggling is because until we do get some kind of decision, then it depends on which side. See, remember the defense is saying he did nothing wrong.
Right.
But the House is saying he did a lot wrong. So I think until a decision is made or is flushed out, you can't say, well, we can say because they brought up a lot of policies, but that's what the whole trial is about. Whether or not he did something wrong, incorrectly, or it was just part of his job.
Stephanie?
Well, I think you don't want to. I don't think you want to set the bar according to this trial and to the things that have gone on along here. There are a lot of ethical ramifications. I mean, nobody is really talking about, because it's not an issue, the ethical ramifications. I mean, at the end of the day, he's still a lawyer and he still has ethical duties and obligations that he has to abide by as a licensed lawyer in the state of Texas, which is why those whistleblowers did what they did. I mean, we've talked about this, Tanya, you and I cannot imagine being a young lawyer, starting your career, going to the AG's office thinking this is the career path. For me, I want to be, whether you decide you want to be a lifelong government employee or if it's a stepping stone to another government job, having the courage and the will, sticking your neck out to not only go against your boss, but to accuse them of a crime. I don't think that we want to set the bar here, and I don't think that anybody is saying that, and I really don't think. I think that's a little overreach by saying that if he is found not sustained, that is a stamp on saying that everything he did was okay, because that happens all the time in criminal trials too. Jurors, I'll often go back and talk to jurors and ask them, what did you base your decision on? And a lot of times they will say, I don't believe that he or she didn't do X, Y, Z. I just don't think that the state proved it. That's different. So I don't think if these articles are not sustained, I don't think that means that he is not without some wrongdoing and that he won't be held accountable in some venue or some realm. He's still going to have to contend with possible criminal, prosecution, possible, if the bar may still look at him for ethical violations. I mean, he's not going to be completely out of the woods. So it's by no means a go-by for anybody.
Well, and I will, whether he's removed or not, that's the purview of the Senate. But as someone who has covered the criminal justice system for 30 years and who did stories that a former Democratic DA probably wasn't very happy with, that exposed his misuse of forfeiture funds, I think that we should hold our public officials to a higher standard. And I believe that. And part of my thought process in terms of the way I do my job is holding people accountable, kind of the old saying, comforting the afflicted and afflicting the comforted, bringing things into the light. I know they all sound kind of hokey when I say it out loud, but I really do believe that. And the things that we heard described here, we cannot pretend that they were okay. It's not okay. Whether you should be removed or not, that's a different matter. That's not for me to say. But I have talked to many, many attorneys, and not an attorney that I know who has said that the things that were described in terms of the hiring of Mr. Kamek, and in terms of even the way the open records situation was handled. I've filed thousands of open records requests in my career, and I know how they're handled, and I know how with the things I've dealt with. it might have not been handled that way. So, we just expect we should hold our public officials to a higher level of accountability, and I think that's regardless of political party, and that's just where I stand on it. But in terms of what should or shouldn't happen to him, that's not for me to say, and that's for these Senate jurors to decide. Okay.
But well, let me just weigh in just quickly.
Okay.
Because everything that you've said, I'm sure a number of people feel the same way, and especially in terms of the law part. But keep in mind now, and I sort of answer from a political perspective, because if he runs again, if they don't sustain and he runs again and he wins, then his voters, which probably will be a great majority of our Texans, they're going to say what he did. While I might not agree with it, I accept it. Now, whether I totally agree that it shouldn't be that type of behavior, definitely, especially from a attorney general. Yeah. It shouldn't be acceptable.
You run the state's law firm.
But
and we should have
if he gets in that office again, then it does raise the question whether or not his voters viewed it, and then if he wins, it's the majority of the voters view it as something that they don't want to hold him accountable for.
So Jay just walked up and handed me, so far we've had a little over 1,300 people voting, and how long senators will deliberate. 48% say until 4 p.m. or earlier. 28% say until 8 p.m. So clearly, clear majority think this is going to end today. Until Saturday, 14%. Until Sunday, 10%. I'm in the probably in the until 8 camp. I mean, I would say I'm in that camp. I say that just because. Yeah, I just feel like it'll well, it may not go till 8, but I think it's going to go later than 4. That's just complete speculation and conjecture based upon. But I'm always wrong about deliberations. So I mean, I've this is not the same as a criminal trial, but anytime I think I know on a deliberation, I never do. So, but it just feels like that these senators are going to want to get home, and I bet if we had access to their travel itineraries, we'd have a much better sense.
Why is that private? why we don't have that information?
We'll talk about it in a minute. Jay's talking in my ear. We'll go back there in a minute. But let me keep going through these questions. I promised folks, Jay, that I'm going to work through these questions. Okay. So somebody asked, have we heard anything from Dick DeGuerin, and if not, why? Dick DeGuerin questioned a couple witnesses, but he didn't do any of the openings or the closings. They obviously, with the openings and closings, they let the House members do that, but he did do a couple of the witnesses. Do you think if Paxton cannot serve in Texas, will Trump ask him to serve if he is elected? You see Trump so if Trump were to get reelected, this is what this person's asking. If Trump were to get reelected, would he bring Paxton to Washington?
Absolutely, if it helps him. If it helps him, because if you look at some of the things that Trump has been accused of, he's been impeached twice, has never had it sustained, then a lot of those things are what Paxton's doing. But I say that it depends upon whether or not it fits within former president's idea of what he wants, because he's still strongly behind Paxton. He's still strong. So I think he would, if only if, because he would carry baggage to anyone else. But he's very popular among Trump supporters. Now, he would never have a peaceful day in his life.
Right.
But that's not how Trump makes decisions.
Oh my, this person sends a lot of questions. Let me see if I can. This person's asking, okay. Sorry, it's really long. So this person's asking about if we think that the FBI or the DOJ will be indicting for a conspiracy. Well, obviously we have no idea on that. Nate Paul is under indictment right now, and what we do know is that from testimony is that there is an ongoing federal grand jury investigation, but in terms of what could or might happen. We have absolutely no idea what might be happening on that. So let me kind of go on to some of the others. That one's sorry guys, I'm trying to go through these in order. Let me bring this up as I kind of work my way through these questions. So, what did you think about Stephanie? About a little bit more about, Laura. How much of a problem do you think it was that we didn't hear from Laura Olson? I mean, were you surprised about that?
No, I mean, all of those things are to use Busby's analogy that he used in his closing, the 3 buckets. Of the 3 buckets, that really wasn't that. I mean, that wasn't the most egregious. I mean, morally, do people disapprove of it? Yes. Is it salacious? Would it have been juicy to hear all of that stuff? Would we have been? Yes. From a trial standpoint or a criminal trial standpoint, I really don't think it's that big of a loss. I think we're just, human natures, we're nosy, and we wanted to hear something juicy.
Well, I would have wanted to know. So, how did you come to know Nate Paul? Who told you about the job?
Exactly.
Who told you about the job?
That's exactly why it didn't happen.
Yeah, I take
But those would be the questions I have.
Right.
Those would be the things I'd want to know.
Exactly what.
How did you come to get this job?
Right. And who's to say
how'd you find out about it? Was it posted?
Who's to say that those questions won't be asked of her someday? Like I said, in another realm, and whether it be by a deposition or an interview. Maybe she gives a big Oprah-like interview. I mean, we don't know. We
know Tucker's doing interviews.
Could be. That's good speculation too.
Not of her.
Yeah, because what I'm referring to, folks, for you guys that don't know, is that Ken Paxton tweeted out, I don't know, was it yesterday, the day before, that he was going to go do an interview in Maine with Tucker Carlson. So here's another question. Since Brandon Kammack was not paid for the services he provided to AG Paxton, could he file a criminal charge of theft of service against the AG, or could it be more of a civil lawsuit to get the money that he's owed? Now, bear in mind, this is now 3 years. Even if, I don't know that you could file criminally, and probably not.
Well, depending on what he puts the value of his services at.
He said he was owed $14,000.
Well, if that's a felony amount, so he has 5 years to file something like that. If he were, I don't see him doing. I don't know why anybody would want to serve themselves up to be scrutinized, whether it be from the prosecutorial end of things or from, I don't know where he's working now, what he's doing now.
He probably just would like to put this behind
exactly.
him.
I'm sure he just would prefer to go back to being just a plain citizen and anonymous. I don't know why he would want to do that and subject himself to that.
But that
scrutiny.
became obvious during his testimony. I just want to go away.
Yeah.
I want to go on my honeymoon. I want to just.
Yeah, I want to be done with this, and I think that was the sense I got from him. I got the sense that the last place that he wanted to be was testifying before the Texas Senate.
In court.
Absolutely. Okay, so here's a question. I think this is a Stephanie question. When Rusty Hardin rested, could he have withdrawn his rest since he mistakenly rested?
Okay, now Deandra talked a little bit about that yesterday. So when you do that in criminal trials in state court, the state, which that's who he's representing, you have the absolute right to reopen if something has. This is not a criminal trial. They are not adhering by black letter procedural rules. Although Justice Landemeyer is the perfect person to have as your spotter, as your judge spotter. I can think of nobody who would be better. I practiced in front of her. Several of us in Dallas have. She is above reproach. She is a rule follower. She is to the T, very extremely thorough. Even before she went on even before she got to the high court, she was very much a by the book judge. So. Yeah, they would have in state court. The answer is I don't know, because I don't know what procedural rules they're using here. But I do know in state court, the state does have the absolute right to reopen.
Can they reject it?
No. In fact, it's a reversible error in state court if you don't let the state
obviously
reopen.
There's no reversible
that's
error
why
in
I'm saying.
impeachment court.
That's why I'm saying it's different. We're in a different realm. So I really don't know.
Yeah.
And could the fact that Busby saying I don't intend to cross him anyway at this point have played into that?
It could be.
Yeah. And he didn't call him back up.
No, he said I
think Brickman was what we're talking about is Blake Brickman. He was the last prosecution witness. And he was a pretty effective witness.
Sure was.
But he was clearly very angry at what had happened to him, but I found him to be pretty effective. Okay, so someone's asking again, did Dan Patrick say whether Angela Paxton could be present during the deliberations? My understanding is she will not be present. She shouldn't be present because she's not a juror. She had to be present for the purposes of because all the senators have to be present per the Constitution. And this person's also telling me to tell my sweet son thank you for sharing his mom. So I appreciate that. He has been, I am very blessed to have an 11-year-old son who is he's just a really good kid. He makes my life easier in times like this, although, he's a typical kid. He throws stuff on the floor, can't seem to find the trash can, like most males. Anyway, so let's go on to the next question. Does the panel feel like there will be fallout at the AG's office no matter the outcome? I don't know.
I mean,
it seems like the fallout happened 3 years ago.
I was going to say, I can't imagine what the morale there has been.
Yeah.
I mean, talk about walking on eggshells. I just can't even imagine, if he's going to come back and resume work as Mr. Busby said he's prepared to do. That'd be a very tense workplace to go back to.
Yeah, but I think that in terms of the fallout, 3 years ago, all the people that were, that had an issue with the way he was running it, they're gone. Mm-hmm. And so the people that he's got surrounding him now are
loyalists.
Okay with,
probably
they're okay
loyalists.
With the way things are, are being
Excuse
done.
me.
So somebody's asking, how would we vote? Well, I definitely am not going to comment on how I would vote one way or the other. That is not for me to say. That is up to the Senate jurors. Let's see. And I know Bernadine's not going to do it.
I have no intentions.
No.
Nor do I.
Because I can't vote anyway.
No, and it's pointless. And so
and then
that's,
no.
Nope. So, okay, I'm going to read this out loud, and I think it's going to be a question that Stephanie's going to have the answer to. The defense attorney made a big point of explaining how investigating the validity of search warrants was the bread and butter of being a defense attorney. Using this logic, he questions why it was illegal for Paxton to ask to investigate the search warrant against Nate Paul. My question to you is this. If it is so common for defense attorneys to investigate the validity of search warrants, why was this not done by Nate Paul's attorney? Why was it necessary for Ken Paxton to hire an outside counsel to do this very basic and common task for all defense attorneys?
Well, if Nate Paul's attorney were to do it, he would have to do it in some kind of litigation aspect, and he would have no way to do that. They were asking Paxton to do it because he is a law enforcement official. He has the connections. He would have the ability to approach anything he uncovered as a law enforcement officer.
But he wouldn't have the ability to get a sealed search warrant.
Well, no, he wouldn't. But he would be able to use his connections, which is what he's essentially getting in trouble for. To ask a private attorney to do that, if there's no pending case, a private attorney doesn't have the right to have the state turn that stuff over to him or her.
Right.
In fact, a lot of people don't understand that we as attorneys, we don't get access to our clients' what they call discovery or criminal offense reports or statements or anything like that until there is a critical step in the prosecution, whether it be indictment or arrest. So if none of that is going on, if you're wondering if your client is being investigated for a crime, you are essentially at the mercy of the police department or the DA's office. And you're right, it's a phone call, and they are under no obligation, no legal obligation at that stage of the process to share that information with you. So yes, we do get to pick apart warrants and so forth, but it has to be at a certain stage in the prosecution process.
Right, and at that point, you know, he had not been charged or indicted with a crime. And Brandon Kamek had not been appointed as a special prosecutor. He was not an attorney pro tem. He had not been appointed by the DA. He had no right to seek grand jury subpoenas, right? I mean, he was a special prosecutor.
Correct.
So, you know, and then there was just so many irregularities about the way that was done. How many times have you been a special prosecutor?
I've been a special prosecutor once, I believe, here in Dallas.
And would you typically
County?
Would you typically pick a person with more or less experience?
More, definitely. Yeah.
And the thing is again, he wasn't a special prosecutor, even though he was billing himself as one.
Yeah.
It seemed like he didn't really totally even understand what a special prosecutor is.
And that very well could be. I mean, he was a young lawyer. That could very well be.
He certainly didn't. I mean, he had to consult. He was consulting with Michael Wynn on how to do a subpoena. So there's just a lot of issues there. Okay. So here's the next question. Understanding the Senate's vote on the impeachment articles will not result in a criminal finding of anything. If an article is sustained and that article, as worded, might constitute criminal activity, what are the chances Paxton will be investigated by a prosecutor for such potential criminal activity such as bribery or abuse or misuse of office or the like? Well, my understanding is there is a federal criminal investigation into all this. There's been reporting on that, and we actually had testimony from Missy Carey talking about being called before a federal grand jury. So there is definitely a criminal investigation. Oh, somebody's emailing saying they're watching from Missouri. By the way, I have relatives in Missouri. That's where my mom and dad live. I grew up in the Houston area, but I have relatives. Most of my immediate family lives in Missouri. So let's see. Let's keep going here. Okay. Oh, okay. So that's the tweet. Jay has put up the Paxton tweet that shows he's going to go sit down with Tucker Carlson. Do you still have the Donald Trump tweet?
Yeah, give me like 5 seconds.
Now he's gonna, give Jay 5 seconds. He's our Eric and Stacy, so he's on the hunt for it. Okay, so here's another question. There are currently 16 articles on the table, 4 were withheld. If the Senate votes no to charges on 16 current, what about those 4? I don't know. I mean, they held those in abeyance, so I guess they could bring them up later. They could decide to throw them out. I think we don't really know the answer to what is going to happen with that. Okay, there it is. That is the tweet that former President Trump sent out in supporting Ken Paxton earlier this week. And so we've seen a lot of activity and support from him from that faction of the party, and from I think the head of the Republican Party also sent something out a couple days ago. I'm not going to read that question out loud. Somebody was asking about sexual allegations involving somebody else, and I'm not touching that one. Let's see. Okay, here we go. Here's the question. So the House voted to impeach Attorney General Paxton with a 121-23 vote. I'd have to go back and look to see if that's an accurate vote. But 60 of the votes in favor came from Republicans. That sounds about right. 23 Republicans were against. This is really a question for Bernadine. How significant do you think this will play with the senators? What he means is that in terms of the overwhelming number of Republicans in the House voted to impeach.
I don't think it'll play a lot. Because they're going to decide, number one, whether or not they believe it, and their own constituents. I don't think that carries any kind of bearing on the senators in terms of how they will vote.
Okay. Yeah, I tend to agree with. I think they're going to make their own decisions. And it'll be interesting. Maybe we'll know this, did some of them change their mind? Did they come in one way and they went the other way? I don't know. Or did they all just come in the way they were? And, it'd be interesting to know at some point how many of them actually had an open mind.
I think
one
we
way or the
will. Now, keep in mind that they won't necessarily comment on it until it has to be in writing. And they have a certain deadline as to when they should submit it. Unless they do some interviews or somewhat, we really won't know.
Okay, so do you want to put it up? Yeah, Jay is pulling something up for me. He just sent me something that Ken Paxton, you said he retweeted it, Jay? Is that what you're saying? Okay, well, we'll take
Today?
a listen. Yeah, so he tweeted this today. He retweeted it. It's a short clip from Busby's closing, so we're going to bring it up. Okay, this is a question related to Brent Webster and Ken Paxton taking Brandon Kamick to the Starbucks. And sorry, that whole scene still plays in my head. And I guess this will be a question for you, Stephanie. What might the legal problems be in firing a contract employee prior to the completion of a contract and claiming lack of completion to that contract as a rationale for non-payment? Is this not proof that Ken Paxton was acting in bad faith relative to the contract with Mr. Kamick? Would it not be problematic for an attorney general to act in bad faith while soliciting legal contracts on behalf of the state, keeping in mind the best interests of the people of Texas?
Well, that is all outside of my
You're a criminal
legal
attorney.
realm. Yeah.
It's way outside
and it
of
would
mine.
be very irresponsible of me to answer
That's
a legal
contract law
a
stuff.
legal question. Yeah, well, employment law, a legal question that I have no experience with.
Yeah, so we don't know. Maybe there's some contract lawyers out there watching.
Yeah, or employment lawyers.
Employment
Yeah.
lawyers. Well, we did have some employment lawyers that were emailing yesterday because I don't know the answer to that one. I mean, it can't be good, but because you had Kamick say, They took me to the Starbucks. They told me you're done, and we're not paying you the $14,000. That's what Brent Webster said. You need to eat it. But then we had testimony from, I can't remember which one of the guys it was yesterday, but from one of those AG's people that spoke yesterday, testifying that if he'd just given us a report, we would have paid him. So,
After they told them that they didn't pay.
And as Deandra said, it's like, well, why would you keep working on? Why would you keep working when you haven't been paid for?
Right. How does it get to $14,000?
Yes.
Yeah. So it was interesting. So somebody's asking about open records. They say, you mentioned earlier that you're going to use the Nate Paul treatment on the Open Records Act since this trial won't set any precedent for case law. How will you get the records you asked for? I guess what I'm saying is that, we heard from the head of the Open Records Division in terms of how they handle these things. They testified that if a law enforcement agency busts the deadline on requesting discretionary exemptions like the law enforcement exception, that it's presumed public and they're going to release it. Now, I know that is not the way they've handled my requests in the past, but I know for a fact, because I have some very good friends who also work for large media outlets, that they were also, like me, taking very close attention, paying very close attention to that testimony, and have sent that on to their lawyers, because we're all going to be going, okay, in this because we now have testimony from the AG's office saying this is how we handle requests. This is what we do. And it wouldn't surprise me to see situations play out where, this testimony and description of how open records are handled. And it's not just us that files open records requests. You file open records requests.
We file them from the police department, the different laboratories, criminal labs that handle things. Absolutely.
And what normally happens when they miss a deadline on a criminal exception?
Well,
do you get the
not
records?
much.
I know.
Do you get the records?
No. A lot of times
you don't
no.
Get the
if you don't, that's fertile ground for cross-examination, and that's something that you.
Right, but I'm just saying now the AG's office has said if you bust the deadline, if you as a police agency miss the deadline on the law enforcement exception or these discretionary exceptions, we're going to release it. Okay. I think they've set some precedent here. They testified to this in open court.
Well, they also quoted policy. So the question is whether or not they're adhering to their own policy.
You don't get to pick and choose.
Absolutely. He was just quoting policy.
Yeah, well, I don't
which
know.
is not they don't do it in practice.
Well,
apparently,
not in practice for me. I mean, and other people I know
Not for us either.
I don't know of anybody that has been on the receiving end of such a. Because in my experience and the experience of others I know who regularly use the open records process, whenever a police agency misses that deadline on claiming the law enforcement exception, they'll write a letter, and I could probably dig around in my records and find one where they'll say, we missed the deadline, but it's still in the public interest, blah 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 blah. I've seen the Dallas Police Department's form letter, and I still don't get it. So this idea that you missed this procedural deadline and we're going to release it, no, that's not the way it works. So, and I feel comfortable speaking to that because I can speak to it from personal experience, and so can you, and so most defense attorneys I know can speak to that. So, okay, so somebody's talking about the Bush family. Well, maybe this is a perfect segue into this clip, actually, this next question. Do you have the thing loaded up yet, Jay? Jay's working on it, guys. He's out there working for me. All right, this is for you because this is political, Bernadine.
I know.
This is like stump Bernadine time. We already stumped her with the contract question.
Well,
let's stump Bernadine.
Okay.
So the Bush family is painted in testimony as rhino. There's a lot of MAGA noise suggesting those senators voting to suspend General Paxton will be primaried. Please discuss this. Okay. I'm reading here, guys. These are not my questions. These are people that have emailed me. If suspended, will Donald Trump choose Ken Paxton to be his running mate?
Read that part again.
Ken
Paxton, would he choose?
So basically, they wanted to discuss two things. They want you to discuss primarying of senators that vote to get rid of Paxton, and will Donald Trump pick Ken Paxton to be his running mate? What's the chances of that?
Well, I think I'll go back to, you had a similar question in terms of President Trump bringing him into his administration, but I don't think that he would choose him as a running mate. He has too much baggage. Okay, and then secondly, when they mentioned the Bush family, by today's standards, they would be considered rhinos because they were not as ultra conservative as most of your grassroots or your primary voters are today. But when I was listening to Busby say that, I'm like, I don't know a lot of, while you do have a lot of the grassroots, and keep in mind he was talking not only to those senators, but to the grassroots as well who do think that the Bushes are past their prime. But I kept thinking, but they don't hate them. They have a lot of respect for Bushes. It's just that they're not part of the political narrative and the political regime now.
You got that ready for us now, Jay? We've put the perfect segue for it.
A minute and 21 seconds.
All right, he's still loading it up. Technology, the bane of our existence. It takes a little bit of time to load, because what it is there's a tweet that Paxton sent out, and he grabbed a little bit of Busby's. Well, no, he didn't send the tweet out. There was a tweet that went out, and Paxton tweeted it out, and it's a little clip from Busby's closing. So that's what we're trying to load up into the. I know somebody's telling me to tell Eric to rush that video. I'm trying, guys. I mean, it's like technology.
I really would like to see that before I comment because it reminds me. Well, maybe I need to see it, but it reminds me of when the House was discussing impeachment, and Ken Paxton was calling into those House representatives, threatening and talking. And
do you think that worked against him?
Absolutely. Well, they said they were offended. They were offended that he was actually calling them, trying to put pressure on them as to how they voted. And then let's look at. Really, I'm glad you brought this tweet up because it would make me wonder if how active he is while they're going through this decision of whether or not he leaves the. Eric.
We're waiting on Eric. Jay, our personal Eric over here, who's working on. He's working on it. Before this is all over with, I feel like you'll have to meet Jay because he's been wonderful. He is behind the scenes making sure everything. He's loading up the videos and loading up graphics and doing all kinds of stuff for us because he's the one that's over there making us look smart.
Like Eric was with the house.
Eric was the defense.
Yeah,
Eric is the defense side. Stacy is the prosecution.
Yeah, that's why I said because everybody knew his name by the time the trial was over.
Well, there was like a GoFundMe started.
Yeah, and then everybody would know Jay by the time.
Okay, you got it? Okay.
Oh,
all right, he's got it.
Yeah.
Do you have an earpiece? Okay, so I can talk over it.
Yes.
Okay. There's no audio. This is what he's grabbed is the whole thing where Busby had talked about the Bush regime. Let's see. I have to go back in my notes to find out exactly what Busby said about the Bush regime. He said, I'm digging back in my notes.
He said it's the end of the
the end of the era,
the end of the Bush era.
I'm digging around. Yeah, he basically said, this is the end of the era. Oh, okay, here we go. The Bush era in Texas ends today. That's what Busby said. And he's also said he beat the latest in line for the Bushes, referring to George P. Bush.
Yeah, so I guess he's implying that those who impeached him preferred the Bush.
Right.
So now he's saying, hey, if you don't sustain these, then that Bush. It's over. The voters have spoken. Okay, now I understand.
Okay, but that's what he retweeted. So, okay, or re-xed, or I can't even begin to remember exactly what the terminology is these days. I know it's not technically Twitter anymore, but
X,
X, whatever. If Ken Paxton, here's the next question: if Ken Paxton is acquitted, could the FBI investigation of Paxton use the information presented by the House to indict Paxton? Well, whether or not they'll indict him, I don't know. But I will say this. They will absolutely be combing through every single word and parsing through it. Because, wouldn't you say that, Stephanie?
Oh, yeah, definitely. Any kind of, they've started their impeachment file. I'm probably sure they've been working on that for a while. But yeah, they definitely have some more stuff to add from this proceeding.
So, I'm going to read this one to you because I don't know how to answer it. You're the political person. One Texas senator represents approximately 920,000 Texans. If 10 senators vote not to impeach, they'll be representative of approximately 9.2 million Texans out of 29 million. Does the panel feel this is a representation or misrepresentation of the people?
Well, that's assuming that all those people are in favor of sustaining or not sustaining. I think that I know that the defense regularly said that if you sustain the orders that you're going against the voters of those 3 million who voted for him, but I couldn't say that everybody in that number supports sustaining or not.
Yeah, I mean each this is a process laid out in the Constitution. So they're following the Constitution at this point.
Yeah, and then, there's no way of knowing that.
So somebody asked about the motion to combine the impeachment action with the action of barring from taking office. My understanding is what Bud said earlier, they withdrew that. So
they withdrew it, but you know what, I was talking about that earlier.
Yeah.
Because it was very interesting that according to the prosecution, in the Constitution, they're not separated. But the House, the Senate decided to separate them. And I was looking at that as perhaps that could be a compromise, a vehicle, because they could vote, the senators could vote to sustain, but not vote to sustain that he couldn't run again. So conceivably, he could get removed now, but still run for another office, or even run for AG.
Yep. Okay. Whew. Folks out there are asking lots of questions. And if you want to send me questions, it's teiserer@wfa.com. And at some point at the end of this trial, I've got to go clean out my email because it's getting out of control. Okay, so somebody's asking, why is Lieutenant Governor Patrick, who is not a lawyer, conducting this trial? Why was this case not tried before the Texas Supreme Court? Well, this is the way the Texas Constitution lays it out. And so, but he made the right decision in getting Lana Myers to help him. And Stephanie, you know her, so
yes.
Talk to me a little bit about her.
Yes, she is a longtime judge. Before she was ascended to the high court, she was a state district judge here in Dallas County. Above reproach, as I stated earlier, very much a rule follower, very thorough. We used to have a joke in the courthouse. If you had to do a plea in Lana Myers Court, that was going to be one of two things you were going to get done that morning, because she was very, very thorough. She ran her courtroom in a very orderly fashion. She had the great qualities that you think about in a judge. You knew what her positions were on certain types of cases. She followed the law, very knowledgeable about the law, and a very good steward of the law, in that she would keep up with everything. Cases, amendments, changes. She was just a very, very conscientious jurist. So when I saw that she was going to be helping Lieutenant Governor Patrick, I thought, wow, that was an excellent choice, because you want somebody who is going to be able to train you well, because they're a good teacher, and like I said, they're a good steward of the law. So that was wonderful. I mean, they could not have had a better person to preside over something that is unprecedented, because I know that she probably stayed up at night studying and utilizing all the materials she had at her disposal.
A clinic. It was like a law school clinic there.
It was. He said that. He said he went to judge boot camp, which I believe. You know, she was a good drill sergeant to have, because she's a wonderful judge. Great, like I said, always on time, always concise in her rulings, would make decisions, and would follow the law.
And you know what, Tanya, I think that Lieutenant Governor, who happens to be the judge / presiding officer in this case, had every intention and tried awfully hard to do a good job.
I thought he did great.
You know, yes. I do too, and I think that was his, you know, he wanted to come across as fair. He wanted to come across as at least doing the best he could, because he said up front, I am neither a lawyer nor a judge, but I will try to do my best. And then, as Stephanie said, he brought on someone who's very well qualified.
Yeah, and he, you know, even when it was funny, because sometimes he would allow hearsay in when he shouldn't have, and sometimes vice versa. But he always felt like he genuinely was trying to do the right thing.
Sure
and
was.
So I just feel like overall he did the best he could and did a good job.
And I think that the defense and the prosecution sort of understood it and just moved on.
Okay, so how soon will there be a book, and who will be the first to write it? Well, I don't know, but I bet there will be, and it will not be me, because I don't have time to write a book. So
I think they're talking about the witnesses. I would hope that Laura Olson's going to be the one on the top of the bestseller list.
I don't know, but she took the fifth. Well, she didn't take the fifth. Let me rephrase that. So she I don't know.
Well, she did.
Well, no, she
didn't
did
take it on the stage.
Well, we don't know.
Okay, according to what the street said. But anyway, but you know what? As I said early on, you can look for a movie. Now, possibly a book prior to, you know, because the producers generally need a script. So they could go with a book, but you're going to see this in a different type of setting. And I could almost bet, if I had investment money, I would invest in a movie.
Mm-hmm.
Okay.
Miniseries, docuseries.
Oh, somebody's going to write something. There will definitely be a book. Okay, so somebody's asking about Brent Webster, the current first assistant. No, he was not called. And Busby, as this person mentioned, you know, basically said, why didn't the prosecution call Brent Webster? And then, of course, the real question is, well, why didn't the defense call him? You know, because why would the prosecution have called Brent Webster? That wouldn't make any sense.
You know what? That is so true. That is so. That's just like the defense is just throwing things out there to have you question something.
Okay, we're going to do one more question, and then Jay says we should take a break. So, and then we'll go back to the Brandon Kamek. We'll go back to the Brandon Kamek cross. Or not cross, direct. Okay, so this person asked, did I hear correctly that Brandon Kamek subpoenaed Ken Paxton's prosecutors? No, he didn't. It wasn't the prosecutors. There was a whole bunch of people on this list, and there was I think there was somebody from the securities board and an investigator, and so it wasn't the prosecutors. But there was just Brandon Kamek was given a list of a bunch of people he should subpoena, and there was some people related to the securities board on it. Okay. Okay, so what was the count in the House? You know what? I better go double check that before
I think it was that 120.
I'm going to go double check that because that's count in the House.
Wasn't it 123?
All right, I'm looking, guys, because I don't remember. I remember that it. Okay. I'm looking. I'm pulling up. Okay, here we go. The House voted 121 to 23. That's what it was, and of course it was the overwhelming majority. So that answers that question. Okay, so here's what we're going to do. We're going to go back. We're going to take a break because we've been talking a lot, and I still got a lot of questions you guys have been sending me. You can keep sending them. It's actually easier if you send like shorter, because the longer you make your email, like my eyes, I'm really tired, to be honest with you, because it's been a long week, and so kind of the shorter your email, maybe the better, because I get lost in a lot of stuff. But anyway, my email is teiserer@wfaa.com. All right, so we're going to go back to testimony from Brandon Kamek.
With him.
Well, what do you mean?
Well, do you recall what the email address was?
No, sir.
Was it an official Attorney General's office email address?
Oh, I see what you mean. No, sir.
All right. What was it?
His email address was a Proton mail address.
All right.
That I was given.
Had you used Proton before?
No, sir.
Had you ever heard of Proton?
I had heard of it. I've never used it.
Okay. Now, in addition, what about the phones? What type of phone number did you have that you would communicate with him?
I had the original number that he had first called me on, and then I think later he gave me another number. Around that time, I was getting calls from unknown numbers, or it'd say potential spam. You know, you get those types of calls, and I was like, well, I don't want to miss the Attorney General's number, so I got myself a separate number and gave it to him. That way I knew when that phone rang, that was Mr. Paxton calling.
So are you saying that you ultimately got a phone that was totally dedicated to phone conversations with the Attorney General of the state of Texas, and that's the only number that you communicated with on that phone?
Yes, sir.
And you did that, why?
Because I didn't want to miss a call from an unknown number or a spam likely call, or, when you get those spam calls, I didn't want to have that come up and miss an important call. So
did he use multiple phone numbers with you?
Yes, sir.
How many?
2 numbers.
Okay. And were either of those official Attorney General lines?
I believe they were cell phone numbers. I don't believe they were office numbers.
Right. In fact, when was the first time that you ever learned what the official email address or the Attorney General office email address was of the Attorney General that you were dealing with all this time?
The first time that I ever saw his governmental email address was when I got a cease and desist letter from Jeff Mateer.
And when was that?
That would have been, I believe, August 1st or 2nd.
And how was it that you saw what the Attorney General's official email address was?
They were all copied on the email. All the gentlemen, Mr.
Mr. Vassar, I think, was one of them. And
was that first time when you got your cease and desist letter, the first time you ever knew of any official communication form of communicating with the Attorney General, whether it was through text or email or phone?
I thought all of my communications with him were official, but that was the first time that I saw his governmental email address.
All right.
Yes, sir.
Now, did you trust the Attorney General?
Yes, sir.
Were you flattered about him reaching out to you?
Yes, sir.
Did you trust Michael Wynn?
Yes, sir.
Did you appreciate him referring you to the Attorney General?
I did. Yes, sir.
Okay. And did you always trust Michael Wynn to have your best interest at heart and try to help you?
Yes, sir. I didn't have any reason not to trust him. I knew that he was Nate Paul's lawyer.
Okay. Did you trust Nate Paul?
Didn't really know Nate Paul. I just was trying to do my job.
All right. Now let's move to the period of the middle of September. After you came back, you had all your material from the 4th that you had gotten from Nate Paul. What did you do after that?
So around this time, I had a conversation with Mr. Paxton because I wanted to try to get the individuals named in that first referral, like call logs and email logs showing whether or not these people had been talking around the time that the search had taken place. And so, being that it's sensitive, since they are federal agents and there's some people in power there, I thought that the grand jury subpoena would be a discreet way to get that information. And so I brought that up to Mr. Paxton.
And do you recall when this conversation was?
I believe it was around, we had talked about it from early on in the month, like within that first week of September, but the conversations kind of continued going on until about the middle of the month, about September 14th.
Okay. Now, at that time, what did you say to Mr. Paxton, and what did he say to you?
I told him I think we should try to do a grand jury subpoenas, being that this is a discreet way to get information. Grand jury proceedings are private and secret proceedings, and so we'd be able to get information that way without raising any kind of alarms or causing some type of, panic about the situation. And he said it was a smart idea.
So he endorsed it?
Yes, sir.
Did either of you talk about the fact that if you issued grand jury subpoenas for a claimed offense that Mr. Paul was presenting to you, that the recipients of those grand jury subpoenas would know what was going on, or have questions, or be maybe even alarmed? Did y'all discuss that at all?
Excuse me, objection leading.
I think I gave him several choices. Did y'all talk about the possible reaction of people that got these subpoenas?
No, sir.
Later you issued subpoenas, did you not, for credit unions and banks and stuff like that, correct?
Yes, sir.
Was there any conversation between you and the Attorney General about how those people might feel when they got those grand juries?
No, sir.
Did you become later aware, we'll get to who all that were on there, of that some of these subpoenas were going to lawyers or people that were opposing Mr. Paul in litigation? Were you aware that that's who some of the people were?
No, sir.
Okay, well then let's get to what you know. When you talked to the Attorney General back about downloading the app and everything, were you also talking to him at that time about trying to seek credentials and other types of things that you needed for what you were doing?
Yes, sir.
When did you first start asking for those types of things?
In my first meeting with him on September 4th, and then I asked about it again, like as I'm approaching the time where I need to be, as the time I'm doing the applications for these subpoenas.
What did you ask him for?
Email address. Am I going to get some type of badge or some credentials? Because I'm going to be approaching people with legal documents, and I need something to show that I have the authority to do that.
What did he say?
We're working on it.
Now, you assumed, did you not, that of course it'd be perfectly fine to give you those things because it would be a public record and there was nothing wrong with it, correct?
I expected to get that.
Yes. And you expected and believed you were going to need that, did you not, in your investigation?
Yes, and I ended up, I did need it.
How many times do you think you asked the Attorney General for these official documents?
It would have had been 4 or 5 times over the course of a month.
And each time you asked him for him, what was his response?
We're working on it. We'll get it to you.
At some time, did you begin to wonder why they would not give you any kind of official documents to show your status?
No. I don't know how the office operates within the Attorney General's office. I wasn't sure if there was a bunch of red tape to go through. I didn't know any of that. I just knew that I would need it to do what he was asking me to do.
Right. We always hear about the slowness of bureaucracy and government agencies. Is that the kind of thing you just thought was going on?
Yes, sir.
Okay. So it never occurred to you that maybe he didn't want them to be public?
Objection, leading and assuming facts not on evidence.
Sustained.
Did it ever occur to you? Did you ever have the thought, a wonder, don't they want this public or what? Did you have that kind of thought process?
I wasn't thinking about anything like that.
Fair enough. Now, when you mentioned the grand jury possibility to the Attorney General, in that conversation, and you think that conversation was when, roughly?
That would have been around I know I spoke with him about it on September 6th. So I have a note here on this invoice, but the middle of the month around September 14th.
Okay.
There were a couple conversations where I was just kind of trying to figure my way through this.
Now, you, of course, as you mentioned before, had never done a grand jury investigation, correct?
That is correct.
So did you ask him some questions, the Attorney General, some questions to try to help you in that respect? First of all, did you assume that maybe he would know these kind of answers?
Yes, sir. I am so sorry. Judge, is there any way I can use a restroom break?
We'll stand at ease for 10 minutes.
Sorry about that.
No, we'll give you 10 minutes. The witness may step down.
Thank you, Judge.
Okay.
Thanks, Judge.
Thank you very much.
I would just stand at your desk, George. I would not leave. He's just stepping out and coming right back. Mr. Harden, you may resume.
Thank you, Your Honor. All right, Mr. Kamek, I want to go to, if I may, when you were asking him and talking to him about the grand jury subpoenas. During that conversation, and you mentioned that you asked him about credentials. How did you go about trying to find out how to do a grand jury issuing and using grand jury subpoenas? What did you do? Your microphone.
Yes, sir. So I asked Mr. Paxton, it's at this point, he's like, this is a smart idea. This is the way that we should proceed. So the next question is, okay, well, how do we do this? Because I wasn't sure whether the Attorney General's office had their own special grand jury in session for cases, or if we would do it through county, like Travis County grand jury. And so I didn't know the answer to that. He said he didn't know the answer to that. He would need to find out. And, I think he had indicated to me at that time, he wasn't a criminal lawyer. Most of his experience was in business law. So he would find out which grand jury that we would.
How did you find out?
He reached back out to me around the middle of the month, maybe a day or so after, and told me that we would be going through the Travis County grand jury.
But the AG himself called you back and told you that?
Yes, sir.
And then what did you do?
So my next step was to reach out to Travis County District Attorney's Office. And it was kind of weird because before I even have an opportunity to do that, I get a message or a voicemail that Michael Wynn had sent me saying, this is the person that you need to contact over there.
How soon after you had the conversation with the Attorney General that concerning the fact that it would be a Travis County grand jury. How soon after that conversation with the Attorney General did Mr. Wynn reach out and give you a contact in the Travis County DA's office?
I don't recall exactly, probably within 24 to 48 hours.
Do you have any idea how Mr. Wynn would have known that you were seeking that information?
Well, I'm sorry.
Had you told Mr. Wynn you were trying to find out, or did it just come in unsolicited?
No, I spoke with Mr. Wynn about the grand jury process.
All right.
So he was aware. Him and Nate Paul were both aware that that's how I was proceeding with their investigation.
When you got that information, did you reach out to the Travis County grand jury?
I reached out to the Travis County District Attorney's Office and spoke.
Excuse me. I said grand jury. You're right. The office. Excuse me. Go ahead.
I spoke with. I forget. It's a nice woman. I forget her name. She put me in touch with a gentleman named Don Clemmer. And then Don Clemmer put me in touch with, I guess, this real sweet lady. I think her name was Bailey. She might have been the grand jury coordinator over there.
Let me ask you this. Was it last name Mulder? Does that sound?
That sounds like.
All right. Did you tell these folks that you were a special prosecutor working with the Attorney General's office?
Yes, sir.
Okay. And as such, you were asking assistance to get some grand jury subpoenas?
Yes, sir.
And did they help you get the grand jury subpoenas?
Yes, sir, they did.
And let me ask you, at this time, Your Honor, I want to move to introduce en masse, I believe we informed counsel on the other side, Exhibit 257, which I'll represent as all of Mr. Kamak's production in this matter to both sides. These are the documents that he has produced to lawyers on both sides, and I move to introduce them in toto.
Any objection? Speak on the microphone, please. Still can't hear you.
Object to 649, 691.
Dan, can I stop you for just a second to explain to the court? We have given them excerpts so that it was too voluminous to be carrying around the hard document here. But what we did do, about 2,000 pages, I think it was a lot. What we've then I've gone through and taken out excerpts and put an exhibit number on them. But there are excerpts from what I was seeking to do was introducing the whole group and then taking out and putting an exhibit number on those that we specifically were going to talk about. Go ahead.
I appreciate all that, Mr. President, but to be clear, we got an amended exhibit at 4:50 this morning, which includes these, several of which I will be objecting to, several of which I won't.
Excuse me, are we going to start getting into when we get stuff for them and what time of the morning? I would just ask for
just stop right now.
Yeah.
You would, like I started to say, object to 649, 691, 687, 688, 689, 690, 686, and 650.
Reason for the objection?
Sir?
You objected to those documents, okay?
I am. Now, okay. I do not have objections to 677, 678, 679, 680, 681, 682, 683, 684, 685, and 693. The last sequence, Mr. President, I do not have an objection to.
So let's go back to the objection.
Yes, sir.
I'd asked you for a reason for the objection to the
yes, sir.
Other documents.
Yes, sir. The basis is hearsay on each. And just so, let me try to get them in order so Mr. Hardin and I can literally be on the same page.
ask one more time real quickly the ones you object to, Dan?
Sure.
To make sure I got all of them.
Yes, sir. The ones I'm objecting to are in order, Rusty, are 649. That's the work product. If you're with me, you want me to come over there? I'm happy to do that, if that's easier for you.
No, go ahead.
649, 650, 686, 687, 689, 690, and 691.
And the type of objection, Your Honor, the basis?
Hearsay. And I don't know if you, Judge, Mr. President, do you have them in front of you?
We don't have them.
May I do this? Let me go right now to discuss the ones that he has no objection to and ask that they be admitted.
Sure.
Okay, we'll admit the items that you have no objection to, and to be certain we have those right numbers, would you repeat those numbers that you do not object to?
The numbers that and I'm not sure these are in order, but 677, no objection.
Okay.
678, no objection. 680, 681, 682,
yes.
683,
yes.
684,
yes.
685,
yes.
And 693.
What about 679?
All right.
Hold on 1 second. Just checking this.
You inquired on 679. I don't have that one in front of me.
Okay, you originally said you had no objection to 679, but you may have misspoken.
Certainly capable of doing that. No, you're correct, Mr. President. 679, we do object to 679.
Okay, so 679. So to the court reporter, and forgive my for a moment there, something I said the witnesses shouldn't do. So to be clear, to the court reporter, no objection to 677, 678, 680, 681, 682, 683, 684, 685, 693. And it's my understanding, Mr. Hardin, to begin, you will just focus on those. And if you want to refer to the others, you'll have to give us an answer on why it's not hearsay at that time.
That's correct. Your time, could I?
I'm admitting, so we are admitting into evidence 677, 678, 679, 680. I'm sorry, 677, 678, not 679 at this time. 680, 681, 682, 683, 684, 685, and 693.
Your Honor, can I have 10 minutes credit back because of the housekeeping we did here?
Did you say you needed 10 minutes?
Could I have 10 minutes credit back for the conversation we've had?
I'll give you 5.
Thanks.
All right.
All right. One has to take what they can get. All right. Mr. Kamek,
yes, sir.
Did you start receiving assistance to get these grand jury subpoenas done as to who they would be from Mr. Wynn?
Yes, sir.
And is it still on? I didn't hear. Yeah.
Can you hear me?
Yes.
Okay.
Yeah. All right. And what form of assistance were you getting from him?
Well, I started to get a lot of information from Mr. Paul and Mr. Wynn through emails. That included the list of individuals who were, I guess, suspects or somehow witnesses or somehow related to that first initial referral.
And were these people that were to be put on the list of subpoenas?
Some of them were, yes, sir.
All right. And were you receiving from Mr. Wynn regularly information of people to include on the grand jury subpoenas?
Yes, sir.
Now, what was your thought process in terms of your investigation as to why you would automatically put those people on if they're asking? In your mind, you were doing what?
Well, I didn't independently source any of these individuals' name. I walk into this referral, and I'm given a lot of information about different people who were involved and how they may be related to that first referral. And so I trusted that was the information that they were giving me was the same information that the Attorney General's office, Mr. Penley, would have already had to conduct his investigation.
All right, so you assume that you were just getting information that already existed?
Yes, sir.
In the hands of the the AG?
Yes, sir.
But you hadn't talked to anyone in the AG, correct?
Other than Mr. Paxton, that's correct.
All right. And each time that you had a course of action in this case and thought you were going to do something, did you have a practice of contacting the Attorney General to update him?
Yes, sir.
And so as you went along and gathered all this information from Mr. Wynn and Mr. Paul, were you keeping the Attorney General informed of all this?
Yes, sir. I would discuss it on the phone, or anytime I got like a document emailed to me from Mr. Wynn, I would forward that on to the Attorney General's email address. And then when we spoke again, if we did, I would say, hey, I sent you this or sent you that.
So let me see if I understand. Whenever you received information from Mr. Wynn and or Mr. Paul by email, you would then forward that information to the Attorney General?
The majority of the time, yes, sir.
All right. So when they were sending you a list of people that should be subpoenaed by the grand jury, were you making sure you kept Mr. Paxton informed of that?
I'm sorry, do you mean if I sent that information to him, or just letting him know that I received that information, or?
Just letting him know that you received that information.
Yes, sir.
All right. So would it be an accurate statement that as you proceeded in this, well, let me put it another way. As you proceeded in your investigation, and as you determined what to do with the grand jury and what to do about grand jury subpoenas, were you at each stage keeping the Attorney General informed?
Yes, sir.
At any time, did the Attorney General contact you and say, no, let's don't do that?
No, sir.
So from your own state of mind, in every single thing you did in this investigation, what is your testimony to the jury as to whether you believed you had the full support and agreement of the Attorney General of the state of Texas?
That's true. I did everything at his supervision, kept him informed on everything. When I reached out to Travis County District Attorney's Office and introduced myself regarding the grand jury subpoenas, I got affirmation the entire time that everything was good, and no one said anything different until I, got a cease and desist letter at the end of.
And so it was one of your frustrations that you didn't have anything official to tell people that's what you were doing. Is that correct?
That's right.
Excuse me. Objection leading.
I'm sorry.
Well,
sustain.
Were you frustrated about not having any identification and documents and means to tell others in this outside world?
Yes, because yes, sir.
All right. And what was the reason? What was the reason for being so frustrated?
For example, when I had some subpoenas issued for Microsoft, and I got an email back saying, without a governmental email address, we can't execute these subpoenas. So I knew that as I'm continuing to work in the course of this deal, that I would need to have some type of identification, whether it's a governmental email address, some number. I don't know what their processes are, but I knew that I would need some type of credential to be able to do what I was asked to do.
What were you subpoenaing Microsoft for?
Email records, I believe, for certain individuals that were involved in that first referral.
All right. So in the first referral, you were seeking email information, everything from Microsoft about all of these individuals?
Whoever had an Outlook email address.
And in addition to the people involved in the execution of the search warrant, were you receiving from Mr. Wynn other names that should be added in?
I don't recall all of the names that were on the list.
Oh, yeah, I'm not asking you what the names were, but were you receiving, during this time that you were conducting an investigation, continued list and suggestions of people to investigate and to list a grand jury subpoena for?
Yes, sir.
And at this stage, did you reach a stage of discomfort that you were getting all this information from the lawyer of a man that you knew was already under investigation by law enforcement?
I didn't know that Mr. Paul was under investigation at the time. I knew about the search, obviously, but I didn't know that he was under any kind of, at the time it would have been a current investigation. And then just with respect to Michael Wynn, I had no reason not to trust that Michael was giving me information that he had already collected and that I thought that the Attorney General's office already had. So I thought that whatever he gave me was for the purposes of investigating that referral.
Okay, I want you to look. I'll put some hard copies up there for you. It's in evidence now. Exhibit 678.
678.
And it's going to be bait stamp. Well, do you need a bait stamp? No. Okay, thank you. Can you tell us what that is, please?
So this is an email that I sent to Ryan Vassar with this is the same day that I met with Mr. Paxton on 9/4, and when I got back home, I signed the draft contract that they sent me and sent it back, and I asked for an executed copy back. Mr. Vassar had asked me to see if there were any kind of conflicts, so I reached out. I didn't have any clients that had any cases pending where the AG's office was opposing counsel, and I reached out to the State Bar Ethics Hotline and said, hey, is this okay? You know, I don't have any cases pending against them, and they said, it's fine, you know, congratulations on the job.
All right. I'm trying to look at these subpoenas in terms of what's admitted, and I want you, if you would, to turn to 681. I'm only going to ask you to not put it up because I believe that's one that is one that's in evidence. Can you help me out? Look at 681. And identify this for the jury, please.
So this was an email from me to Michael Wynn, and it says sample form grand jury, Google grand jury subpoena.
All right. And then look over to why did you send it to Michael Wynn?
Michael Wynn had initially, so I had never issued a grand jury subpoena before.
Pardon me?
I had never issued a grand jury subpoena before.
Right.
And so I asked Michael, once I put this draft together, if you take a look at it, it's the same information that they had already given me, and make sure that the form here is correct.
And so Mr. Wynn respond to you and tell you it was okay?
He said, form is fine.
And then at the end of the day, what did that help you do?
What did it help me do?
Yes. Did that help you decide how you were going to do the subpoenas and what language you were going to use and everything?
I sent this to him. I mean, I knew he was a federal prosecutor at this point in the past, you know, Harvard educated. I just sent it to him does the form look okay here? So it helped me to know that this was the right way to do it.
All right. Your Honor, I'm looking here. I was having to order up the ones they've objected to, and there are some of these that I very much want to get into evidence, and I don't believe there is a legitimate objection. I'm trying to figure out how to handle this without taking any undue time now. But for instance, if I could, do we have hard copies for the court, Stella? of these exhibits? Do we have any more stacks? Do you have before you 691 without saying anything about what is in context? I want you to identify it for the record and tell us what it is.
Mr. Hardin, you said 691?
Yes. I wrote that down as one you objected to.
I don't have a 6. Oh, I do too. I stand corrected. Thank you.
We have that on the list you objected to, correct?
Yes, sir. I'm sorry.
Well, we're waiting for us to see it. We don't have a copy before we can rule.
Yes, sir.
All right. You see 691, would you, without talking about the internal contents yet, would you describe what that document is?
This was an email from Michael Wynn on September 21st, 2020, with an attached Excel spreadsheet that appears to have individuals' names listed there with various demographic information.
Does it list names, addresses, and identifying data that have been blacked out for purposes of this exhibit? But does it list names, addresses, and personal data of people to be investigated and included on the grand jury subpoena?
Yes, sir.
All right. I don't understand what the objection was to that, Your Honor.
Go
ahead, I'm sorry.
The objection is hearsay. It's not a list created by Mr. Kamek, but by Mr. Wynn, and it is being offered for the truth of the matter asserted because they're going to...
Your Honor, go ahead. I'm excused if you were talking. No, I thought you were through. Go ahead.
That's okay. It is going to be offered for the truth of the matter asserted because they're going to be arguing that these were the names ultimately where subpoenas were being used on. So objection, hearsay.
There are a series of these, Your Honor, that first of all, not offered for the truth of the matter, only that it was provided to them. We are not suggesting that these people should be and were witnesses for the grand jury, should have been a grand jury subpoena. But the more important part is, Article 16 is a conspiracy article that says that General Paxton engaged in conspiracy with others. We are not alleging that they engaged in this conspiracy with Mr. Kamek. We are alleging that he engaged in a conspiracy with Mr. Paul and Mr. Wynn. And any statements that are made in pursuant of that conspiracy would be admissible, whether or not it is hearsay. It's an exception to the hearsay rule. I know I am springing that on the court. You might want a moment to think about it or so, but that's why, A, it's not hearsay, but B, even it it is an act in furtherance of the conspiracy.
They are admissible through the testimony of a co-conspirator, not through Mr. Kamek, who Mr. Hardin admits is not a co-conspirator.
Give us a moment.
Pardon me? Okay.
And just, Judge, Mr. President, while you're considering this, I would, based upon Mr. Hardin's argument for the admissibility of it, there is no suggestion that General Paxton created or participated in the creation or the assimilation of this exhibit.
Okay, give us a moment.
Okay, I'm Tanya Iser, an investigative reporter here at Channel 8. We're back from a break. I'm joined by Bernadine Steptoe, our WFA senior political producer, and Stephanie Alvarado, who's our legal expert today. And I have promised I will keep going through these questions that folks have been emailing me, and I have got a whole bunch of them. So I think this is probably for you, Bernadine.
Okay.
This person's assuming the Senate won't sustain any articles. How do you think the voters will vote in Paxton's next re-election?
Well, we're primarily talking about the primary. I'm sure that's what the writer is alluding to. Well, you must remember the last election he only won during a runoff. So if I think he's going to get, you know what, to be honest with you, I'm not real sure.
Well, it's also re-election is several years from now, which is an eternity.
I understand, but if what his supporters are threatening, that we have short memories, long memories, that we won't forget, that they might turn out to ensure that he is elected. But I think that it's going to have a lot to do with who his opponents are in the primary. But remember, there's a short memory and a long memory in politics. Mm-hmm. And you also have the voucher issue that's coming up in October. So that's going to sort of change the focus from trying to stay mad about Paxton to trying to get the voucher program pushed through. So as of today, I wouldn't predict any way or the other.
Okay, so Jason Wheeler has a question. He texted me his question. I'm not going to say my cell phone on a live stream though. I'm afraid my phone would just blow up. He's curious of theories on who it benefits more the longer a jury is out. I'm going to let
That is a good question, and there's a lot of lore that goes along with that question. It used to be, when I was a young lawyer back in 1996, the school of thought used to be, if it comes back quick, that's not good for the defense. That means they have decided quickly to find the defendant guilty. Nowadays, you just really can't tell, and this is not your typical trial either, so I certainly would be remiss to try to speculate, but typically, plain vanilla trial, it's a school of thought that the faster they come back, the worse it is for you. We as defense attorneys hope it's taking a long time because there's a holdout or two, or maybe it's split back there and they're sticking to their guns like we asked them to do. But in this situation, with this not being your typical plain vanilla trial, I don't know. I would be, like I said, I would not even want to speculate.
Yeah, and it's not like at a normal trial where you got to have 12 people agree.
Correct. There's no unanimity required. That's true.
There's just we got to reach this threshold one way or the other. So somebody's asking about the litmus test in the Senate is beyond a reasonable doubt. What was the litmus test in the House impeachment vote? The best description I can give on that is like a grand jury, right? I mean that it's a grand jury indicts believing there's
probable cause for the case to be held over for trial.
It was a little bit like an indictment, for want of a better word.
Yes.
And so, with an indictment, you don't have to quote unquote prove the case. That's why you have a trial, which is what we've had. Somebody's asking if he's convicted, is there an appeals process?
No.
I mean, if he is removed, he is removed.
And you know what? And let me bring this point up too. Which we don't know how they vote in a real jury, real trial, but they're not. Once they cast that vote in the chamber, they're not allowed to change it.
Really?
Once they cast it, they have to move on. They can't change it, which makes a lot of sense because if you like on a city council vote. If you vote and then see that vote is going a certain way, you can switch your vote and go with the vote so that you can bring it back up. But in this instance, once you cast that vote, you're done.
I'm sending this question to Bud because I don't know that I know the answer to it, and I don't want to read it aloud. So I'm going to see if maybe he knows the answer because I don't know the answer to that one. Somebody's asking, do I think there were concessions made to Laura Olson being unavailable to testify? I mean, we don't really know exactly. We don't. I mean, anything that we say about that really is speculation. We really don't know. We just know that that she came. We thought she was going to testify, and then she didn't. And all they said for sure was that she was present but unavailable to testify.
Well, and remember, one of the senators stood up and asked, what does that mean? And Patrick said, it means what I just said, that
he didn't
both sides agreed with it, And this is what it is.
Yeah, let's. Jay is going to play that audio, that exchange. How long is it going to take you to do it? 20 seconds. Okay, we're looking at a video of Laura Olson the day that she arrived to testify, and they announced that she would testify, and then there was this waiting period, and then we learned late in the afternoon that she was not going to testify. So that was a very interesting day. A lot of things happened that day that we did not expect, including Rusty Hardin seemingly resting without meaning to. At least, I mean, I think he planned to rest, but maybe not right at that moment. Or maybe he faked us out and he meant to do it, but he wanted us to think he didn't meant to do it. What do you think?
Could be.
I mean, because was it a fake out? Could it have been a fake out?
I don't know.
But if you believe him, though, he said it was a mistake.
I think it was.
Yeah, he said it was a mistake.
What y'all thinking? They're gonna finish today?
I don't know. Somebody's asking me in the room if we think they're going to finish. I have no idea. I mean, my gut says they will, but I don't know. Yeah. Okay, so next question. So somebody's asking if they convict on one or they sustain on one of them, do they have to continue voting? They when they come up to vote, they vote on all of them, right? So I mean, they vote on. They
vote on each one.
They vote on each one. I mean, I would think they would continue. I don't know why they wouldn't. Yeah, they'll
according
continue.
to the rules, they have to vote on each one.
Yeah.
And then if one is sustained, then he will be removed, but they keep going.
You got it? Jay is gonna play that audio for us.
Mr. President, we call Laura Olson to this.
Laura Olson, the bailiff will bring Laura Olson. The House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify. The statement has been made by the court. It says what it means. Both sides have agreed to that statement. Both statements have agreed to that statement.
And that senator that we saw standing up, that's actually Nathan Johnson, who's a Dallas senator. So that's one of our local senators who clearly was questioning what happened, because obviously I think they were also expecting her testimony and were a little surprised by the outcome. So this person's asking, while in deliberation, are political parties allowed to caucus and arrive at group decisions? I mean, there's nothing in the rules that say really what they can and can't do in deliberations other than they have to be in the room together.
Yeah, but remember, Patrick said it's an individual vote.
It's true, but there's going to be some kind of deliberations.
Oh, we don't know what they're talking about.
We just don't know. I mean, what's going on in that room is anybody's guess at this point. We haven't heard any word. I mean, maybe later on after, things come out, we'll hear some sense of what happens. Okay, so who takes the Attorney General's position if the articles are sustained?
Remember, Abbott has already appointed his I think chief of staff unit, and it stays there until he either appoints someone else or his term runs out or he calls a special election.
Yeah, and I know and I'm going to be honest, guys, I don't know all the rules on that. So, but I would have to look that one up. Did the Senate jurors set the rules? Can they now vote to change them? No. Well, they did set the rules, but they're not going to vote to change them because now they're in deliberations. Yes. There'd be no reason to do that. I don't think they could change them at this late in the game anyway. Let's keep going here. Somebody says, did you notice that Dan Patrick, who got his start in talk radio, did not include listening to the radio in his list of media injunctions when the senators were released to start their deliberations? I didn't notice that, but even so, I don't think he meant anything by it, one way or the other. Okay, so here's a question for Stephanie. Can you plead the Fifth when matters are not illegal?
No, because the short answer is no. Because the answer, you can only assert the Fifth Amendment, your constitutional right, against self-incrimination if the things you believe you are going to testify about would make you the subject of a criminal prosecution. So usually you discuss that with a lawyer. before you're going to do that. You don't just blindly say, well, I'm going to assert the fifth. You would get some kind of legal advice about that, or somebody who is at least versed in the constitutional law enough to tell you, no, that's not tantamount to that. That's not going to work. You're not going to be able to do that. But you have to have you have to believe, and it has to be true, that you could be the subject of a criminal prosecution based on what you're going to be asked about or what you're going to testify about.
So someone's asking if he wins, can the Fed still prosecute? Yes. This doesn't have anything to do with whatever's going on a federal level. That continues, and of course, we, based on everything, the reporting, and based on the testimony in this trial, there is a federal grand jury, or there was one, but we don't know. There's been nothing to say exactly where that stands. If Paxton is convicted and removed, is the AG's office required to allow those who took a leave of absence to return to work? I mean, they said they could return to work. I mean, Brent Webster said they could return to work. I don't know why they wouldn't. I mean, I would think they would open themselves up to a different set of problems if they didn't let them return to work. So, because they gave them temporary leaves of absences, and so I don't know. I mean, I assume that Brent Webster will allow them to return to their jobs. Let's see. Is there an opportunity for appellate review? I mean, there is no, I mean, this is the decision of the Senate, and that's it. So somebody's asking, so Dan Patrick addressed the senators and said they should vote with beyond a reasonable doubt. Does that apply when this is not a criminal trial?
Yes, because that's the standard they've adopted.
Yeah, they've adopted that standard, and so that is the standard that they have said they're going to, and explain reasonable doubt to people. I mean, what does reasonable doubt mean? Come on.
Well, the lawyer in me says I'm not allowed to. I'm not. If I were trying a case, the law does not allow me to explain to a jury what that it is. I can skate really close.
Well, you can explain, but you're not.
Well, and most of us lawyers, we explain it in a comparative sense. We use a graphic, stair steps, the lowest being reasonable suspicion, which is what you have to be which is what you have to be investigated. Probable cause, the next step, what is needed to arrest you or charge you. Clear and convincing evidence, preponderance of the evidence. Someone's suing you in a car wreck. That's what they've got. That's what their standard is in a civil trial. Clear and convincing. That is what they have to take your kids away from you. And then at the very top is beyond a reasonable doubt. So it's a lot. Things that would make you. We used to have under the Gisa case, we used to be able to say something that would make you hesitate in the most important of your affairs. When I was a prosecutor, that's what I used to be able to say. We can't say that anymore. Now we're supposed to say it is what you think it is. All right? It is what you think it is. So
it's really just a personal.
We're not supposed to invade the province of the jury. So.
But it doesn't mean you have to set aside all common sense, right?
That is exactly right. And the House has done. They have done a good job of talking about that when they were arguing, saying it is doubt based, but based on reason. Okay, not beyond all doubt. Not beyond all doubt. Don't get led down that path. It is not beyond all doubt.
So somebody asked, how effective do we think Representative Leach's comments were in closing arguments for the prosecution?
Very.
I thought
very
it was really
effective. He brought a personal portion to the whole trial, and I think that he tried to alleviate the narrative that they hated Paxton.
Approximate time deliberating. We have a timer going now.
Oh, we have a timer going now.
That's approximate time deliberating.
Very cool. I like that.
Oh,
so they got a clock up there for us.
Nice.
Man, we've upped our game.
Good.
Way to go, Jay. See,
Jay.
Eric is working it. Eric and Stacy. He's there we go. Okay, but go ahead. No, we were talking about Jeff Leach.
Yes, I think that he was very effective. The defense implied that that Paxton was going through this impeachment because the House hated him. And Leach said, no, that's not the case. Matter of fact, we were friends until things just started happening and they were questionable. But I think that, he was the excellent person in narrative to end the defense, the prosecutor's case. So he was very, very effective.
Well, I kept thinking throughout the week or throughout this trial that as I saw him at that prosecution desk, and I don't remember who I said it to, but I remember saying out loud to somebody, I bet they end with Leach. Yeah. He's Collin County. He is, you want to end with someone who has that personal relationship or had that personal relationship with Ken Paxton, who can say, like he did, this is my friend, this was my friend, we worked together, we got stuff done together, but I can't condone this behavior, and that's what Jeff Leach was able to do.
Yeah. And you know what too, he personally connected with those senators, because he said that I know it's a hard vote. It was a hard vote for me. And I think that he put in the minds of some of those senators, especially those up in Collin County, that hey, I know it's a hard vote, but if you look at the evidence, and he also said that up until a few years ago, it was different. Something changed. And then it gets back to the point of what changed. And then, the prosecutors want to say it was the affair or trying to cover up. But that's what the evidence showed or tried to show.
Okay. So somebody's asking about that email that they really wanted to get in yesterday afternoon. This was the email that the prosecution tried to get in during Dorfman's testimony. That was the deputy first assistant. I have no idea what that email was, but I think it was something they really, really wanted to get in. And I think they were, based on the context of it, they were going to use it to impeach him in some way, but we just don't know what it was. Maybe one day, maybe somebody will reach out to me and tell me what that was, because I very much would like to know what it was. Because it seemed like it was pretty important, because they spent some time on it, trying to get it in. They really did.
And Patrick, did he stop the clock?
Stopped the clock at one point, and they went back and forth, and then ultimately it didn't come in. But I was very curious. It felt like it would have been good to have. But we don't always get what we want. So,
and you know what, Tanya? That was one time that clock came in that was not good for them, how they ran it out at the beginning, because they didn't have time to focus on trying to get that memo. They had to move on.
Yeah, well, we don't know how much time they had left, actually.
Well, we knew that they didn't have a lot.
Now, we knew it wasn't a lot, but they didn't actually announce at the end how much time was left, so we don't actually know. We don't know if it was 5 minutes, was it 10 minutes, was it 20? The other thing was they didn't know how many witnesses the defense was going to call. So they had to be careful about not eating up too much of their clock.
In case they needed it.
That's true.
Yeah. That was the thing.
That is definitely true.
But it felt to me like Busby wasn't thrilled with what he was hearing from those witnesses, and he decided to quit while we're ahead.
Oh,
that's
absolutely.
how it felt to me. That's how it felt.
That's how it felt to me as well.
Okay, so somebody's asking about basically, in other words, allowing Senator Paxton to be counted in the total vote. In a way, isn't it essentially giving A.G. Paxton an automatic vote against the article without Senator Paxton having to cast a vote? I mean, not exactly, but it does mean you have to. It's a little bit. Just one more. It's one more vote you have to get.
It raised the.
It raised the bar. Yeah, it raised the number. But really, that's just.
But actually, it helped him in that way that they had to get more senators to vote, not to sustain it or whatever. But it didn't affect. No.
Now, somebody's asking how to find the recordings from each day of the Ken Paxton trial. You can title a trial. Sorry, I'm getting tired. You can find that on our YouTube page, and we actually have a playlist for this trial, so you can easily find that. Somebody's asking me how would I rank this in importance amongst all the stories I've covered. Gosh, I've covered so many stories. It's hard to rank it. I mean, I don't know.
Rank it according to the trials you've covered. I know they didn't ask that.
I did Amber Geiger. I mean, that was a huge trial. Aaron Dean. I mean, I think Amber Geiger was really big. I mean, I'm not saying this is a political importance, right? And so it's hard to say. And I mean, I covered about 10 years ago. I covered the death penalty trial for Eric Williams, who killed the DA, his wife, and a prosecutor down in Kaufman County. And honestly, that was a case that was I was all in the middle of, because I had covered it as a Dallas Morning News reporter, and then I had come over here, and so that was actually my first TV trial. And so that's the one case. If I could pick a case and say I should have written a book, that's the one.
You can still write a book.
Yeah, but I was.
I'm telling you.
I was so busy when it all. It's funny because I covered that as a DMN reporter, and I look back and I think, why wasn't I taking like a daily journal? Because there was so much happening all the time. We were working crazy hours. Wait a minute, I'm working crazy hours right now. But anyway, but I look back and I go, wow, that was the one. And you know how it is as a reporter. You're so busy like actually doing the job, and you don't have to. I'm not a person who sits down in journals, so there we go. I should have. That was the one I should have. So honestly, I think for me that trial was probably my biggest one. Eric Williams, and he's still sitting on death row, and he is, eventually, presumably, going to, be executed in the state of Texas at some point. So but he's still fighting his appeals process. So somebody's asking, they understand that Senator Paxton. They're asking why she can communicate with other senators. They're not supposed to be talking about before this. They weren't supposed to be talking about the case. So there's no way to know
what they're talking about.
Yeah, okay. So I'm kind of running through these questions, guys. I'm just going to keep going here. Somebody asking me what I think. I don't know. I'm being careful about what I say. Okay, so somebody's asking me if I think they got to Laura Olson. I don't know. I think it could just be as simple as what we've already discussed.
Yeah.
I'm sorry. I'm keep going through these questions here. Oh, well, somebody's a tenant in Nate Paul's properties, and they're just sending some rumors. I'm not going to read those aloud. Are you surprised that that we're still deliberating? All right, let me turn on my thing because Jay's trying to talk to me. I got you now. I can hear you.
Now it's okay. I was saying we should bring in Ken Paxton.
Oh, do you want to play the? Okay. We can.
50 seconds introduce.
Okay, so Jay is going to play the story that talks about Angela Paxton, so we can kind of get her background.
Good evening. Ken Paxton's campaign still has this video posted on its YouTube channel from 7 years ago.
Well, I am Angela Paxton, as my last name might kind of give away. I am married to our Texas Attorney General, Ken Paxton.
Before winning election to the Texas Senate, Angela Paxton sometimes campaigned with her husband and sang.
I'm a pistol packing mama, and my husband Sue's Obama. I'm a pistol packing mama, yes I am.
Angela and Ken met at Baylor University. They married in 1986 and had 4 children. Through the years, they've shared several family photos on social media. She was a career educator, a teacher, and then a guidance counselor. 16 years after her husband entered politics, she did too.
Angela Paxton is an educator with 22 years of experience helping kids reach their dreams.
In 2018, Angela Paxton ran for the same state Senate seat Ken Paxton once held. She won, and won again in 2022. As a senator, she's also now a juror in her husband's impeachment trial. But she is a juror without a vote.
The motion is adopted.
The Texas Senate approved 31 rules to govern the upcoming trial, and rule number 31 applies solely to Angela Paxton. It says spouses have a conflict of interest. It allows her to hear all of the evidence, but that's all she can do. When senators deliberate behind closed doors, she will not listen in or weigh in. Her presence counts towards the total number of votes needed to convict her husband, but she will not cast a vote on anything. Senator Paxton voted against those rules. Then she put out a statement saying she will do everything in her power to be a voice for the people of her district. Never before has a Texas Attorney General been impeached. And never before.
I'm a pistol packing mama, yes I am.
Has a senator sat in on her husband's impeachment trial. In Dallas, I'm Teresa Woodard.
So the next person's that's the second time I've heard that story. Wow. Okay, so somebody says, who do you think gave the most impactful testimony during this trial, and do you think that testimony will sway anybody's vote? You know, I thought Brandon Kamek, Drew Wicker, Missy Carey, probably David Maxwell. Those are my four.
Those are my four.
I mean,
and I put Brandon up at the top, and I liked Missy.
Missy and Brandon and Drew Wicker, they don't really have a dog in the hunt, and they're not whistleblowers. They're just people that are probably in the last place they'd prefer not to be. And do you think any testimony will sway anybody's vote?
Brandon's. If any vote is swayed, but I think that Brandon, he raised too many ifs. Why? And wondering, why did you hire this person? So, and I liked Maxwell's. He was, to me, it was as if it was a craft for him.
Yeah, well, he was like, Walker, Texas Ranger kind of thing.
He's a cop's cop.
Yeah.
Yeah, his testimony was very impressive. Very impressive.
Yeah, and he came across as somebody just, that long time Texas Ranger, I thought he was very impressive.
And it also made me wonder, whatever his reason, and I know that they've given it, why would you fire someone that's respected so much? Why would you take that risk? I know I loved his testimony, and I just asked a lot of questions in my mind.
Well, and Wicker's testimony, I think, was pretty powerful too, because I mean, this is the guy who spent a lot of time with Ken Paxton and clearly still likes Ken Paxton, but felt like there was a lot of things that worried him, concerned him.
He was uncomfortable.
And the least effective, I think some of the whistleblowers were, it wasn't that they were, I just felt like the people that were the most effective were the people that had less of a dog in the hunt, except for Maxwell. Banger was also good too. Banger was good, and so was Blake Brickman. But I do think that those were my favorite, the first four that I mentioned.
Yeah.
Okay, so let's see. Let's keep going here. Now they're going to take us live at 4, so I got to also kind of be mentally. We'll start. I'll warn you guys out there on the live stream where we're kind of about to go do that. Oh, so let's see here. They're not showing Bernadine doing her makeup.
Okay.
It's all good. You can do your makeup. Folks on the live stream don't care.
Well, that was my signal.
Real, you know what it looks. That
was my signal. Oh my goodness.
Somebody's asking. Like, what do you think the discussions among the Senate jurors are like right now? I don't know. I mean, what do you think? There's a lot of discussion back there, Stephanie?
I don't know. So many people, and Bud has said this, and I think a lot of us that have been watching this for the last 2 weeks tend to agree. And this happens a lot of times as a lawyer, as a trial lawyer. You go into a case thinking, all right, well, I know how this is, I have a tendency to feel how this is going to turn out. I have a gut feeling. And then it plays out, the evidence is presented, the matter unfolds, and you feel differently I don't know. I don't know, because this is a political trial. I don't know that there probably is, if there is much discussion. And who's to say, and Bernadine, you could talk about this, because I like your theory about the whole splitting the baby thing. Mm-hmm. I mean, if there is discussion, do you think that there is bargaining going on back there? Like, do you think somebody's saying, I live in a district where it is not a possibility for me to vote this way, but you don't, madam, wherever you're from, and maybe we could work something out?
I think that they could say, okay, we remove him because the evidence has come out.
In other words, a Solomaic type thing.
Yeah,
Yes.
then, allow him to run again, and then the voters can decide after they've heard all of this information, because it raises the question as to why they separated it.
Yeah, I don't know. I have no idea what I don't know what.
But I don't know now. Hey, that's why we're up here.
I most certainly do not claim to have all the answers.
Yeah.
People want to know if we'll get access or see the exhibits shown to the senators and jury members. A lot of these exhibits were actually included in, if you go to the Senate impeachment site, a lot of them, back in mid-August, the House impeachment managers dropped a lot of these exhibits, but they're numbered a little differently. So, because I think once they started entering them into the trial, but they may at some point post them again. I don't know, but a lot of that stuff, a lot of those exhibits are actually available on that site. Somebody's asking me, if there's no conclusion today, will you be live tomorrow? Yes. Yes, I'll be here. I will be here. I had something else I was supposed to do, but yes, I will be here. I will be here until the bitter end. Whatever the end is, I will be here for it. And if it goes into Sunday, I will go to church first, and then I will be here. So, but we'll see. We'll see. Kind of how things turn out. But my instincts are still that this wraps today. I mean, is that your instinct? Can you tell me that that's going to happen? Because that's what I really think.
I can't tell you that it is definitely going to happen, but that's what the speculation is.
I mean, it just because generally, and I understand this is not a typical juror, but generally jurors want to go home for the weekend.
Yeah,
that's exactly right.
So so somebody's asking about Busby. And I'll ask you this. Why was Busby allowed to state his own opinions in closing, as well as a number of misleading or false statements that were not produced as evidence at trial?
And I meant to talk about this before we got started, and I think Lieutenant Patrick hit on this, but I don't think he talked about it very much. Closing arguments are not evidence. They are not evidence. And so when lawyers get up there and make these impassioned speeches, they are obviously putting their spin on their case that they put on, the evidence. They're highlighting what they feel are the strong points on their side, but they can be impassioned. They can be a little bit more fast and loose, because the rules, not so many rules of evidence apply to arguments, because they are not evidence. Arguments are not evidence. And so that's why you hear lawyers skate close to the line, and some of them are very impassioned, exhibits are used, things are done like that. There's a little bit more leeway than there is at the case in chief portion of the trial. So that's why it's just there's no rule against it. There are rules with respect to closing argument. Don't argue things, facts that are not in evidence, which he did make that objection to the other side. But as far as voicing his opinion and him injecting himself into it, talking about being a Marine, things like that, those things are all allowed, because it is not closing arguments are not evidence.
So somebody asked, does Paxton have any legal recourse if he is removed? No. This is a constitutional process, and this is the final arbiter, whatever the Senate decides to do. Okay, so somebody's emailing from the United Kingdom. Wow. Okay. So do you and the panel think that a conviction for a maladministration article, and not a criminal one like bribery, opens a Pandora's box for future impeachments?
I definitely think that was the argument that Attorney Busby made.
Yeah.
He's like, think about the ramifications of this, ladies and gentlemen of the jury, think about that. What is this going to mean for other people? Is this going to have a chilling effect on people running for office, on how our current elected officials conduct business in their office? I mean, he really hammered that home. That's something to think about. I mean, we really don't know.
Yeah, I mean, I don't know, and I'm not gonna go there. So, I mean, I think it's difficult to know what could or would happen. The Supreme Court set the standard, and Bud has read it several times. It had to, because in Texas, you don't have to prove a crime was committed in order to remove from office. It has to do with, abuse of office, that kind of thing. I think the words were, it was like maladministration, and there was another word. I forget the other word that was in that Supreme Court opinion.
And then the House still has to vote it. So.
Yeah, so assuming the Democratic senators, okay, here's one. Assuming Democrat senators unanimously vote to sustain, should there be any criticism of them voting politically rather than on the facts? I guess somebody could make that argument.
Yeah.
Sorry, still going through my questions, but they're going to be taking us live soon, guys. I'm also kind of listening in my ear to this. So somebody asked why, and this is you, Stephanie. Why didn't the prosecution call Paxton? Well, they couldn't call Paxton because they said he couldn't call him. Yeah, I'm sorry. At the beginning of the trial, they ruled that Paxton could not be made to testify.
Right, which is the same case in a criminal trial.
Yeah, which would have been. Somebody wants to know what do we think are the one or two biggest mistakes made in the trial by the House managers and/or by the defense? I thought time management was a problem for the House. Just a failure to manage that clock more effectively.
Well, and this is such an artificial way to try a case, and especially for these seasoned litigators. I mean, this is very different, even for these lawyers who are considered top tier, trial lawyers. It's very, very artificial and foreign to be able to work within those confines. I'm sure they had a lot more trial prep than they probably already would have to accommodate for that. I know just from practicing in Collin County, when I do practice in Collin County, the family law courts do that. They have to limit the litigants' trial or litigation hearings because because of the nature of that type of law, they can get out of control. So I know that that's a whole different way to practice. I have so much respect for my family lawyer friends that work within those confines because it is very, very different. So Tanya, you're probably right. They probably didn't do a great job of that, but probably they didn't have a lot of experience having to try a case that way.
And my take on that is, I'd wait to see how the verdict goes.
Well, that's true.
Before I say that any mistakes
that something was a mistake. That's true.
Yeah.
And from the defense side, I thought that the witnesses they put on yesterday didn't really help them. One of the things Deandra said yesterday was she thought the defense might have been better off just to rest, say, you know what, they didn't prove their case. We don't have to put anything on.
Exactly.
I agree with that.
Exactly.
And I think that Busby realized that once they started
because it felt like he ended it abruptly. That's how it felt to me. So that, let's see here. We got a few more questions before we go live on like the real TV.
I know that I start putting makeup on.
I know. Folks out there don't care if you put on makeup. We can have. Eric, can you put up some videos so that she can do her makeup?
No, I'm done.
You're done? Oh, she's done.
I'm done.
Never mind. She's done. It's good. So somebody wants to know if he's removed, would a special election occur to replace him?
Here it is. I pulled it up.
Because I feel like I
pulled it up.
Okay. So explain that.
Okay, Paxton's removal would create a vacancy under the law and trigger an election for the season of 2024.
And you're reading from the Houston Chronicle.
Mm-hmm. And trigger an election
in the 2024 cycle.
The winner who makes it through the March primary and the November election will serve the final 2 years of Paxton's term. Okay, until the victor is sworn in, Governor Greg Abbott will appoint a replacement. Abbott already named Angela, I don't want to butcher her name, but his former deputy chief of staff as an interim while Paxton is suspended during the trial. He could choose her or someone else.
Right. So that answers that question. So the answer is eventually there'll be a special election sometime next year. Okay. Why? Somebody wants to know, why aren't the deliberations being televised? Well, because it's akin to a jury, and jury deliberations are not televised, and that makes a lot of sense to me. I don't think there'd be much good of trying to televise. I mean, well, not to say that I wouldn't mind being a fly on that wall, but it's not unusual for jury deliberations to be. For that to be, sorry, I'm reading questions as I go here. And I'm also listening in my ear for when they're going to take us live on TV. So, we're testing my abilities to multitask. We're just seeing how much can she multitask all at once. Can she read, can she listen, and can she talk? That's a lot. Okay, so this is an interesting one. This person says, a lot of senators may not appreciate Mr. Busby mocking the witnesses in his closing, particularly the, quote, 6'6" Texas Ranger. What do you think? What do you think, Stephanie?
Like I said, they have every lawyer has different styles. It's a stylistic thing. And if that's your style, you've got to, and he's been doing it a long time, he's got to know, and you've got to know, like, you could rub some people the wrong way. But that's his style. That's what he does. And, apparently he's doing very well. It hasn't hurt him. He's a very well-respected trial attorney. He does well financially. So while it may rub some the wrong way, it's, you don't have to fix it if it ain't broke.
Well,
in his book,
we'll see. He's that approach is what he does in a regular. Of course, that's so different. It's just so different. In terms of, this is not your typical trial, and so and like Bernadine said, we'll see what worked when we see an outcome.
Yeah. Exactly.
And that's when we'll. And then again, you're going to have some senators who probably knew what they were going to do from the very start.
And he's been doing it. That style. He's been doing it the entire trial.
That's been his approach to attack law enforcement, which is kind of it's sort of an upside down. It really feels very upside down to me as somebody who's covered stuff for many decades. It just the whole thing.
But I think where he miscalculated was when he interrupted Jeff Leach.
Okay, we're in the
closing.
Oh. All right, guys, we're in the show. Jay, are you able to bring the show up and just show the show?
Potentially.
Because I gotta also pay attention to this. All right, folks, for that are watching us live out there, I'm also listening to the 4 o'clock they're gonna be taking us live on the regular TV. So I'm having to get myself mentally prepared for that. And I'm trying to see if they can bring that up live, because it'll make my life a little easier if they do that. I probably should have asked them that earlier.
Stand by, Tanya.
Wow, somebody said my name, like stand by, really loud. I don't know if you guys heard that out there. Well, what we heard is the defense arguing that this is a political witch hunt, that these were rogue employees who got together and concocted a story and listened to speculation and rumor, and that they just really didn't have any evidence. And that we also heard that this was something that was that this was just that they presented no evidence and that there really was nothing to back this up. And of course, in the prosecution, we're hearing that Ken Paxton violated his oath of office and that he deserves to be removed and that he allowed a criminal investigation to be conducted on behalf of his friend and campaign donor, Nate Paul. So let's take a listen to both sides and what they had to say this morning during closing arguments.
Might as well take it out.
And that's right, you just heard those closing arguments from both sides, and the Senate jurors have been deliberating now, looking at the clock, for just over 4 hours. So, and we have not heard anything from them yet, and we'll kind of see how this plays out. So I've got with me Bernadine Steptoe, our senior political producer, and Stephanie Alvarado, who is our legal analyst for the day. And just your thoughts about where things stand.
Well, I think that both the House and the prosecution did an excellent job in their closing of presenting their case. The defense primarily depended upon politics. Theirs was about telling the senators the impact it would have on the Republican Party, whereas the House relied a lot on the evidence. And I think that now we'll just have to wait and see which side worked best.
Stephanie, where do you see this going?
I agree with Bernadine. I think that the styles were very different, both very effective, very engaging. I have a tendency to think, like a lot of people think, that if minds were made up, they may have been changed today or may not. Maybe that's why they're taking so long. If you would consider 4 hours a long time for such an important decision, for something that's unprecedented. I don't think the weight of this escapes any of these senators. I think they know it's going to have lasting ramifications. In fact, Attorney Busby, that was one of the things he talked about. Let's be careful about the precedents that this sets. If we start impeaching, if we impeach my client, what does that mean for other people, other elected officials, and how are they going to conduct their business? Are they going to be afraid to do things because they're afraid that they will end up here trying to prove their innocence?
You know, the other thing we saw was that Representative Leach, who is from Collin County, was the one that gave the final closing arguments from the prosecution side. Bernadine, why do you think the House impeachment managers chose to have him do that?
Because I think that they wanted Leach, which he did very well, to make a connection with the senators. Number one, he's from Collin County, so you have a number of those senators who are from Collin County that voted to impeach him. And I think that he wanted to say, hey, I'm friends. And then also he wanted to dispel the notion that the House impeached Paxton because they hated him. He talked about the friendship. He talked about their families doing activities together. He talked about them going to church. And I think he made that connection, that this is not about hate. This is about doing the right thing. And he even quoted Martin Luther King. I wish that I had that quote with me now because I'm very, very familiar with it. I don't know it without reading it, but it was so effective. Matter of fact, when I finished, I'm like, wow, and I was surprised. But as you said, you were not surprised, but I was surprised that they ended with him. Very good strategy. Very good strategy. The House said, okay, we've given you the evidence. Then they bring up Leach and they say, okay, I was not comfortable voting to impeach him, but I had to do my duty.
Okay, we're going to send it back to Chris and Izzy. Thank you so much, guys.
Whew, I know.
I didn't hear him talking in my ear.
Yeah, we can hear him either.
I'm just saying, I didn't hear them talking in my ear. I know we're live.
Oh.
I'm just saying that I didn't hear the producers talking in my ear. So I had them, I had the correct IFB on. I know we're live, guys. Y'all are seeing a little bit about how the sausage is made over here. And sometimes, we live and we learn. Okay, so I'm going to go back to, sorry to sweat there a little bit. We're going to go back to answering questions from folks. Actually, you know what? We're going to take a break because I need a break.
I need some water.
Can you bring up can we play some more video for folks?
Yeah, I'll get to it in a second.
What do we want to play?
Tell them we'll play some Wicker video.
Okay, we're going to play some Drew Wicker. This is Drew Wicker was Ken Paxton's personal assistant. He spent a lot of time with Ken Paxton, and his testimony, I think, it will end up being very.
In like 5 minutes.
Okay, in like 5 minutes. But you know what? We can talk for 5 more minutes until he gets the Wicker video. Okay, so will we know how each senator voted? Yes.
Yes.
We will. We will know. That's the next question. And so this person asked, does the fact that Abbott appointed someone from outside the office of the AG to act as in the interim forecast how he feels about Ken Paxton?
No, because the Constitution allows him to vote whoever he wants to vote.
To select.
Pardon?
You mean to select, not to vote, to select.
Oh, yeah. We do need a break.
We do need a break.
To select whoever he wants to, and he would select someone who he trusted. So no, it doesn't tell anything other than he just put someone in there who he thought was competent and who he trusted.
And Maxwell, so somebody's emailing me saying that Maxwell was sitting in the closing arguments listening, and he was in the upper gallery.
Yeah.
So there's some people that are clearly agitated with some of what Busby had to say, because I'm getting a number of people are asking, will the deliberations remain secret, or can the senators discuss their deliberations publicly once a verdict is rendered? They can discuss them once it's rendered,
They can discuss it. But you know what? If I'm not mistaken, the rules dictate that they cannot discuss the vote until they write it down, and then there's a certain number of days because it has to become record first.
Okay, so we are going to take a break because I need a mental break. I need all the breaks in the world right now. It has been an incredibly long week, and we're gonna play Drew Wicker.
What?
Mr. Wicker, please raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please be seated.
Yes, sir. May I proceed, Mr. President?
You may proceed.
Thank you. Please state your name for the record. Andrew James Wicker. Mr. Wicker, it's a large room. Yeah.
Okay. Andrew James Wicker.
Thank you. I appreciate it. Tell us a little bit about your background. Where did you grow up? Where did you go to school?
I went to school at Prestonwood Christian Academy. That's where I graduated from high school. I grew up in Prosper, Texas, a little town north of Frisco, Texas, in North Dallas.
Let me pause you for a moment. Okay. Can y'all hear him well enough?
Okay. No? Okay, how about this?
Thank you, much better.
All right.
Please go ahead.
My name is Andrew James Wicker. I grew up in Prosper, Texas. I grew up going to school at Prestonwood Christian Academy, which is where I graduated from high school. I then continued on to go to SMU for undergrad, and then I went on to a graduate degree at Georgetown University.
Okay. Can you tell us a little bit about what activities you were involved in college or in while getting your master's?
In terms of my involvement in college, my first job was working for Don Huffines on his Senate campaign, and then I continued on to later be involved with founding the Young Americans for Freedom chapter at SMU, where I served as vice president, and then I helped refound the College Republicans for SMU. I ended up working with several student organizations on a 9/11 flag memorial and pro-life memorial. We had a tiff, I would say, with the administration. And so I got involved in politics in that way. And then I continued on to Georgetown and landed in DC for my graduation. And then I went to work for General Paxton.
Okay. Do you recall approximately what time or the date that you went to work for Ken Paxton?
My employment with the OAG started September of 2019.
How did you originally meet Mr. Paxton?
I had met General Paxton previously, both as my state senator, but also as the Attorney General at various Lincoln Reagan Day dinners. In terms of my employment and the opportunity to start working for him, I met him through Mark Rylander, who was a previous associate in North Texas in terms of my community. And I was recommended for the position by Mark Rylander to General Paxton. And that's whenever I met him at the Marriott Marquis in DC, and I was hired.
Okay. If Jeff Mateer was the first assistant, did Mr. Rylander have a nickname as well?
He was known commonly as the first friend.
Okay. And through that connection, you end up working at the Office of the Attorney General. In what role? What'd you do?
My title was executive aide to the Texas Attorney General, and then I was also on the campaign staff as well.
And what does an executive aide do?
My responsibilities expanded and contracted as I also had to assume scheduling responsibilities. We had 2 schedulers during my time there. Whenever we did not have a scheduler, I assumed those responsibilities, but my standard job responsibilities during whenever I was performing the functions as an executive aide was to ensure that the general was going to his schedule on time, that he was prepared for those appointments, and that he had all necessary documents and context to the discussions that he was having for that day.
That sounds like a great deal of access to the Attorney General. Is that fair?
Yes.
Approximately how much time did you spend with each other in any given day?
At least 8 hours, normally closer to probably 10.
And was that just weekdays or weekends as well?
That would include weekends.
How often was Attorney General Ken Paxton in Austin in 2020?
This was during COVID, so after probably the first 3 or 4 weeks of COVID setting in, he spent the majority of his time in Austin, starting in probably about April-May timeframe through the remainder of 2020.
And where was Senator Angela Paxton?
She regularly split her time both between their home in McKinney and in Austin.
What was your relationship with the Paxtons, individually and as a couple?
Individually, I would call General Paxton as a friend. I spent a great deal of time with him. He and I bonded over a good number of activities, such as watching football, sometimes talking politics, but just talking life. With Senator Paxton, I would say that she was nothing but loving and caring. I think she also understood that the demands of the job kept me away from my family. So in many ways, she was kind and understanding in the way that a mother would be normally. As a couple, I would say that they were incredibly welcoming and caring to me, and always inclusive.
So fair to say there's no animosity or bad blood between you and the Paxtons?
Not from me, no.
Are you part of some vast conspiracy to harm them?
No.
Are you in league with TLR or the Bushes?
No.
Are you here to tell the truth?
Yes.
I'm going to turn your attention to Nate Paul. Are you familiar with that name?
Yes.
How so?
During 2020, I was introduced to Nate Paul, and there were a number of activities and discussions that revolved around Nate Paul throughout 2020.
Oh my gosh! Okay.
If it hadn't been for one simple safety item, this could have been a family tragedy.
House fires occur in this country every 87 seconds.
350,000 house fires are reported each year. Nearly 3,000 people lose their lives.
And did you know the number one place that they start is right here in the kitchen?
With my years on fire departments, I've extinguished and dealt with the aftermath of a lot of kitchen fires. And folks, they devastate families.
Can you tell me the first time you remember hearing of Nate Paul or meeting him?
The first time I remember meeting Nate Paul would have been February or March of 2020. General Paxton and I met him for lunch at Terry Black's barbecue.
Was it just the three of you?
It was.
And what was the topic of conversation?
Objection, hearsay.
Your Honor, may I please respond? Anything from Ken Paxton as an admission by party opponent. Nate Paul is very clearly tied to a conspiracy, at least in terms of the evidence before this Senate, and Drew Wicker is available for cross-examination. None of that evidence is hearsay.
Again, Your Honor, the question she asked, she did not specify who was talking. Anything Nate Paul may or may not have said would be hearsay.
Sustained.
In the course of getting to know Nate Paul and Ken Paxton as a friendship, well, let me do this differently. How are the interactions between Nate Paul and Ken Paxton?
I'm sorry, can you state this question again?
Yes, sir. What was the relationship like between Nate Paul and Ken Paxton?
Objection, Your Honor. Speculation. He can testify about what he saw and maybe what he heard from Ken Paxton, but that's the extent of it.
It's foundational evidence, Your Honor. He can testify to his rational perception of the facts.
Sustained.
Did you see the two of these men interact with one another?
Yes.
And what did you see in terms of their demeanor?
A cordial relationship.
Did Mr. Paxton look to be under pressure to you?
No.
Now, I'm going to turn your attention to the second time you had lunch with them. Do you recall that?
Yes.
And where was that?
That was at Polvos, downtown in Austin.
Do you recall approximately when?
This would have been May, June timeframe.
Okay. And was anybody else present for that lunch?
Ryan Bangert.
Does Mr. Bangert work for Attorney General Ken Paxton at that point?
He did.
Is he there in his personal capacity or as part of his job duties?
He was asked by the general to attend as part of his job responsibilities.
And what was the topic of that conversation?
The Many Foundation.
Did anything change in regards to what Mr. Paul wanted between the first and the second lunch?
Objection, Your Honor. This calls for hearsay again.
Your Honor, if I may, I would really appreciate it if you would look at 801 E2D specific to co-conspirator statements.
Your Honor, there's no evidence of any silly conspiracy. This is hearsay.
This entire trial has been about a conspiracy, Your Honor.
Sustained.
Who paid for lunch?
Nate Paul.
How did you perceive their demeanor and interactions with one another, hostile or friendly?
Between Nate Paul and Ken Paxton?
Yes, sir.
Friendly.
What about Ryan Bangert? How was his demeanor?
Inquisitive.
Did he seem to agree with what it is they wanted?
Objection, Your Honor. Speculation. We've already heard from Mr. Bangert.
That is exactly why it's relevant, Your Honor. He attacked the credibility of Mr. Bangert. So it is not only not hearsay because he's a representative working for Attorney General Ken Paxton who would have adopted a belief in or offered contrary information to. In addition to that, it's a consistent statement used to rehabilitate Ryan Bangert because of their attacks.
Your Honor, I'm sorry to belabor this, but Mr. Bangert testified. And to have this witness tell us what Mr. Bangert's attitude was about some lunch 3 or 4 years ago is just improper.
Time frame has nothing to do with exceptions to hearsay, Your Honor.
Overruled.
Thank you. Can you please tell me what Ryan Bangert was saying in response to this conversation?
Okay, Your Honor, now she changed the question. And
I'm entitled to do that.
Let me finish my objection, please. Now instead of the witness answering the last question, now she's asked a clearly hearsay question.
I went more specifically at it after the court's ruling, which I'm entitled to do.
She cannot ask this witness what Ryan Bangert said. She just can't do that, and that's what she just did.
Sustained.
Thank you, Your Honor. I'm going to turn your attention to the third lunch involving Nate Paul and Ken Paxton. Can you tell me when that was?
This would have been June, July timeframe.
Of 2020?
Yes, ma'am.
And who was present at that lunch?
General Paxton, myself, and Nate Paul.
What was the topic of conversation for this lunch?
The FBI raid on Nate Paul's home and office.
Specifically, access to the affidavit underlying that search warrant?
Objection leading. And again, Your Honor, I'm sorry to interrupt, but she's asking about what Nate Paul said at a lunch. That's improper, and that would be hearsay.
Your Honor, may we approach?
You may approach.
Okay, so Victor, your reaction to what we're seeing right now?
So the strategy we were talking about before the proceeding started today, where we see these shotgun objections, the strategy is being employed, and it's obviously very effective. It's breaking the flow of testimony on an important witness. What's notable is when I'm trying cases, I like to watch my jury as I'm looking at the jurors in this instance during one of the back and forth between the prosecutor and the defense. You can see Senator West, who is a very good trial lawyer and litigator here in the Metroplex, looking very perplexed by some of the rulings.
Of course, that was the ruling where they had the exchange about. She said this is all about a conspiracy, and Busby said, well, they haven't presented any silly conspiracy. So and Governor Patrick actually upheld Busby on that, which made Royce West.
And you kind of shook your head.
And that is
surprised us.
That's where I saw Senator West looking perplexed, and I was perplexed myself. The evidentiary basis that was proffered by the prosecutor was actually a good basis for the admission of that testimony.
Does this show the limitations of having a presiding judge who is not a lawyer and not a judge?
It does. But the prosecutor is doing a really good job of educating as she is presenting her objections. Or she's responding to the objections.
But this also allowed the defense attorney to bring back up this boogeyman of there was no.
Video of Laura Olson. So we thought we were going to get Laura Olson, the former mistress, on the stand this morning. Victor, what do you make of this? This is a screw up, right?
It is. You want to make sure that if there's going to be testimony that's critical and there is a requirement to exchange information regarding who's going to testify, that you meet that deadline. So yes, it is pretty disappointing error.
And even if she gets on the stand, how much time will be left?
Well, right. Okay, so it looks like they're about to restart here. But, oh, no, they're still conferring at the bench. Sorry, I've also got the Senate live feed up so I can keep an eye on it. But, yeah, I mean, well, it seems like they're running a fairly, I hate to use the word. The reason I say that is because they started yesterday with 9 hours. Only has 5 hours left. So maybe they'll get to her. Given just kind of the way they seem to be running the clock, it seems like they're being pretty judicious.
We will sustain the objection.
May I proceed? Outside of those 3 lunches in which you ate with Nate Paul and Ken Paxton, did you have occasion to be around them on other times, other occasions?
Yes.
And what kind of things would you do together? Where would you see them together?
There were 2 types of instances. The first was continued lunches, usually at Polvo's. The second was meeting at Nate Paul's place of business. And I was not part of those discussions whenever those did occur.
So to make sure that I understand, there would be times you were at lunch but not seated at the table and eating with them?
That's correct.
How many times did that occur?
Dozen and a half.
Roofers are furious about this new product that's going viral. Replace your whole roof in as little as 8 hours? And right now, we're looking for homeowners to experience this futuristic roofing product. Click below and enter your zip code to see if you qualify. Erie Metal Roofs.
And what about trips to Nate Paul's business? How many times do you recall that happening?
At least a half dozen.
Were you ever at Nate Paul's home?
No.
And did you ever see Nate Paul join Ken Paxton at the office?
Only once.
Okay, we'll come back to that in a moment. Your Honor, at this time, the House offers House Exhibit 704, which is a public record. It is already on file, and there's a business records affidavit attached that has been on file with the court and defense for over 14 days.
Any objection once you read that?
Coming to me? Oh, I was like, what are you doing?
Your Honor, there's a facial problem on this exhibit. It claims an affidavit proving up 12 pages of records, but apparently there's 23. I don't know if there's anything in here that matters, but the affidavit is improper and obviously inaccurate, unless somebody wants to correct me.
Your Honor, it's a record of the Texas Department of Public Safety, and pursuant to the rules related to public records, it would be incumbent upon Mr. Busby to establish why he thinks the records would be inaccurate. Also, the page count is likely attributable to the fact that photographs were enlarged and attached.
Again, Your Honor, she's the proponent of this document. It says it's 12 pages. It's not 12 pages. I mean, that right there gives us some element of maybe it's not trustworthy, and she's the proponent. She needs to show us why the affidavit doesn't match the documents attached. That's her job.
Your Honor, I'm confident in my response as it exists, but let me speak to my co-counsel out of a moment of respect.
May I approach and give the court a copy of what I'm looking at?
I would also add that at the conclusion of each of the records is a notification that it's a certified copy. It comes in 3 different exceptions to hearsay: business record, public record, and it's a certified copy. Additionally, I emphasize that the Attorney General works for the state of Texas, and these are state of Texas records. It's intellectually dishonest for him to fight them. Mr. President, while you're considering, can I also ask that the clock be stopped and we returned about 10 minutes between the last 2 sections of this? It's an excellent defense strategy, but it's slowing us down since we agreed to all of their exhibits and they would not for hours.
Your Honor, I'm sorry. This is important. First off, I've been called intellectually dishonest because I look at an affidavit that says 12 pages and it's 23. And now that we're playing games because they're offering an exhibit that's clearly not what they claim it is. So I'm just making my objections, and that's all I'm doing.
Yes, you stipulated it was 12, it's 23.
Yes.
So I am going to overrule the objection because there are 5 large photographs, may account for it, and it is a government document. But I'm not giving you back the time because if you had explained this up front, we wouldn't be having this issue.
That seems fair, Mr. President. I'll go faster.
Overruled. Here's your document back.
Stacy, would you turn to, don't publish it yet, but
704 is admitted into evidence.
turn to the picture we discussed. If we were to show you a picture of Nate Paul, would you be able to identify him?
Yes.
And are you going to feel like I've led you, or if I show you the wrong picture, will you correct it?
Yes.
Yes, you'll correct me?
Yes, I will.
Thank you, sir. Permission to publish.
Yes.
Who do you see on the screen before you?
That is Nate Paul.
And is this the same person that was having lunch with Ken Paxton on those occasions and whose office that you visited?
It was.
And is this the same person who is currently facing charges in the federal courts?
Objection, hearsay, and relevance.
Sustained.
Is this the same person who was discussing the Mitty Foundation in front of you?
Objection, hearsay. We've already discussed this. This is hearsay.
He was having the conversation with Ken Paxton, who's a party opponent, Your Honor. And again, I would direct you to 801.
Overruled.
Thank you. Is this the same person who was discussing Mitty with you and Ken Paxton?
Yes.
The same person who discussed that in front of Ryan Bangert?
Yes.
And was he making requests or pressure upon the office?
Objection, hearsay.
Overruled.
What kind of things was he asking the office to do?
Objection, Your Honor, that's hearsay.
Let me go back and do it exactly the same way that he just overruled. Is this the same person who was talking to Nate Paul and Ken Paxton about Mitty?
Yes.
And what kind of things was he asking the office to do?
Objection, assumes facts not in evidence. No one's established he was asking for anything. Hearsay.
What was he asking of the office?
Again, Your Honor, she just asked the exact same question. Hearsay and assumes facts not in.
I understand why he doesn't want this in, Your Honor, but can we stop the clock again?
No, we're not going to stop the clock each moment. We haven't throughout the trial. If there's a long delay, I will stop the clock and give you time back. We're going to sustain the objection, and both sides need to stop the ongoing speaking objections.
Yes, Your Honor. May I get a clarification? A moment ago it was overruled and then sustained. Is Nate Paul going to be considered a co-conspirator for the purpose of this line of questioning or not?
Your Honor, before you, if I could, a conspiracy requires an agreement. Can I take the witness on voir dire to establish there's never an agreement? A conspiracy at its heart requires an agreement between two parties and then acts in furtherance of the conspiracy. There's been no evidence whatsoever in this trial. There can be no evidence in this trial of any agreement between Nate Paul and Attorney General Paxton. This witness will confirm that. I would like to take him on voir dire to establish that, and we'll put an end to all this.
If I may clarify, it is not incumbent on the sponsoring witness to establish conspiracy. That is an obligation of the court or the presiding officer. This entire case has been about Nate Paul and Ken Paxton, and I understand why they don't want it in, but that goes to weight, not admissibility, and he can be crossed on these issues. This entire trial has been about Nate Paul and Ken Paxton.
Two questions, Your Honor, to establish with this young man that there was never an agreement. He never heard an agreement, no conspiracy, and we can quit talking about that. They can use this word all day long like they've been, but they cannot establish an agreement between Nate Paul and Ken Paxton.
If I may.
We'll stop the clock for a moment. Ms. Epley, Mr. Busby, come up.
Okay, Victor, talk to us about what we're seeing here.
Yeah, so this is very interesting. We're seeing a clinic on the rules of evidence through the barrage of objections and the responses. It's all very great. So what they're probably talking about right now is the defense's request to voir dire the witness on a foundational fact that will be necessary to sustain or to establish the co-conspirator exception that the prosecutor is talking about. I expect that's what's going on here.
What do you think Patrick's going to do, or what should he do?
Well, if I were in Dan Patrick's shoes, if I were the judge and somebody asked to take a witness on voir dire on a foundational fact necessary to establish whether or not an exception applies, then he probably should give the defense the voir dire opportunity. And what's happening there, what we're talking about is examining the witness on a foundational fact to see whether an exception to the rules of hearsay applies. And it really goes to the crux of the prosecution's case.
Okay, let's take a listen.
Ms. Epley, we've already ruled on that issue. You may move forward.
Yes, Your Honor, based on the ruling, I will proceed. I'm going to turn your attention to specific silos in the office. Are you comfortable with that term? Do you know what I mean? In terms of MIDI, foreclosure, open records, and branding Kamek or the search warrant.
Yes.
Okay. Turning your attention to the open records request, who was in charge of the division during that relevant time period?
Ryan Vassar.
And do you recall an occasion in which you were asked to collect a file specific to an open records request?
Yes.
What were you asked to do?
I was asked to pick up those documents for Ryan Vassar and provide them to General Paxton.
Did you do that?
Yes.
What, if anything, do you recall about that package?
I recall that it was in a sealed manila envelope and it had a CD with it.
And when you say CD, I know common parlance, but can you explain specifically what you mean?
A compact disc to go into a computer to maintain digital files.
So something with structure to it that would hold additional data?
Yes.
Why do you remember it being there?
Because it was on the outside.
Where did you take that file?
General Paxton.
How long did it stay with General Paxton, or did you collect it at some point?
I did collect it at some point.
How long was it gone? How long was it with?
A week and a half.
After you collected the file, where did you return it to?
Ryan Vassar.
Do you recall during this time frame whether or not you had done any pickups or deliveries involving Nate Paul and Ken Paxton?
The deliveries that I made to Nate Paul took place in May and June.
Okay, and can you tell us about that?
There were 3 occurrences in which I met Nate Paul to pick up or deliver items. The first was to deliver a manila envelope. The second was to pick up the general's phone that he had left at Nate Paul's office. And the third was to pick up documents related to the Mitty Foundation to deliver to Ryan Bangert.
Now, you mentioned the delivery of a manila envelope. Do you recall whether that was substantially similar to the one that you had picked up from Ryan Vassar and delivered to Ken Paxton?
I do not.
Do you recall how heavy or thick the package was?
I do not.
Could you use your fingers to demonstrate for the senators, similar to the way you explained it to us the first time? What is the smallest and largest it could have been?
The smallest that it could have been would have been about this.
I'm sorry, Drew. You want to object? He already said he doesn't remember. Now he's just speculating. Overruled.
Please go ahead.
The way I explained it to the House impeachment managers was this size to this size.
And do you recall whether or not that package had any CDs attached to it?
I do not.
Do you know if it contained any?
No.
So would you be able to tell these senators that it was in any way substantially different than from what you received from Ryan Vassar and delivered to Ken Paxton?
No.
Okay. When we first spoke, do you recall approximately when that was?
May. May of this year.
And did you want to speak with us?
No.
What did you understand at the time, whether you were correct or incorrect? What did you understand we were doing?
My understanding was that there were questions about funding the settlement of the whistleblowers.
And when you arrived, was it subsequent to a subpoena?
It was.
Was that necessary in order to have you attend?
It was.
Did you arrive alone?
No.
Who were you with?
My attorney.
Who is your attorney?
John Evans.
Is he present here today?
Yes.
And why did you retain Mr. Evans?
I retained Mr. Evans 3 years ago after the events that occurred in the fall of 2020. I retained Mr. Evans after being reached out to by the FBI and after being offered counsel by the Office of the Attorney General. I chose to retain my own counsel that would look out for my own interests.
I want to make sure that I understand. At some point, the Office of the Attorney General offered to provide you an attorney?
Yes.
Are you under the impression you had done anything wrong?
No.
Did the Office of the Attorney General indicate whether or not they wanted you to speak to FBI?
They indicated that they would not like me to speak to the FBI.
And you said to protect your interests. What concerns did you have about using their attorney as opposed to your own?
I would assume that an attorney employed by the Office of the Attorney General would look out for the interest of that institution, but not for me.
And did you feel then that your motives or your interests were not aligned?
I didn't know that they were not aligned, but I wanted to make sure that they were aligned to my interests.
Okay. When we had you come in and speak to us in May of 2023, what was your demeanor, in your opinion, when you first came in? Were you forthcoming and happy to talk?
No.
Were you honest to the best of your ability?
Yes.
And was that statement consistent with the testimony you're giving today?
Yes.
And was it consistent with the testimony, or at least the statements you had provided 3 years before that date?
Yes, they were.
I saw you hesitate. Did you correct yourself on your own at some point during the conversation with us?
I did.
What was that about?
The correction was a question by the House team asking me whether or not I had delivered documents to Nate Paul. Over the course of that discussion, I was asked about it again, and I recalled that I had in fact done so, and I have since verified with my attorney and with other law enforcement officials that that is consistent with my testimony from 3 years ago.
Thank you, sir. There was some implication that we had threatened, or I think it was Mr. Busby talking about squeezing you. Did you feel squeezed?
No.
Did we threaten you at all?
No.
Did we lead you or give you the answers?
No.
So when you made that correction, why did you do it?
I did so because I remembered something, and I had misrepresented my testimony whenever I provided an incorrect answer earlier, and so I sought to correct that.
Thank you, sir. I'm going to turn your attention then to the foreclosure, and specifically whether or not you ever heard any conversations involving Ken Paxton related to the foreclosure.
Okay.
Do you recall any conversations?
I recall one conversation.
And what was that?
It was a conversation where I was in Ryan Bangert's office and overheard he and Ryan Bangert discussing...
Sorry, Drew. He who?
General Paxton and Ryan Bangert were discussing the opinion, and General Paxton asked Mr. Bangert if he had been able to reach out and contact an individual. Mr. Bangert responded that this individual had not been helpful in the matter that he had reached out about.
Let me pause you. Not helpful in what way? They just declined to assist?
I'm not completely aware, no.
Okay, go ahead.
The second part of that conversation was in which the general expressed a desire to make sure that grandmothers were not evicted from their homes, and that's where I learned about the foreclosure opinion.
Are you aware that there was a stay related to residential homes at the time?
At the time, I probably was.
So the foreclosure letter would have impacted commercial business, not residential?
Objection, leading, and speculation. Sustained.
I'm going to turn your attention to the Omni Hotel in the summer of 2020. Were you familiar with that hotel at that time?
I was.
And why is that?
During the course of General Paxton's renovations at his home, that's where he was staying in the interim.
Okay, I'm going to come back to the renovations at his home, but help me understand, do you have any personal knowledge of Mr. Paxton being at the Omni in the summer of 2020?
I do.
How's that?
General Paxton called off his protective detail for the time that he was staying at the Omni Hotel, and as part of my job responsibilities, I picked him up and dropped him off each day to the Omni Hotel.
Did Mr. Paxton drop his security detail on few or many occasions in 2020?
It came in spurts.
Help me understand spurts. What would a frequency be?
There were times at which it was highly frequent and I was his primary means of transportation, and there were other times at which we utilized the protective detail.
And while we're on the topic, so that I can move a little faster, what about items being on a schedule? Was everything he did through OAG or personally reflected on a schedule?
No.
Is the schedule supposed to contain the comings and goings of the Attorney General?
More generally, yes.
Why is that?
For the assistance of DPS specifically, I would provide a 2-week outlook on the schedule so that they could understand where appointments were, what time, who their POC was at that place and time, so that they could coordinate security efforts.
And were there occasions in which Mr. Paxton's plans were not contained on his schedule?
Yes.
Specifically related to Nate Paul?
Yes.
How do you know that?
Because I managed the schedule.
Did you have concerns about that at the time?
No.
At some point, did it become concerning enough to you for you to speak to a supervisor?
Yes.
Who was your supervisor?
Blake Brickman.
And why would you go to Blake Brickman about such a concern?
I was receiving some new requests in terms of both transportation as well as documentation and scheduling, and I was trying to understand the best way to handle that with my boss, who was General Paxton.
I'm going to return you back to the Omni. On one occasion, were you there with your family?
Yes.
Can you quickly tell this Senate why you were there and for how long?
My family had come down for a weekend. I don't recall if there was any sort of special significance for that occasion. They were down there to stay there for the weekend. General Paxton was also there at that time due to the renovations being conducted on his home. And they were staying down there, and I chose to stay with them for the time that they were at that hotel as well.
Did you have occasion to see Ken Paxton while you were there?
I did run into him, yes.
Can you please tell us about that?
My mom and sister had gone up to the hotel room. My father and I had run back to my apartment downtown. Upon returning to the Omnia Hotel and entering the lobby, we turned right to go into the elevators. We had pushed the button and were waiting on the elevators, and on the other side of the door, my father and I heard a lively discussion, just to be clear, not adversarial, just lively. And whenever the doors opened, two individuals exited. One was General Paxton. He was in workout attire, and he told us that he was going to the gym. The other individual was in a dress and high heels and exited rather quickly. General Paxton walked out, shook my hand as well as my father's. We spoke for a moment, and then he told us he was going to work out.
Was there anyone else on the elevator for which that lively conversation could have included?
No.
And what, if anything, did you notice about the dynamic between the two, if anything at all?
I couldn't overhear the conversation, but whenever they exited, she quickly exited the elevator, and that was the only time I really saw them interact in person.
Did that cause any concern for you or questions?
It did spur some questions.
And who would you have directed those questions to?
I reached out to Mark Rylander about that.
And why did you reach out to Mark Rylander?
Prior to coming to the office of the Attorney General, I had been informed that there had been...
Objection, hearsay. Sustained.
Did you have reason to think, whether true or not true on the part of Mr. Rylander, this might be something of interest to him?
Objection, yes. Again, Your Honor, she's just trying to ask a different way. This was based on hearsay. Overruled.
Did you have any reason to think this might be of interest to him?
Yes.
And was it?
Yes.
Did he seem to understand who it was you had seen?
Yes.
Did you receive a photograph to confirm?
Yes.
Now, I'm not going to show you the same photograph, but I am going to show you a person. Would you be able to tell me if this was the person that you saw in the elevator?
Yes.
May I approach? So used to government work, I forget we have technology. Can I turn everyone's attention to 704? And Stacy, would you pull up the photograph, please? Do you recognize the person in this picture, whether you know her name or not?
I do.
For purposes of the record, the person being depicted in the photograph is Laura Olson, as established by her Texas driver's license. Thank you, Stacy. May I have 699? Next, Your Honor, the House offers Exhibit 699. It is a business record as established by the affidavit on the face. I'm confident that the page count will match this time, as there's no substantial photographs, and it has been on record for over 14 days. And it is being admitted by agreement, as I understand it.
Any objection?
No objection, Your Honor.
Admit Exhibit 699 into evidence.
Now, Mr. Wicker, I'm not going to have you do this, but inside of an apartment complex application, would it explain where you have lived before and where you're going to live now? I know that didn't make sense. Are you aware of the fact that application leases will establish your prior address as well as your current one?
Yes.
And is the name on that record the same as the driver's license, Laura Olson?
It is.
Is that the woman that you saw step off the elevator with Ken Paxton?
It is.
You mentioned home renovations. Do you remember why those renovations were occurring?
There were storms late spring that caused water damage to General Paxton's Austin home.
Okay. I don't want you to give the address, but could you give us the street name so that we're all familiar with the fact that we're speaking about the same thing?
Margarinita Crescent.
So you said spring. Do you recall what month the damage occurred in?
This probably would have occurred March, April timeframe.
Okay. And do you know where the damage was?
To the best of my recollection, it was confined to the master bedroom.
Why would you know that?
I met with the insurance adjuster multiple times at the request of General Paxton while he was out of town or in other meetings.
So there were occasions where you were authorized on his behalf to conduct personal business, for example, the adjustment of the insurance.
I was authorized to greet the insurance adjuster and show them the home.
Does that mean you would sometimes also receive records related to the home renovation?
I can only think of one occurrence in which that happened.
And what was that?
I received an invoice that I had been included on from the STEAM team.
And are you aware, as the adjuster, that there are some renovations that were done pursuant to the water damage itself and covered by insurance?
I would assume so, yes.
Okay. I'm going to turn everyone's attention to House Exhibit 703. Again, it's a business record. It's Cupertino Builders. There's a business record affidavit, and it's been on file for over 14 days.
Any objection?
No, sir.
Admit 703 into evidence.
Stacy, would you please pull up the face of the email that's attached? Mr. Wicker, do you recognize the name of the individual who sent the email?
Kevin Wood.
And who is Kevin Wood?
Kevin Wood was the lead contractor at the Paxton's home renovation.
Is he someone that you met personally?
He is.
How many times did you see or speak with Kevin Wood?
At least a half dozen.
And do you see that on the to line is the name Raj Kumar?
I see, yes, I do.
And moving down further, do you see that Nate Paul was N Paul at worldclass.com was the person who emailed Kevin Wood?
I do.
Where is that? What are we looking at?
Is the body of that email related to home items or repairs, things that need to be done?
It would appear so, yes.
I'm going to have Stacy then turn to the first couple of pictures in the file. Can we see the next? Does anything about the home being depicted look familiar to you?
Several of these images do appear to be, that's the Paxton's dining room.
Are you wondering or are you sure?
No, I'm positive.
Thank you. On how many occasions were you at the Margarinita home in the summer of 2020 during renovations?
During the renovations, half dozen.
Okay. And do you recall any times that you were present where Kevin Wood and Ken Paxton were both there?
I do.
I'm going to turn your attention to a conversation about the kitchen. Do you recall whether or not there was any damage to that area of the home?
I do not.
Would it make sense then that these are things external to insurance coverage?
It would make sense.
Is that an area of the home that you ever discussed in regards to being an adjuster or assisting the adjuster, rather?
Not to my recollection.
Can you walk us through any conversations you overheard between Kevin Wood and Ken Paxton?
Objection, Your Honor. Anything Kevin Wood may have said would be hearsay.
At this stage, Your Honor, it's not being offered for the truth. It's to set an anchor. I will get more specific in a moment.
Again, Your Honor, the question is very nonspecific, and anything she's going to ask about what Kevin Wood may have said is hearsay.
Your Honor, it is clear from the course of the conversation that Kevin Wood was acting as a service provider. At that point, the truth doesn't matter. At the point in which it does, it goes to his motive, intent, and plan.
Again, Your Honor, you've already... She just said what Kevin Wood said wouldn't matter. I agree. Hearsay and irrelevant.
I didn't say it ultimately wouldn't matter, Your Honor. It will matter very much.
Sustained.
Did you get an idea as to what the relationship was between Ken Paxton and Kevin Wood?
Kevin Wood was the lead contractor on General Paxton's home.
And if Mr. Paxton then wanted additional things or changes to the renovation, whom would he speak with?
Kevin Wood.
Is there any other way Mr. Paxton would find out the timing of renovations or the duration of renovations or the cost of renovations other than Kevin Wood?
Objection, compound, and speculation. She is asking what Ken Paxton would do and what he would know. That's pure speculation.
It's an operative fact, Your Honor. There's no other way for him to know it.
Again, she just asked what Ken Paxton might know. That's speculation.
I'm going to overrule. You can answer if you know.
Not to my knowledge.
I don't even remember the question at this point, frankly. I might have to read it back. At any point, were there conversations about changes to the property?
Yes.
Isn't that the entire point of a contractor?
Yes.
And at any point, were there discussions about particular items in the home?
Yes.
Would what matters to you be whether a counter is granted or not, or whether the renovations are occurring at this stage?
Objection, vague, and relevance.
Did you care what his countertops were made of?
Again, Your Honor, what does it matter whether young Drew Wicker cares about the countertops? It's irrelevant.
Overrule.
Did you care what the countertops were made of?
No.
Did anything about a conversation related to countertops concern you?
Objection, hearsay.
It is not being offered for the truth of the matter asserted. There's no statement. It asks if he overheard something he was concerned about.
She just asked for hearsay right there, Your Honor. That's hearsay.
No, Your Honor, it goes to state of mind.
Overruled.
Thank you. At some point, did you hear something that concerned you?
Yes.
What was that?
Objection, hearsay.
Your Honor, there's three places. One, nucleus of operative facts, because it goes to the center of this. Specific to hearsay, it goes to state of mind. There's no other way for General Paxton to know how long something is going to take or what it will cost other than speaking to his contractor. And finally, it goes to Drew Wicker's state of mind in regards to what he does next because of what he heard, whether the statement is true or not.
Your Honor, we need to know who she's talking about was speaking. I think she's trying to elicit testimony about what this man heard a contractor say who has been subpoenaed and who could come here and testify. This is not the right witness for that.
I'm going to overrule. You're not saying it's the truth of the matter, just the statement was made.
That's at this point, Your Honor. Mr. President, thank you. What did you hear that concerned you?
Kevin Wood stated that he would check with Nate on several of the items.
Now, was that about how long something would take or when something would be delivered?
No, sir. No, ma'am. It was with regards to cost.
Now, if Kevin Wood's a contractor who's trying to make money on his own, why would he need to check with anyone?
Objection, speculation.
Sustained.
So let's back up a little bit. What would he have to check with Nate on specifically? Please tell us in detail what you recall.
He was stating that he would need to check with Nate on the cost of countertops and renovations to the cabinetry in the kitchen.
I'm going to be very specific. Did he have to check on the cost, or did he have to check on, did Mr. Wood seem to already understand what the cost would be?
Yes.
And what was the cost?
He mentioned the total of $20,000.
For what?
For the cabinetry and the countertops.
And what was Ken Paxton's response? That he wanted to do it or did not want to do it?
He stated that he would like to move forward.
And then what was said by Kevin Wood?
He said, I would check with Nate.
Did you relay that conversation to anyone?
I related to two individuals.
Were either of them people who worked above you at the Office of the Attorney General?
Yes.
Were you relaying the information to be salacious or for another reason?
I was seeking advice.
And who did you speak to?
I spoke to Mark Rylander and Blake Brickman.
What did Mark Rylander or Blake Brickman advise you to do?
Objection, hearsay.
Your Honor, Okay. What did you do after speaking to Mark Rylander and Blake Brickman?
I spoke to General Paxton.
What did you say to Mr. General Paxton?
I asked him about the conversation that I'd overheard, and I stated that I walked away with a certain impression.
Pause you. With what impression?
I walked away with the impression that Nate Paul was involved in the renovations of General Paxton's home.
What concerns did you have about that?
Given the fact that we were working on several items related to Mr. Paul, it felt as though there might be an inappropriate relationship there.
Were you that clear with the general?
Yes.
And what happened?
He stated that he appreciated me bringing his concern to him, and that he then assured me that that was in fact not the case.
Did his explanation absolve all concerns?
No.
How did you feel at the conclusion of that conversation?
Still uneasy, but I never discussed it after that with him.
Okay. Are you aware of the fact that we've issued subpoenas for Kevin Wood for him to address these issues and that he does not intend to testify before this court?
Objection, speculation. She just testifying now. Sustained.
Did you spend much time at the Paxton home after that?
Not much, no.
Why not?
It was a mix of ongoing renovations, increased travel, and just lack of requests to be there.
Okay. Did you feel comfortable about the home or being present at the home?
Not always, no.
Why is that?
There were still some lingering concerns over the questions that I had asked the general, but I had not followed up on those concerns.
In the summer of 2020, prior to the whistleblowing allegations, did you have an opinion as to the veracity or the truthfulness of Mark Penley?
Yes.
And what was it?
He seemed to be an individual of the utmost integrity.
And did you have an opinion as to the credibility or truthfulness of Jeff Mateer?
Yes.
I'm sorry, it's not proper for one witness to talk about whether another witness is truthful. That's just not how it works.
It absolutely is, Your Honor.
So please let me finish and quit interrupting, please. Your Honor, it's not proper for one witness to sit up on the stand and say, this person's truthful, that's not how it works. It's improper, I object.
He's absolutely right in a vacuum. I would have no authority to talk about the character of truthfulness as a primary rule, and I wouldn't infringe it. But once he attacks their credibility, Rule 405A1 allows me to establish by reputation or opinion a relevant character trait. In this case, truthfulness.
That's not how it works, Your Honor.
Yes, it is.
Anyway, this is not how it works, Your Honor. You don't get to get up here and bring one witness and talk about the veracity of all the other witnesses. Now, if she feels like Mr. Penley's veracity was challenged on some particular statement, then she brings a different statement to try to rehabilitate him. But she don't do it with this witness.
You can do it with any witness, Your Honor.
Will sustain the objection.
How did you communicate with Ken Paxton in 2020?
Through email and text message and phone calls.
How many cell phones did Ken Paxton have?
He had 2 primary, and he later obtained 2 more cell phones.
I learned through the course of opening that I used the term burner phone incorrectly. Apparently, they have to be cheap and from 7-Eleven. What would you call extra phones that most people don't know about?
Extra phones.
Okay, so two primary phones, 2 extra phones.
Yes, ma'am.
Do you have the phone number of his personal phone?
I do.
And would you give us the last 4 digits of that, please?
The cell phone is 8128.
And what about his work phone?
0220.
Can you describe for us physically what the other 2 phones look like?
The other 2 phones being the extra phones?
That's correct.
Okay. The other 2 phones, one was a Samsung Galaxy Fold, the other was a red iPhone.
You mentioned that you also communicated with him by email. Outside of work email, did he have another?
He did.
What kind of account was that?
It was a Proton mail.
And do you know how the Proton account was set up?
It was set up through the OAG's office.
Why was that?
We went to China.
So it was safer to discuss business on that phone than it would be for a Chinese hacker to get into a personal cell or a work cell, correct?
Yes.
But do you also know that their headquarters are out of the United States?
I believe they're in Switzerland.
And so they wouldn't be subsequent to a search warrant and are not provided as part of a public records request to the OAG.
Objection, speculation, Your Honor. Sustain.
And are you familiar with something called Signal?
I am.
What is that?
It is an encrypted messaging app.
Encrypted, also making it safer, correct?
Yes.
Are you aware that they too are housed out of the country, not subsequent to, or not under the pressures of a subpoena and not provided by the OAG?
Again, Your Honor, this is just her testifying what she thinks Signal is. This witness doesn't know this. It's speculation and improper. Sustained.
At any point, did General Paxton ask to use technology that you provided?
Yes.
What was that?
He used my personal cell phone.
How many times did the General use your personal cell phone?
At least 3 to 4.
Were you able to hear those conversations or who they were with?
I was not.
Were you able to determine after you got your property back why he needed your phone?
No.
Why not?
Whenever I received my cellular device back, the call log had been wiped.
And did he use anything of yours other than your cell phone?
No.
Do you recall after the whistleblowers, Mr. Paxton asking to use your laptop?
Yes.
And what was that about?
That was a request. He was working on a letter to the Inspector General of the United States.
Can you anchor that in time for us? What had just occurred?
This was late October, and this would have been after the whistleblower complaint.
And do you know, what were you asked to do?
I was asked, General Paxton handed me a hard copy of a document and asked me to transcribe the events outlined in the document in the form of a letter to the Inspector General.
And by hard copy, you mean like what I have here?
Yes.
So not handwriting, but typed written?
Yes.
Why would you need to be provided a typed written copy of anything that's already in electronic format?
Objection, speculation. Overruled.
Why would you need to be provided a hand copy of anything that's already in electronic format?
I don't know.
And what were you asked to do? Transcribe, you said?
Yes.
Were you making additions or deletions?
I did make several additions, yes.
What kind of additions?
Since it was asked to be in the format of a letter to Inspector General Horowitz, it was addressed to Inspector General Horowitz. There was a slight introduction that I'd been asked to include, and then this sign-off was asked to be as General Paxton.
At this time, I offer House Exhibit 573. This is part of the Office of the Attorney General records. There is a business record affidavit. It has been on file for greater than 14 days.
Any objection? Do we know about this?
No objection, Your Honor.
Please admit Exhibit 573 to evidence, into evidence.
Mr. Wicker, will you take a moment and look at the body of that letter and let me know if you recognize it?
This is the letter that I was asked to write for Inspector General Horowitz.
So if I turn you to the top where you add Dear Mr. Horowitz, you typed that in?
Yes.
Do you know who that is?
He was or is the Inspector General of the United States.
We've heard about the Office of the Inspector General throughout this trial. Do you know whether or not that's the appropriate person to go to if you want to make complaints about federal prosecutors or federal agents?
That is my understanding, yes.
At any point prior to the whistleblow situation, had Ken Paxton talked to you about or in your presence about the Office of the Attorney General?
About the Office of the Attorney General, yes.
Had he ever suggested going there or that they were the correct place to bring this complaint?
He had not mentioned that to me, no.
In fact, do you know that he didn't want to take it to OIG prior to that?
Objection, speculation.
Overruled.
Do you know whether or not he wanted to take Nate Paul's complaint to the OIG prior to the whistleblowers coming forward?
I do not.
And then once you look at this letter, I'm going to turn you down to the bottom in regards to the allegations made by Nate Paul, and I'm going to go quickly. Did these amount to things like not getting to use the restroom?
It did.
And when you drafted it, did you realize part of Nate Paul's big federal complaint is that he couldn't call his attorney except from using an agent's cell phone?
Yes.
And that he was not allowed to call for counsel, and that's why they provided him a cell phone?
Yes.
Are you aware that the only allegations he makes, well, let me do this differently. Where were you when you were helping type this up for the General?
This letter was written in the Office of the Attorney General.
On what laptop?
My state laptop.
And what did you do with the laptop after typing up the letter?
I followed up with General Paxton about having completed the transcribed letter.
And then what?
And I asked him what he'd like to do with it.
And what was the response?
He said that he had several insertions that he would like to make and that he would let me know about when he needed it.
Did he have you email him or put it into a USB drive?
Not to my recollection, no.
What did he do?
He asked me to bring my state laptop to his Austin home so that he could work on the letter.
And did he make changes to your knowledge?
To my knowledge, no.
Okay. Okay. After drafting the letter for the Attorney General, do you know whether or not the letter was ever sent to OIG?
I do not.
Let me turn your attention then to the conclusion of your career there. What was the status of your job?
The status was that I was both the scheduler as well as the executive aide.
Well, I mean, it's at the end, in October of 2020, leading into November. Were you offered a promotion? Were you offered a change in job function?
I was.
And what was that?
General Paxton had expressed an interest in myself taking on greater responsibilities with regards to certain policy areas, and that I would continue with my present job responsibilities, but also take on the additional policy-related responsibilities.
And at some point you mentioned that FBI had reached out to you and you make Ken Paxton aware of that. Is that accurate?
Yes.
And what did he do?
General Paxton's question that he asked me was, why?
Did you have a response for him?
No, I did not.
What, if anything, did he direct you to do?
He did not direct me to do anything at that time.
Did he take you anywhere?
Not at that time, no.
Okay, ultimately, you say not at that time, so what happens next in regards to that?
The next discussion I had with a member of the AG staff regarding the FBI was Brent Webster requested to meet with me.
And what, if anything, did Brent Webster have to say on behalf of the Office of the Attorney General?
Objection, hearsay, Your Honor.
Sustained.
Was he working in his official capacity as a representative or employee of the Office of the Attorney General?
That is my understanding, yes.
Same question, Your Honor, subsequent to 801 ED, which is specific to representatives or employees. Brent Webster is making the comment to Mr. Wicker in his capacity as an employee of Ken Paxton.
It's the same objection, Your Honor. We've established in this trial, you can't, that's not how it works. She cannot just come up here and ask him what somebody else said other than General Paxton himself.
You can when he's being directed as part of his employment.
He's not an employee of Ken Paxton.
He's an agent of Ken Paxton, so we'll overrule.
Thank you. What, if anything, did Brent Webster tell you?
Mr. Webster said that he understood that the FBI had reached out to me and that I should not respond.
Did he tell you why?
He said that I ran the risk of incriminating myself.
And did he then bring you back to Ken Paxton?
Eventually, yes.
What was that conversation about?
He believed that there was an opportunity to assert attorney-client privilege.
So he too wanted to prevent you from speaking to FBI?
It certainly seems that way, yes.
And were you asked to speak to anyone else about this?
Leslie French.
And what did she tell you to do?
Leslie French advised me that she had been through something similar and that there was nothing to worry about, that the AG's office would provide me with counsel while I met with the FBI, and that there was no need for me to bring my own counsel.
What was your response?
My response was that I would feel more comfortable retaining my own counsel that would look out for my interests.
Why did you respond that way?
Because that's where I would have been that's how I would have felt comfortable in that instance.
After all of this, what decision do you ultimately make about this promotion?
The conversation that occurred regarding the promotion was all at once, and this was actually, I informed General Paxton that I would not be taking the promotion, but I would gladly accept the responsibilities.
Why were you making that distinction?
I did not want the general to have the appearance of having offered me anything in light of the FBI reaching out.
So you were trying to protect the appearance of what that would look like for General Paxton?
For General Paxton and myself.
Thank you. Did you ultimately put in your notice and quit?
I did resign, yes.
Was that on November 2nd, 2020?
If I recall correctly, yes.
Makes sense then that payments would stop, is that correct?
Yes.
And did they stop from the Office of the Attorney General?
They did.
Did they stop overall?
No.
What else were you provided?
I was continued to be provided a monthly stipend by the campaign.
Did you notify Ken Paxton's campaign that you were still receiving money and that you should not be?
No, I had let them know that I was leaving and to cut off my access to both the email and the calendar, and that I should cease receiving stipends.
When did you cease receiving stipends?
Not until the following year.
And what, if anything, did you do with that extra money that you had been provided?
Michelle Smith had sent me a W-2 with that amount. I contacted her, not understanding that I continued to be paid. I asked her what I should do with the money and if General Paxton would like it back. She reached out to General Paxton, who informed her to tell me to keep it. And I stated no problem, and I went ahead and donated the money back.
They told you to keep it and you donated it back?
Yes.
Why did you do that?
I didn't do the work.
How did you feel about receiving money from Ken Paxton's campaign after you ceased employment and in light of all the facts relevant today?
I have no reason to believe that it was with malicious intent. It might have been an innocent mistake.
I think maybe more specifically, I'm talking about your character. What made you return it?
I didn't put in the work, and I did not want any instance. I didn't want it to appear as though I might have any conflict of interest if anything like this ever came about.
Thank you, sir. Pass the witness.
We're going to take a break now, and members, we went longer in this section, so we'll take a 20-minute break, and then we'll go till 12:30. We'll move lunch 12:30 to 1:30 today. So be back here at 15 minutes after 11.
Okay, so we're back. You've been listening to Drew Wicker. He was the former personal assistant and scheduler for Ken Paxton. What you were listening to was the direct examination, and the next time we take a break, we'll play the cross-examination. So we're basically playing this testimony in order. While we wait for deliberations, we're trying to play just some of the more important testimony that we heard. Also want to bring up that our Y'all-itics podcast has done a special I'm stumbling on my words. A special podcast that has the closing arguments, and Jay has put that in the chat, and he'll put it in there again if y'all want to go catch that. Don't leave the live stream to go do it, but later on, when we're not on, you can go watch it. Also the clock that's up on the screen, that's showing that it's been about 5 hours and 32 minutes since the Senate jurors began deliberating, and we haven't heard a word. We just know that they're back there deliberating after they heard closing arguments, and I've got two political stalwarts with me.
No lawyer at all.
No lawyers. Well, I think at this point we're in a political process.
Yeah.
So.
Very much so, and I really think we have been all along, but I think, they're back there going through the articles. Each senator gets to make sure that they know everything they want to know about each of the 16 articles. And then if they happen to know how they're going to vote, they're negotiating like the Senate would on any bill of whether they can get more votes or fewer votes. And if they've disclosed that we don't really know what's going on.
I know. I'd like to be a fly on the wall back there.
Well, that's not legal.
I know. I'm just saying I'd like to be. I didn't say I would be, but I'd like to be.
Well, that's what reporters do.
We're a little bit nosy by nature, yes.
Yeah.
Are we going to know today? The poll that, and I don't know what the latest poll results are, but do you guys think, will we know today?
Well, we don't exactly know, but most of the experts have said that will be done by today. And then didn't our poll, the last poll that
the YouTube experts think we will be.
You know what? I think that Bud described it very well when he said that they're going to be negotiating like they do in the Senate on bills, and then they have 16 to go through. I'm thinking that will be done by tonight. So what do you think, Bud?
I think everybody expects them to be done tonight so they can go to their grandkids' games tomorrow. They could come out any time and cast yay or nay votes, and we would know. But they are still, studying, and at least given the show, given it a lot of consideration, and they're carefully considering their dinner order, I think.
And keep something else in mind too, that Patrick has said you will be here until you do make a decision.
Well, he said that if you don't make a decision by Monday, I'm going to sequester you.
He sure did. So they know that we're either going to be here until it's done, or we're going to go ahead and, cautiously and deliberately and think about it and all of that. But when we're done, it's when we're done, and we'll get a chance to leave.
Yeah, we'll see. So I have a number of people who have sent me questions, and I'm going to continue while we're tap dancing here, because this is really what this is. We're tap dancing. We're waiting. So this person asked, do they have to reach a consensus during deliberations, or do they just have to agree that they are ready for the votes to be called?
That whenever they can ready to vote, they can come out and vote. We'll see whether there's 2/3 or not 2/3.
See, and it consensus in the sense that they have to all agree on something, no, because they're going to vote individually, and they're going to vote either the conscience, what they believe, or whatever. But there does not have to be a consensus in terms of everybody agreeing to one thing.
Right, because it's not a typical jury.
No, but they do have to have each reach a conclusion on how they're going to vote on every charge.
Somebody asked, why was it not brought up that Kamek was introduced to his quote-unquote job as outside counsel by Michael Wynn, his fellow Rotarian friend, when it turns out that Wynn was actually a party to the dispute, aka Nate Paul's personal lawyer? Actually, that was brought up. It was brought up that's how they knew each other, is they were in Rotary together, and they had been involved in some kind of legal thing that Wynn had spoke at. And so it was Wynn who, by all accounts, gave Paxton his name, Kamek's name, to be the person.
He said, here's a talented young man.
Exactly.
Here's someone you ought to know.
Yeah, well, yeah, it was a very interesting selection, to be sure.
He'll have a brand name from now on, though. He'll be well known in Houston.
Yeah, well, I mean, I don't know if this is what you really want to be known for. I'm out of questions, guys. We finally have made it through all your questions. You can email us, teiserer@wfa.com. Probably want to stick with the non-legal questions since we don't have any lawyers on the panel at the moment. It's just an investigative reporter and 2 political experts, but we definitely can try to answer your political or more procedural questions, which means I'll be looking at the Senate rules and making sure I understand what the rules say. Just how hard is this decision for these senators?
I think it's going to be, well, you know what? Those who have, and I think there are some who had made up their minds before they even started the trial, because you did have some who didn't even want to go through a trial. But for those who didn't necessarily make up their mind or were straddling the fence, I think that they're taking it very seriously, and they're going to go through the evidence. They're going to do what is required of them.
I think they've made up their minds and they've had their consultants write their statements. I think they know how they're going to vote.
So then why aren't they coming out?
I think they're killing time. I think they're going through, and there may be a senator who's still cross-checking something or saying, maybe this or maybe that. I mean, if it is within 1 vote, as I've said all along, I think it's within 1 vote, then, they may be trying to persuade somebody to come over to the other side or persuade more votes to come to the 2/3 side.
And keep in mind, they're going to have to go back to their districts and explain these votes. So I think that they're carefully considering those who have not already made up their mind. And I'm not like Bud. I don't think that everybody has made up their mind before the trial started.
What do you think? I mean, at this point, we just have no idea how this is going to go.
No.
I mean, but you still think it's going to be close, right? I mean, Bud, you think it's going to be?
I think it's 1 vote. I think the Paxton supporters for quite a while were putting out a message to bombard a couple of senators' offices because they were the swing votes. And then later there was a message that maybe Paxton had gotten enough to keep his office. But I don't think we can really tell which way the wind's blowing from what the paid commenters are posting on social media.
Oh, I definitely don't. Because you have a number, and I'm not discrediting, listen to me, I'm not discrediting those who are genuinely responding and genuinely expressing their decision, but you have paid consultants,
right,
who work social media. So I have learned in many years that you cannot always put what you're seeing on social media actually what's happening. In some instances it is, but let's go back to the House. You had this campaign when there was considering the impeach.
Did it backfire?
It didn't work. He got impeached overwhelmingly. What was it, 121 to 23? In favor of impeachment?
It was something like that, and
yes.
it was the overwhelming number of Republicans, which shocked me. I mean, I'm not a political expert, so that was shocking to me. Although it was not shocking to Jason Whiteley and others who are more politically connected to it. I was just surprised.
Well, since the Republicans and Democrats voted evenly to impeach Paxton, I mean, let's face it, impeachment is in fashion. You know, we have a former president now facing a number of charges. We have discussion of impeaching the president. You know, we're just getting used to impeachments coming through like tractor-trailer rigs on Central Expressway. And so it's just taken more casually now, and people feel like no matter who's impeached or what they've done, that they have to get in there and fight for what they see as their team or their side. I want to go back to they're saying call senators' offices, and you know, obviously the senators just take the phone off the hook, and particularly now the office is closed and nobody's going to be answering. And it just does no good at all to bombard senators or representatives' offices with phone calls, particularly from outside the district. If the phone lights up and it's not somebody from inside
Well, they're not allowed
the
to have a phone in there right now.
Well, the senators or representatives are not. That would be jury tampering if you called a senator or representative inside the jury room. And their offices are not answering the phone, and they usually don't answer the phone if it's not somebody inside the district. It's, you know, it's a waste of time.
Somebody's asking, do they vote by voice or electronic?
They have to write it down.
They vote by paper
They
first.
paper,
And then they
Poll the
publicly,
jury.
yeah, they poll the jury.
That's what they did during the motions.
Mhm,
Yeah.
That's what they're going to do. They're going to publicly announce the vote, but they have to write it as well.
So somebody's asking if the things that Busby said about Ranger Maxwell during closings are found to be false, can Maxwell sue Busby for defamation? Well, we are not libel attorneys, so I'm not. I don't
Well,
know.
it was Cogdell who said he was like a expired milk carton.
Oh yeah, that was Cogdell.
And
Okay.
I think certainly that would be considered, you know, a opinion about a person who'd inserted himself into the public.
Yeah, I don't.
But you know what though, as we talked earlier, at this point, I think that most of these parties, the whistleblowers, the witnesses, or whatever, they just want to move on.
Yeah.
You know, the whistleblowers want to win their case or get paid.
And get their money.
Yeah, get their money and just move on with their lives.
Well, and every one of these guys, I mean, you know, what's interesting is, and I compare it a little bit to the January 6th committee, every single one of these witnesses, they're Republicans. They're not
Squeaky clean Republican.
Yeah, these are not. These are, in some cases, like with Mateer and Banger, they work for, you know, right-leaning organizations that push, you know, causes, conservative causes. So these are not. Again, these are not rhinos.
Right.
These are not.
They're not.
I mean, these are very,
more
very
Republican
conservative.
than some of the, you know, MAGA militia that will come in support of the defendant.
And handpicked by
Right.
Paxton.
Right.
You
Yeah.
know, by the way, I thought it was interesting. They had several whistleblowers were in the gallery today, but there weren't many other people in the gallery at all. The promise that there would be busloads of people from Collin County, I think there might have been a couple of van loads, but there was no great outpouring of public support in the Capitol gallery.
Does that weigh on the senator's decisions not to see that?
It makes it look a lot easier to vote impeachment.
Yeah. And then the fact
vote,
too that you had
removal.
you had Ken Paxton show up in the chamber today.
That didn't surprise me at all. I felt like the fact that he was there, he almost had to be there. Not because like he was required, but because when his attorney, when Busby and Cogdell are referring to him, you want to be able to point to him and say, that guy, I'm representing him.
He was wrong.
He was wrong, right? You know, and so it made sense. And all the legal experts agreed on this. It made sense not to have him here during the trial if he didn't have to be, because you run the risk of, you know, he rolls his eyes or does something that, you know, is caught on camera or something that, you know, is problematic. But to have him here during closings made a lot of sense, and I actually would have been surprised had he not been here. That would have been surprising to me.
Well, he had to be there, and we said this earlier, Bernadine, but he had to be there so he could stare down the senators that he used to sit alongside in the Senate and work with, and he wanted to be able to stare at each one as his case was heard.
I think he should have been there the entire time. And keep in mind that lawyers, they train their clients. they discipline their clients. This is how you act. And it was not a good optic for that seat to be empty while you had Angela Paxton sitting there having to go through this entire trial. See, remember, you're still talking about politics. And while legally, when you have Ken Paxton missing, where you have all these senators sitting there for 2 weeks, you have his wife sitting there for 2 weeks, and then he's not there. I mean, you have to discipline your client, and he is a client. Well, he's a defendant. But no, I think he should have been there. And you know what I think?
I could make an argument either way.
I understand, but just let me finish this.
Okay, you go ahead. We got
He's not an attractive man, and having him on camera in court does not help your case.
And we have plenty of time. You can talk as much as you want, Bernadine.
What'd you say?
You got plenty of time. You can talk as much as you want. We are not on a clock here.
The viewers out there are going, oh, Lord.
But I just think and then you know what? Also, he was getting blasted on social media. If remember, I sort of discredited that earlier.
Right.
But even if you looked at it and took it at its word, then he was getting blasted that your wife is sitting in there and where are you? Where is Ken Paxton throughout the entire trial? And it's still political, and it still does not look. It just doesn't look like the optics are not in his favor to me.
Right. Yeah. So I've got more. So somebody's asking. Oh, okay, yeah. So we go ahead and
yes.
talk about it.
Well, yeah, this is something he tweeted, I guess, yesterday, the day before. Said he's going to Maine next week. So apparently, he said he's going to Maine to sit down with Tucker Carlson and talk about the last 2 weeks. I can only assume he's not planning to be back on the job since he's going to Maine. But yeah.
Well, I mean, he maybe needs a vacation.
He may need a break. He may get back to work and need a vacation. But you know, his lawyer Tony Busby said, "Let's send the Bushes back to Maine." So I guess that he can get together with the Bushes in Maine, and everybody can have a big time discussing.
Maybe
Texas
George P. will come and Karl Rove.
That's right. All the
and
Maine.
TLR, the TLR. People.
We could have the main outpost of Texas politics.
And you know what? I'm sure that he has his reasons. I really am. But you're going through a trial to save your save your job, and you're tweeting saying, "I'm going to be on a talk show next week." I mean, it just begs to wonder how. And he probably does want people to think I'm not taking this seriously, but
because doesn't want to deign it with, you know, that it basically his position is this is all a witch hunt and. I should never be here to begin with.
But he's wrapping himself in all the national name of Trump and the Trump campaign and the Trump followers. He's just, he wasn't that well known. He did challenge the last presidential election, but he didn't really build a national reputation for it. But this trial and the fact that he's been impeached, that somebody who helped Trump was impeached, has put him more in the national eye. This helps him build more national fame. And he is, becoming a regular on the Trump defender circuit.
So I'm going to run through. We got more questions. Did the House managers pass their findings to the Inspector General or the FBI? We don't know that, but I guarantee you the FBI will be interested because I'm sure they will be.
Well, and we did see that story today that they interviewed. Wicker last week, so they have talked to Wicker for the first time. They're still working on this case.
They're still working.
Yeah, this is not over with by a long shot. Okay, so Matt Yarbrough, who's was one of our legal experts, and who will be back tomorrow, by the way, if this goes into tomorrow. And I haven't figured out my legal guest for Sunday. I'm really hoping it doesn't go into Sunday.
Okay, yes, we should tell everybody we'll see you all tomorrow, bright and early.
Yeah.
Oh, we don't want to speak things into existence.
Let's not speak it into existence. Okay, so political question.
I hope they're here if we're here.
So his political question is for Bud and Bernadine. Will there be any political blowback on the senators if they acquit Paxton of all articles? Specifically, when Ford pardoned Nixon in 1976, he ended up losing his election to Jimmy Carter. There was such blowback that basically he's talking about the blowback that Ford got after the pardoning. Thoughts? on that? I mean, in other words,
I'll let him start. I'll get starting. Because I have my thoughts on that too.
It is very difficult to defeat an incumbent. The senators, remember, are even more protected than the members of the House. I mean, there are so many members of the House, their districts are 1 or 2 counties, and you can, if you find just the right candidate, you can mount a challenge to an incumbent House member. But some of the senators have these giant sprawling districts that cover 17, 20, 30 counties. It's really difficult. A senator who's gone around and gone to every Lions Club and every fish fry and every Little League tournament in his giant district, a senator who's done his job and really built his following, it's very difficult to defeat that incumbent, even if you have someone coming up screaming, we got to get rid of him. He got rid of Ken Paxton. All that's going to be forgotten by March. The senators have the benefit of raising all the money that an incumbent gets to raise. They'll be well supported by, obviously, there's a large faction in the party that wants this to pass. And so he'll be well supported by that faction of the party.
Pass, you mean?
Wants Paxton removed. Yeah. 57% of Texas Republicans voted for somebody besides Ken Paxton.
Sure did.
In the primary March last year. Well, that was 57% of Republicans wanted somebody else.
Yes.
Then he came through the runoff, which is just a tiny runoff, a handful of voters, 600,000, and then came down to the general election with a little funded. The Democrats, of course, as Democrats often do, nominated the wrong candidate. Instead of Joe Jaworski, who would have been statewide support with a statewide bar, they nominated Rochelle Garza from the Valley, who didn't have as much support and was further to the left. And so she wasn't able to mount the kind of challenge to Paxton. So, but 57% of the Republicans wanted somebody else. He doesn't have that much support, and the political. If you think that Ken Paxton has a lot of support, then you're living in the Twitter world and not in the real world.
I will underline that because as Bud
You mean
pointed,
Twitter's not the real world?
Well,
or X or whatever we call it these days?
If you think that what he's saying is not true, you're believing what you're reading and seeing in Twitter. Because as Bud said, remember, he was in a runoff. And then he beat George P. And I think Busby used the Bushes, but he beat George P. Bush, who primary voters didn't want. So I do not think that your senators are going to have blowback if they do sustain the charges. Now,
we could look at these senators that we consider the swing votes. Phil King has been in Fort Worth. He's been a police officer, captain. He's been in Parker County and Tarrant County for 30 years. I don't think a challenger could beat Phil King. I don't think a challenger could beat Flores out of South San Antonio. The senators, and now on Twitter, some of the people have been attacking Senator Kelly Hancock from North Tarrant County. Well, Kelly Hancock now represents this giant establishment district that Jay Nelson used to represent. It has a lot more, business Republican voters who wanted to remove Paxton. So he's not just the North Tarrant County ultra conservatives anymore. And even if you look at, and I know I'm getting local here, but
that's fine.
But even if you look at North Tarrant County, which is kind of a hotbed of Texas conservative politics, that the religious conservatives there were split, and you had groups like Patriot Mobile that's gotten so much attention for its work in school board races. They had nothing to say about this, and Connie Burton was in favor of removing Paxton. And so you had the people, the predecessors, who there was a deep split. Matt Krause, of course, ran against, filed in that race and ran against Paxton. So I mean, the conservatives in North Tarrant County were deeply divided for and against. I think Kelly Hancock would easily stay in office. I could go down a couple of the other. I think Schwertner wouldn't face that much of a challenge. He might face an energetic challenge in Georgetown, Round Rock, but I think he'd ultimately come out the winner. I don't think these senators are beatable.
And keep in mind too, as we have said, ever since they started the impeachment, they take polls, and polling is being done. And I think that they understand where their districts are in terms of where you believe polling, but and if it is going to sway them, that's where they're at their own personal polls. But I don't think they know going in probably where their districts on which side. I just don't see a blowback. And then what they have staggered terms too, right?
They have staggered terms.
So,
only a handful are up next year,
yeah.
and then the other half are up in 26.
Yeah. So that's not. I don't. And all of the campaigning, the pressure that's being put on these senators, I don't think that they're taking it as seriously, and I think they're recognizing it. Don't get me wrong, but then also keep in mind the other issues that are coming up besides Ken Paxton. You know, they have the voucher issue that Governor Abbott has said that he's going to call a special session in October.
And that's about to blow up like a volcano.
Yes. So they're going to be past Ken Paxton. And
what you're saying is you think Ken Paxton will be old news.
Anything that happens in this time of year is very old news by the time we get to March.
Okay. So, political question again from one of our viewers out there.
Love it.
They want to know, are the Democrats likely to be able to take advantage of this schism, the Bush family versus Paxton in the Texas GOP, or is Texas too red, so to speak?
You want to take that one first too, Bud?
I thought you'd want to.
You know what?
I don't think the Democrats are capable of taking advantage of a cinnamon roll on the sidewalk. But.
Well, and then keep in mind, you haven't. You know what?
That's pretty good.
Wait a minute. What are those objections that you stop the train, the strain?
I mean, I'm waiting for somebody to clip that and post that on Twitter.
Yes. And we haven't even heard from Democrats.
Yeah.
Because they're just sitting quietly, and I don't think at this time now someone could come up. But I don't think that that at this point they have someone who could be a serious challenger statewide. And no, and that's one of the things that's probably going to play against Paxton in the sense, if they do sustain, is that they will probably end up with another Republican. It will just be who.
Right.
So the Republicans will keep that seat.
It'll just be a question of which faction that person comes from.
Yes.
Now, let's say, you
talked about the 5 factions.
I think a couple of the prosecutors in this case are Democrats from Harris County, or at least a couple of lawyers who worked on this case. I don't remember exactly which. But let's say one of the prosecutors from this case ran.
I thought Andrew Murr was really impressive.
Well, Andrew Murr is an extremely conservative Republican.
I mean, very, very. I just found him very impressive. I also like the handlebar mustache.
Yeah, I think. There are some Democrats who might have the statewide profile, but it's just very difficult for Democrats to raise money and to have the profile. And Democrats are so fractured in Texas that there's just...
So we've got the crossing guard at Ann Richards Elementary, and what was the one you just said? It was so funny.
Something about a donut. A donut.
A donut. Couldn't take advantage of a cinnamon roll on the sidewalk.
See how messaging is. I walk away with a donut.
Well, the Texas Democrats really, their attendees in Austin is all they really are.
Well, they just basically saying they have no power.
Yeah, they have no power. They can't stop anything really. They are only power they get is through negotiating with Speaker Phelan or President Patrick and Lieutenant Governor Patrick. He does let the Democrats pass some bills. Speaker Phelan works with the Democrats and allows some legislation to go through that Republicans co-sponsor.
Well, he lets some of them chair committees.
Yeah, he lets some chair committees where he thinks it's important, and to bring all voices to the leadership of the House.
But you know what? I don't think it's likely. But where you could see some pushback among Democrats from their constituents is if they voted to sustain. I mean, they voted to not remove Paxton. So, and that's not likely. But because they're not players in this game.
So that's a good question. If Paxton stays, then are Democrats able to do anything about it?
What you mean?
And here's what I don't know, Brenda. You may have looked that up, and I tried to get the answer. I know it's a special election, Well, if he stays, it's not a special election. If he stays, he's there. So
He's there. He's there.
If he's removed, it's a special election. But I don't know whether it's an open all-comers special election or if it goes through the primary system. I haven't looked that up
It's going to
yet.
be part of that 2024. It is
Part
a
of
primary.
2024, it is.
Yeah, I looked it up. It's a primary, and they go into the general.
Okay.
And then whoever wins will take his remaining, the years remaining in his term.
Okay. I thought the governor called a special that it was a wide open special. But
I did too, but when I looked it up, and I think it was on the Houston Chronicle, so.
Okay.
But when I looked it up, I thought it was he could call a special session as well, and there was no, necessarily a timeline. But according to what I read, that it would be part of the 2024 election.
2024. So if Paxton retains his seat, returns to work, then he's not up again until 2026.
Yes.
And at that point, first of all, if he's convicted of a felony, he would not be eligible to run again. But second, we don't know what else might happen between now and then. But if he avoids conviction and is able to run again, then he'd have that choice, and the Democrats might be able to mount some sort of candidacy.
And you know what? Now, here's another thing that's interesting, because if the articles are sustained, he could run for a federal. So he could run for Congress.
He can run for any congressional seat in the United States of America.
He could be a congressional candidate.
There is no restriction at all on Congress. You can run for Congress in Florida, California, wherever you want. And so he could run for Congress, or he could run for U.S. Senator.
Yeah.
Well, I don't think if he were to be removed and barred, that I don't think we would hear the last of Ken Paxton.
Of course not.
That's, absolutely.
But he has backers, but he would have to be able to raise the money. But some of his supporters could view him as unwinnable, and looking for another candidate. But those are speculations that we could look at once we find out what the verdict is. But he has options.
I just don't know. You have something like this, and people always speculate and say, "Oh, he's going to do this, and he's going to do that. He's going to run against Cornyn. He's going to run against Abbott."
No.
Those kind of things never really pan out.
No. If he were going to run for a federal, I can see him going for Congress, but Senate, because Congress he can go into a smaller, but then he would still challenge other Republicans, because he's not going to win a Democratic seat. So he would still challenge Republicans.
And then there are people who think he might be in President Trump's cabinet if President Trump wins re-election. But President Trump kept his distance from him even during the election challenge. Paxton filed those challenges, but Trump never really seized on to what Paxton was doing, didn't really put him on the team, but let him work around the edges. He was at the January 6th rally beforehand as a speaker, but he wasn't really part of the Trump legal team. And now President Trump didn't come out until yesterday and say, "Oh, you got to keep Ken Paxton."
Yeah, there's the tweet that.
Yeah, exactly. It was not until yesterday that Trump came out on social media talking about rhinos as usual and saying, it called him one of the toughest and best attorney generals in the country. Well, when Greg Abbott was attorney general, he was one of the toughest and best attorney generals in the country. The Texas attorney generals are all tough, and they all challenge the Washington establishment consistently.
So somebody's asked, who is the Senate jury foreman? I don't think they would have a foreman.
It's been interesting to see the dynamic on the floor. They don't have a jury foreman because they don't have to reach a consensus. Nobody has to really rally them to do anything, but they have looked at Senator Birdwell when they have questions about what's going on or who's doing what or what time do we come back. They seem to constantly gather around Senator Birdwell, who chaired the committee that wrote the rules. And so they go ask Senator Birdwell, can we make a motion? What can we do about this? Can you ask him about this? And so he seems to be the de facto jury foreman. Senator Birdwell is from Granbury, also represents up into Tarrant County, part of Mansfield. He's actually a 9/11 survivor from the Pentagon who came back and was elected to be senator, and the largest part of his district is Waco. He represents Waco up to Mansfield. But he seems to be kind of the leader of the jury. I don't know if there's anybody as a Democrat who's kind of taken that role.
Because like Senator West was on that committee that created the rules, and you haven't seen a lot of activity from him. But you know what? The one
I've
time
seen him look up a few times.
well,
He's been on
that's
camera.
better than going to sleep on.
That's right.
But you know what? The only senator, other than walking around, he'll tell, and Patrick would tell them to take a seat. The only one that actually there were two, but I do know that Senator Nathan Johnson was one, where they broke protocol, and that's when they announced that Olson would not be testified, and he jumped up.
And Nathan Johnson jumped up.
And so that was the only time that I really saw them breaking protocol. They were dressed properly. They were sitting in their seats. They were trying to not look as if they were not paying attention. And sometimes that I have a very good friend who appears to be asleep and hears everything going on. So, but that's the only time that I actually saw any kind of break from protocol.
So
here's a reporter from a ABC affiliate in Houston who says Senator Schwartner just walked up to his office on the third floor. This is the first time we've seen any of the senators going to the third floor or going to an office. No word yet.
Interesting.
Could they have a break?
I mean, they could.
They might have
it
a
is
break in their
6:02.
deliberations, sure.
It's 6:02. I mean, they might be eating dinner.
Yeah.
So that doesn't necessarily signal that it's over.
I mean, you've got to either bring the whiskey in or go out for it.
Bud, are you making these? Are these original?
I've covered the Texas legislature for 18 sessions. I've seen the whiskey.
We have no whiskey here. We have no alcohol at all. So this person says, "Hi, I'm a Texas voter that has been watching the trial. If Paxton is convicted, will Governor Abbott keep Angela Colmenero as the permanent replacement for AG, or will Abbott pick someone else after the trial?"
That's his choice, but we were just talking that I don't know what they mean by permanent, because they're according to these rules that we read, there will be an election. So he could support her to run for that seat, but she would not be a permanent placement.
I think that, of course, I think Governor Abbott might identify a candidate who would benefit from getting a head start, or he might choose the opposite, which would be to stay out of showing any preference and to appoint a neutral attorney general. She already has, there was one opinion that she refrained from this week because it involved actions of the governor, and she wrote a letter saying, because I'm appointed by the governor, then our office is not taking a position on this right now. So you need an attorney general who can take positions, but I think he's had 2 interims, and he could have as many more as he wants
until the election.
So next question is, I'd like to know from Bud, how involved does he think the West Texas billionaires have been in lobbying the senators in the last couple of weeks?
The last couple of weeks during the time they're not supposed to be lobbying the senators. If they've been lobbying the senators, that is something that violated the rules of the trial. They certainly have a great deal of influence. I know the senators are aware of how much influence they have, and what the viewer's talking about, of course, is Tim Dunn of Midland and Ferris Wilks of Cisco, who contribute millions of dollars of their oil field wealth. Tim Dunn from oil and Ferris Wilks from oil field supplies. And then contribute multiple millions of dollars to elect hand-picked candidates in certain districts. They find a House or a Senate district that they think that is weak, and they pick a candidate and plant them in that district, and then they put $6 million behind their campaign. They defeat all the local people, and then basically that representative senator works for Tim Dunn and Ferris Wilks instead of working for the people in that district. Of course, they donated the $2 million to Lieutenant Governor Patrick over his career, and a tremendous amount of money to Attorney General Paxton. They are ardent supporters of faith and values conservatives up and down the line, and so I think that the people in the Senate who listen to them constantly certainly are aware of their influence here. I think I saw the list of who gets how much money, and I've forgotten who in the Senate gets the most money from Dunn, Wilks, Texas Liberty. Jonathan Stickland handles the money.
I'm going to let y'all keep going. My kid's calling me.
Okay.
Y'all keep going. I'm going to go
Jonathan Stickland handles the money now for the Wilks brothers. But I've forgotten who gets the most money. But it's interesting then who gets the least money. And some of the people who are the swing votes are the people who get the least money from Dunn and Wilks. And so I think that they have a tremendous amount of influence on everything in Texas. And I think that there has been some great reporting done on the influence of the West Texas oil money on the conservative movement in Texas and how it has pulled Texas Republicans further to the right by electing more conservative candidates in hand-picked districts. But I can't say that money is directly affecting this decision. And Dan Patrick has not seemed to be partial at all. Dan Patrick has gotten better as the trial went on and actually acted like a judge the last few days several times and seemed to keep order in his court, and it seemed like pretty good for an old broken down ex-sportscaster. He looked great.
And then, and to add to that, they might not be lobbying senators, but they are financing organizations such as the Texas Liberty, who are out there trying to influence their vote.
Texas Liberty, Empower Texans, Texas Work Hard. There's about 5 organizations. There's a gun organization, an abortion organization, a homeschool organization. There are about 5 organizations that all spend Dunn and Wilks money.
Yeah, and they're actively trying to influence the vote, not necessarily going to those senators individually, because as you say, that's against the rules, but they are spending a lot of money to try to influence the vote.
They're going to the senators' consultants. Every one of these senators has a consultant. Most of the senators who voted against the motions who voted for the motions on the first day, trying to dismiss the charges, all have the same consultant out of Houston. It's also Dan Patrick's consultant.
Yeah, that's
and
true.
so the one exception was Senator Flores, who
So you think that
voted
was
the
all
other
pre-planned?
way. I certainly think that was kind of going along with the team.
Right.
And then there was obviously a couple other consultants whose candidates voted against all the motions. So there are about 3 or 4 major consultants in the Senate, and so they've all talked with their consultants about what to do, where the money will come from, and how to run their next campaign.
Yeah, so the money is influencing, it's just not being directly, it's not directly going into the campaigns of senators.
Alan Blakemore in Houston is the consultant for Lieutenant Governor Patrick, and also the consultant for 5 of the 6 senators who voted to throw out the whole, all the articles. So and that's why in the beginning we thought, well, maybe people are expected to all be on the Dan Patrick team. But Dan Patrick's been very open-handed. I don't think he's made anybody feel like they're pressured to take one side or the other, and I think that I even wonder if he still feels the same way he used to about Ken Paxton. I told Tanya the other day, I think that people of deep faith, like Lieutenant Governor Patrick, who's written a Christian book and obviously comes from a strong Baptist background in Houston. I get the feeling some of them may feel like that Ken Paxton, General Paxton, is no longer a useful witness for faith and Christianity, that he is not able to to win souls or witness to others like he might have at one time.
That's true.
So, continuing to go down these questions.
Sure.
Because these folks have questions.
Okay.
Somebody was asking, do we know why Michael Gerhardt was never called again by the defense? He was the guy when Rusty Hardin rested, and then the defense opened, they called this guy named Michael Gerhardt, who was an constitutional impeachment expert. I don't recall they ever really saying why.
The prosecutors objected.
And I think it was just that.
And he all went away, and we never found out why the prosecutors objected. Yet maybe they would say that he doesn't know anything about the Texas Constitution, so he's not relevant here.
I mean, yeah, because when I read up on him, he definitely knows a lot about impeachment, but on a national level.
Impeachment on a national level, which involves high crimes and misdemeanors, which is not the least bit involved in the Texas Constitution. The Texas Constitution and the Texas Supreme Court said impeachment only requires delinquencies or maladministration. We can impeach a lot more people than Congress can.
But I wondered the same thing.
So we've got Teresa Woodard and Jason Wheeler, who are in Austin, joining us via video call. Wow, you're together.
Look at
both
that.
Of you.
Yes, we're sharing one set of earbuds. You see this? We each have one.
Yeah. And Jason came up with the genius idea. I've been holding my phone out on my arm for hours at a time, it feels like. And Jason came up with the idea to, raise a stand and put it up there. So we're in good shape now.
So what are you guys
Can you hear
hearing? So what are you guys hearing there?
Nothing. It's been crickets for quite some time here. It's been
Literal crickets.
Literal crickets. There are a lot of crickets here in the Capitol. I tweeted out about this earlier. You just see them all over the place.
It rained in Austin, as it did in Dallas for the first time in quite a while, and that just meant an invasion of crickets inside the Capitol.
But we've had figurative crickets as well. We're more than 6 hours now into deliberations by this Senate jury, and nothing so far. And again, they'll be sticking around until at least 8 o'clock tonight. They could decide to go further than that. I'm dying to see if they end up still here on Sunday night and the lieutenant governor saying that he would sequester them in that case and they'd sleep in their offices.
I kind of wondered, you guys probably have talked about some of the, it's hard to call them jury instructions, but that's sort of what it felt like to them. And they talked about you cannot have your cell phones, you cannot have computers, you cannot have laptops, you cannot have a staffer inside that room during deliberations. And so from my perspective, I thought, well, that's going to push them along to go a little faster. But here we are, 6:15, they started deliberating right about noon. Of course, I don't know if they broke for lunch, but anyway, I was sort of expecting that we might have an answer tonight, because in my head I was thinking, Friday Night Lights, Saturday college football. Also, it is Rosh Hashanah, and so there may be some members of the Jewish faith who wanted to be home with their family. We're in services tonight and tomorrow morning, but here we are approaching sundown, and we've heard nothing.
And one other thing, Tanya, real quickly, I am, and I don't know how many of these senators are going to be in the mood to stick around after a verdict is announced and after the vote is announced. I don't know how many of them are going to be sticking around to sort of walk through the process of what happened here. And everybody here is wishing that they were sort of a fly on the wall in that room. And
or a cricket on the floor.
Yeah, or a cricket on the floor, although a lot of those haven't fared so well. They're not doing so great on the floors. And so, I think a lot of us are just, dying to know what's happening in that room. And if the senators are not really in the mood to talk a whole lot afterwards, do we get that full picture? But there is this little stipulation down in all of these rules that they came up with for this trial. And it says that a senator, when they go out to the floor and they cast their vote, they've got to do it without saying anything. They just write down what they think, and it gets
yay
read,
or nay.
and then yay or nay. But for 72 hours after that vote, they can still take their full written comment about what happened, what they thought, whatever, and give that to the clerk, and then it becomes part of the official record and goes into the journal. So within 3 days after whatever the verdict is, we might be reading some interesting narratives about all this.
Yeah. And I think, so many times when we're watching even a criminal trial, you try to read into, well, if it's taking longer, what does that mean for the jury? Is that good or bad for the prosecution or the defense? And, I don't know. I don't know in this instance.
We've been talking about that all afternoon, and we can't really come to a decision on who does this benefit here.
No.
And a lot of people had talked about this before today. Of course, Ken Paxton showed up on that very first day when the trial began. He was here for the morning. Lunchtime hit. We didn't see him again after that. The House questioned that. The House managers, the prosecution questioned that. They looked in the rules and they were like, well, lo and behold, it says he has to be here at 9 a.m. and enter a plea. And then it doesn't look like it says he has to be here anymore after that. But then there he was again today as closing arguments were being read.
And you were inside the gallery. I was out here near the rotunda sort of watching things and manning our camera, but you were inside and you said you could read some body language.
Yeah, he was sitting there, he was listening, he was very attentive to what was being said by both sides in the closing arguments. Our photographer actually said it looked like he was timing how long they were taking because each side only had 60 minutes to give their closing arguments. He looked a little tired to me, but that's probably to be expected. I think we all look a little tired after these past couple of weeks. I just thought it was interesting that he was here today, especially if he was not required to be here today. What does that say? Is that, signaling to the jury that, yes, I do take this seriously? Some people have criticized that he hasn't been here for his own trial. And what message does that send to these jurors who, by the way, are also senators? And they've been through a whole legislative session. They've been through some special sessions. These are part-time legislators. They have actual jobs that they're not able, to necessarily get to. And they still have more special sessions ahead. So, they might not be in the best mood having to sit through this trial. And he wasn't here for much of it. And there was some conjecture that maybe he would show up on the final day if he thought that he had the votes for acquittal. Again, that's just speculation. People saying that he probably wouldn't show up if he saw it, that it wasn't going to go his way. All of it's just speculation, though, just like we've heard a lot of speculation that they're going to come back immediately, or no, it's going to take them 4 days. Nobody really knows.
I don't think there is any way to know. And I was frankly not surprised to see him today. I think that his attorneys, based on what I've heard from legal experts, would want him there. You can point to him and say, we're here defending this guy. We back him up. We think there's no evidence. He is ready and willing and can't wait to return to his job. And so I think that's why you would want him there. I could also see reasons why you wouldn't want him there during testimony in terms of, if you just glance the wrong way, or you roll your eyes, or you make the wrong facial expressions, we'd all be trying to read the tea leaves the whole time had he been there. So I could, in terms of talking to some of the legal experts, I understood the decision not to have him there. I think the question is, what are the senators having for dinner?
I talked about that with somebody earlier, because obviously they've got to order in. And we were, maybe it's because we were hungry here at the Capitol. And so we were like, what could they be ordering in? And, we're kind of going through this and wondering what their per diem is. Do they have a per diem? But yeah, it looks like they're going to be sharing at least one dinner in these deliberations. We don't know.
Is it pizza?
Will they be having breakfast together too, and then another dinner, and maybe another?
Right.
Nobody knows at this point. But you got the sense there was kind of an interesting buzz in the room. First of all, when we got to the closing arguments, that room just felt electric in there, and boy, those crickets were loud, and I'm not kidding. Even inside the Senate chambers, but the people in there were buzzing as well. And then it got really quiet during part of the closing arguments, especially when Representative Leach was up. It just felt like the whole room just got heavy and shut down.
And I felt like also when Lieutenant Governor Dan Patrick began, as I called it earlier, sort of the jury charge, that felt as if we all understood the gravity of the moment, and I mean, we had just been through, almost whiplash from how different those closing arguments were. You had the brash, loud Tony Busby, and then you had the more methodical, surgical Andrew Murr, and then you had Jeff Leach come in and just give that really impassioned, personal testimony almost. And then to follow that up with Dan Patrick describing, like I said, sort of the gravity of the moment. I don't know. It did feel like you had this swing of emotions, and when they went in to deliberate, it was serious. And I don't know that I expected to feel that at that moment.
Yeah, you almost expected a relief among the senators, but you didn't get that feeling. It felt weighty in there. And I will say, before they took off and left the room there, when Dan Patrick was giving all of the instructions and so forth, at the end, it was almost like a judge looking over the glasses moment, like, take as long as y'all need, really. You'll be here for this hour and these days and these days. But if you go into Sunday night, I'm really considering that you're going to have to stay under the dome until we get this thing done. It was almost that look like, then it's going to really be time. It's time to wrap this up.
Nobody wants to sleep on the cot or the couch.
Right. And this does have to come to a conclusion. There is no mistrial here. It's got to come to a conclusion. And, interesting thing, and I know this has been discussed by some people, it's not something that can be undone and clawed back. The governor, if Ken Paxton is convicted, the governor cannot just come in and pardon him. That's not possible in a case like this.
Right, because it's not a criminal proceeding.
Right.
It is ultimately
a political.
It's political.
That's all it is.
Yeah, and for people who don't necessarily know how to distinguish because they've been following a lot of the rules of criminal procedure, I say the most interesting way of looking at that is to look at the jury. This is not your typical jury. You think about the lobbying that has been done up to this day to get them to go one way or the other. There have been ads that have been run in some of their districts targeting them. Donations have been made. And usually when you sit on a jury, you don't go in and think, well, depending on if I vote for guilt or innocence, I may or may not have a job for much longer after that. So it is very much political. It is very much a different animal than any of the rest of us are used to if we've been to jury duty.
Well, and generally, when you're on a jury, you don't vote on motions. I mean, that just there, that's very unusual. There's nothing about this that is typical or normal, although it has some of the trappings of a criminal trial. And you wouldn't normally have a presiding judge that's not a lawyer. So it's all the things.
I'm curious, Bud and Bernadine, can you guys hear us?
Yes.
Okay. I'm just curious. I know, Bud, you've talked about this, and I'm sure, Bernadine, you've had conversations, but based on the votes that were taken during the motions early on day one, the senators, the Republican senators who said, yes, I want to go ahead and go forth with this trial and not end things right now. Who are you keeping your eyes on the most?
Well, there were 6 to 8 senators who, depending on the motion, who wanted to discontinue the trial. I think that told you a little bit about who was staunchly in Ken Paxton's corner. I think since then, there's probably been one more who's joined him. It's the senator from Midland, and Senator Sparks from Midland probably is staunchly with him. So I think we probably have a core of 7 to 8, but I'm not sure he has the 9th or 10th. I've said several times today that the senators to watch are probably Senator King from Weatherford Parker County, Senator Flores from San Antonio. They both have a law enforcement background, so it'll be interesting to see how they respond to the attacks on law enforcement. And I'm not sure that those attacks on law enforcement worked well for Tony Buzbee the way the votes fall. There are a couple other senators. The Twitter sphere seems to think that Kelly Hancock from Tarrant County has a swing vote. I wouldn't think he would be suspect to flip is what I'm trying to say. But I think that there are a few senators right in the middle that we're definitely watching the most.
I agree with you on that Tarrant County point there, Bud, but as well as anybody covering that county forever and a day, that county is an interesting animal politics-wise, especially in recent years. And so you wonder how much of that is being calculated, by all of these senators with their districts.
I'm just still not sure how long of a memory voters would have on this. I'm not 100% sure that people would lose their jobs because they voted one way or another. However, they could get a primary opponent, and that is a whole other beast.
And potentially a very well-funded primary opponent, just depending on who is behind that. So I'm sure that all that calculus is being done by each one of them, which again, points out what a different kind of trial this is. When that's part of perhaps your decision making.
Right.
Yeah, in fact, Bud and Bernadine and I were talking about that earlier, about how that very issue, and both of them were saying that they actually thought that these senators would survive that they would be able to power through it.
It all blows over by March, and the senatorial districts are much larger than House districts, so it's much tougher to attack an incumbent in a senatorial district. They have more money. They've gone around. They've gone to all the chicken fried steak dinners and Kiwanis clubs and pancake suppers and everything else, and they've just had a lot of time to get to know people all around these gigantic districts that they represent.
Well, and also, there are going to be more issues that they're going to have to battle over, such as, remember, you have the voucher issue that's coming up potentially in October. So by the time this is over, I think that the senators, their voters, the constituents will be looking at other issues.
I wanted to
go ahead.
Oh, go ahead. Just some people here were talking about how we're sort of in the throes of election season here again. There's fundraising to be done. There's events to attend, and because of that, they were thinking that, well, this thing's probably going to wrap up pretty quickly because they've still got special sessions ahead, perhaps maybe multiples, and before you know it, we're to the primaries, and they may want to get some campaigning in or some fundraising in, or at least be seen in some places, and so they were surmising that maybe that would mean that we get to a quick verdict, but who knows if any of that's true. Again, it's all just speculation until we finally see it all play out. One thing I was interested in, though, today, when those closing arguments were being given, they were referring back to previous testimony, especially the prosecution. It was showing on those senators' screens. They were looking down. They were paying attention. And I saw a lot of them with their legal pads out during those closing arguments, taking lots of notes. And so you wonder, so many of them are attorneys. You wonder, when they get behind closed doors, again, a totally different kind of jury, are they sort of presenting their own version of the case to try to convince their fellow senators?
And I wonder too what kind of pontificating might be going on. I mean, you have people who love to talk and love to hear themselves talk, or they wouldn't be in the positions that they're in. And so
it's like a room full of Tanya Isers. I mean, it's nuts.
Oh, please! What about a room full of Jason Wheelers?
Know anything about that? That sounds horrible, though.
Let's just say a room full of Jason Whiteleys. He's not here to defend himself, so let's blame that.
You can tell we're all getting tired because we're starting to get.
I don't know what to think.
Starting to get tired. I mean, we are tired.
This is turning into a cream pie fight here. I'm not sure what to think about this.
Oh, mercy.
Oh, gosh, guys. Well, it'll be good to see y'all on the other side of this. No matter how it turns out. So
it'll be good to see daylight after this. Somebody just came in a few minutes ago. It's really weird, and I'm sure all of you have been in the Capitol, covering things. It's a really weird place. I mean, it's a beautiful place. It really is. But it's got this lighting. It's got this really dim lighting. And,
you feel like it's like 8 p.m., 24 hours a day.
You're drawn to this middle part here. You don't see a lot of exterior windows and such. And so you forget that it's daylight outside. You forget that you're on Earth. You know what I mean? And somebody came in and said, it's really nice outside right now. And I was like, well, yeah. Outside still exists and it's daylight.
I'm thinking I'm pretty low on vitamin D right now.
So what are these senators feeling like?
I did wonder that. There are so many different rooms in the Capitol complex. I don't know. None of us know exactly where they are right now. Can they see the light of day? Can they see that it's a beautiful evening outside and they want to get out and enjoy it? Or are they inside a room and they've lost track of time too?
Jason, Teresa, if you can still hear me, I hate to break it to you, but there are photos of Senator Shortner out taking a walk around the Capitol grounds, so he's out getting some daylight. Senator Nichols has gone up to his office, but Senator Shortner is out having a little stroll.
And
do we know when those were taken?
Do what?
Do we know when those were taken?
I can go back and look. It looked like it was just a few moments ago.
And they can't deliberate without them all being in the room, right? I mean, at least that's normally how it is with a jury. Normally, they all have to be in the room in order to deliberate.
I don't know that answer.
Well, you know what? These are bendable rules.
Yeah.
I mean, I think we've learned
They voted on their own rules.
I know. I mean, they weren't supposed to. If I remember correctly, I think that the rules originally said they could not have their phones with them on the floor of the Senate gallery, and I could see people flipping through their phones while I was in there watching just yesterday. So, as I said, maybe we've got a little bit of wiggle room here.
Well, that's the way it is when you vote on your own rules,
yeah,
too.
it's true. It's true. Yeah.
I want to vote on my own rules.
Yeah. Jason, we need to start a rules committee.
Why can't we do that? just you and me. You and me.
Right.
We're going to have the rules, Tanya.
We'll let Teresa be on that committee with us. She can be the chairperson.
I'll join.
No, Teresa's way too responsible to be a part of that.
I think I'd be a good rule maker because I'm a silly rule follower. That's my problem.
See, that's our problem. That's why we wouldn't want you there.
I would be sitting in that room deliberating and never take a bathroom break because I didn't think I was supposed to because it wasn't in the rules. That's
aren't rules made to be broken?
They are.
I know.
That's how I approach life.
Yeah.
Anyway, all right, guys. Well, appreciate y'all joining us. I'm sure we'll talk again. So
yeah. Well, let's see, 6:30.
We may talk again for days.
We could. All right.
Awesome.
Thank you.
We'll see y'all soon.
Thank you.
Bye, y'all. Good to see you.
Bye, guys.
All right. Okay. Well,
I didn't want to cut in and break it to them. They were saying, who has the advantage if the jury continues deliberating? I don't think there's any question the caterer has the advantage. The caterer is the one who's making big money, bringing in dinner for these senators. That's who gets the advantage.
Yeah, that's true.
I still think they're probably eating dinner, but that's just my opinion.
Shortner, this is 9 minutes ago, Shortner was out with it looks like a woman walking around the Capitol. And I don't know, the significance of wife or daughter, but it looks like he's out taking a stroll around the perimeter. And then there are other videos of Senator Nichols going to his office. So I think some of the senators may be loose.
Sounds like it. I mean, and like I said, I read through the rules, and I don't know if the rules said they all have to be in the room all the time.
Right.
I'd have to go back and look at it again. Okay, so I don't know about y'all, but I'd like to take a break.
Please.
Okay, so we're going to
I see that the caterer brought our dinner, I see.
Well, yeah, we're going to have to get some real food. So we're going to restart Drew Wicker, and we're going to start with the cross-examination of Drew Wicker.
For acquittal or conviction, if you vote for conviction, it automatically prevents the Attorney General from serving in office. Again, they want to combine that. That's what the motion is. It has to lay out for 24 hours. It's 11:30, so we would not take it up until 11:30 tomorrow, and that will come to you to do with as you decide. You can table it, you can take it up, whatever you decide. So I wanted you to be aware of that motion because that's the proper procedure if the parties are making a motion to bring it to me and for me to share it with you. Mr. Busby.
Thank you, Your Honor. Is it okay if I call you Drew? Turn your mic on there.
There we go. Is this better? Yes, sir. That is okay.
You don't think I'm being disrespectful?
No, go ahead.
We did speak on the phone a couple of nights ago.
Yes, sir.
Okay. And you also talked to these folks over here as well?
Yes, sir.
Okay. I want to clear something up. When you were working as an aide to General Paxton, you were getting paid not only from the state, but also from his campaign.
Yes, sir, that is correct.
Because you were doing some things, not only for the state, but you were doing other business for General Paxton.
Correct.
And so it would make sense that you would be paid by both entities.
Yes, sir.
And as I understand it, you were getting paid direct deposit by the campaign?
Yes, sir.
Okay, so just to clear this up, when you decided to leave the AG's office and go and work in your family's business, somebody forgot to turn off your direct deposit from the campaign.
Yes, sir.
It wasn't somebody like still giving you checks. It was just an automatic direct deposit.
Objection, speculation.
I mean, you know how you're getting paid in your own bank account.
I'll sustain the objection, but you can ask again.
You know how you were getting paid. It was a direct deposit into your bank account, wasn't it?
That's correct.
And it just continued until you raised the issue and then you gave the money back, right?
Objection, speculation.
We've already heard from this.
Overruled.
Isn't that what happened when it was figured out? General Paxton said, well, just keep the money, Drew, and you decided, no, the better thing to do is just give it back to the campaign, right?
That is correct.
Okay. You talked about 3 lunches in your direct, did you not?
I did.
These were at restaurants?
Yes, sir.
In a public place?
Yes, sir.
Was anybody hiding or in a secret dark back room?
Not to my knowledge.
Anybody that walked in the restaurant could see General Paxton there, could see you there, could see whoever he was having lunch with there, right?
That is correct.
Wasn't anything secret about that at all, was there?
No, sir.
Okay. I want to make sure the members understand, Drew, because this is some things that you not only told the House when you were interviewed, but you also told me the other night on the phone. When you were working for General Paxton, you almost considered him family, didn't you?
That is correct.
You have no animosity towards the Paxtons, do you?
I do not.
And you told me you love the General, right?
That is correct.
And you also said you appreciate everything that General Paxton did for you.
Correct.
The Paxtons used to joke that you were a second son, didn't they?
They did.
You told me that you and General Paxton were very close.
That's correct.
Are you accusing, and I don't think you are, I just want to make it clear, because you were probably with General Paxton more than anyone else during that time frame that you were working for him, weren't you?
Yes.
I mean, I want to make it clear. I think that the senators know, but just for the public, sometimes you would be what's called a body man. You ever heard that term?
Yes, I've heard that term.
Yeah, and basically you're with your boss all the time until he releases you for the day.
That is correct.
So you would have been spending more time with General Paxton than anyone else, right?
Yes.
More so than even his wife, Angela.
Yes.
You're not accusing him of bribery, are you?
I'm not.
Let's be clear. The guy that spent more time, and that's you, Drew, with General Paxton than anyone else during the time frame that we're here to talk about is absolutely not accusing General Paxton of doing anything wrong at all, are you?
I'm not accusing anybody of anything, no.
Okay. You also were with General Paxton when he traveled, right?
That's correct.
And just so, and I know you've read some of these press reports, haven't you?
I've done my best to stay away from any sort of media. I've had some people say some things to me, but I've tried to shut that down as soon as it's come up.
And I know it's hard to ignore some of this stuff in the newspaper, but you know that there's been an allegation that General Paxton had a secret email address?
I believe you mentioned that to me on the call the other day, yes.
And you and I know that the reason he had that Proton address, that email address, was because he was traveling to China.
That is correct.
And the reason and that was something set up for him by the IT department at the Office of Attorney General.
That is correct.
And that email address was to prevent the Chinese from hacking into his into his email, right?
Correct.
Okay. And other people in the office had that same type of email address, didn't they?
I don't know how many others, but yes.
Okay. You remember the suggestion of burner phones?
Miss Epley mentioned it earlier, but yes.
Yeah, it was, and I know you probably haven't been reading the newspaper, but let's just go ahead and get this out of the way. If a burner phone is a phone, a plastic phone that you can buy at a convenience store with a certain amount of minutes, and when it's over, you break it and throw it in the trash. General Paxton never had anything like that, did he?
Not to my knowledge, no.
He never had any burner phone, did he?
Not under that definition, no, sir.
Okay. You told the House you could not speculate as to what relationship Nate Paul had with General Paxton. Isn't that right?
I stated that I believe that they were friends, yes. But I wouldn't speculate beyond that.
Yeah, that's all you know, right?
Yes.
Okay. One thing you do know, that you never were in the presence of General Paxton when he and Nate Paul made any kind of agreement. Isn't that right?
That is correct.
I mean, let's be clear. They've been throwing around this word conspiracy for literally a week and almost a half. And you were the man who was with General Paxton more than anyone else. And you can say definitively, you never saw Nate Paul and General Paxton reach any sort of agreement whatsoever. Isn't that right?
No, sir.
Is that right?
For the conversations I was privy to, that is an accurate statement. Yes, sir.
Okay. You don't have any actual knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that right?
That is correct.
Let's be clear. The man that was with General Paxton more than anyone else is testifying under oath that you have no evidence, no knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that true?
That is correct.
Now, you have seen some speculation in the newspaper and the press, haven't you?
Prior to this trial, yes.
Yeah, and I want to, and I'm not picking on you, Drew, because I think you can tell that I'm fond of you and I like you. But I want you to know that this whole idea of the house renovations, everybody says it came from you. Do you know anything about who paid for General Paxton's home renovations?
Not directly, no.
All you have is one stray comment, right?
Across multiple instances, yes.
And you were concerned about it and you went and raised it with your boss, right?
That is correct.
And he was very clear with you. That is not what's going on here. Isn't that right?
That is what he stated to me, yes.
Okay. When you interviewed with the house managers, did they ever bother to show you the receipts, bills, payments related to General Paxton's house renovations?
No, sir.
They are in evidence. Did you ever go with General Paxton and Senator Paxton when they went to Home Depot?
No, sir.
When they went to Lowe's?
No, sir.
When they went to a different Lowe's?
No, sir.
Were you ever with them when they were pricing sinks and countertops?
No, sir.
You did say in your testimony to the House that General Paxton's, I don't want to use the wrong word, but he's close with his money.
Yes.
I don't want to call him cheap because he's my client, but he pays attention to what he spends.
The word I would use is frugal.
Frugal, good word, okay. You believed, based on what some people have told you or maybe what you read, that General Paxton got granite countertops?
That was what I read in one news article, yes.
Okay, let's let that sink in. And when you read that, and when you connected it to the statement you say you heard, you thought, well, there it is. General Paxton got granite countertops paid for by Nate Paul, right?
No, sir.
You still didn't believe that, did you?
No, sir. In terms of the timing, I had already made my statements to the House committee, and the article that I read and am referencing now, I believe, came out after that.
Okay, and I'm not talking about that. I just want to make sure that at some point in time, you believed that General Paxton had gotten granite countertops, right?
I had heard that. I don't think I believed that. No, sir.
Do you believe it now?
No, sir.
Let's pull up, Eric, if you will, Attorney General Exhibit 371. You told us you had been in the kitchen of the Paxton's home in Austin?
I was.
And that's in Terrytown here in Austin?
That is my understanding what the neighborhood's called, yes.
Okay. Can we pull that up, Eric, please?
Objection, Your Honor. Is this already in evidence? And he hasn't established the relevant time period, whether it was before or after?
I've already said this is in evidence, Your Honor. It's AG 371.
Overruled.
Now, this picture, sir, was taken a few days before this trial started. Do you see the countertops?
Objection assumes facts not in evidence.
It's already been proved up, Your Honor. We'll do it again.
It has not been proven up. It is a photograph, and it depicts exactly what it reports to until or unless he lays a predicate for someone who can say when it was taken.
If I could keep going, Your Honor, we'll do all that. Sir, do you see the kitchen, the Paxton kitchen there?
I do.
Do you see the countertops?
I do.
Are those the same countertops that you saw when you were in the Paxton kitchen?
Prior to the renovation, yes.
Okay. Do you realize that that's the same countertops as they exist today?
Objection, facts not in evidence. He doesn't have a predicate for that, and he's testifying to the Senate.
Your Honor, this has already come into evidence of the current picture of General Paxton's kitchen. It's already in evidence.
Mischaracterization of the evidence, Your Honor. The photograph is in evidence, but what it depicts has not been established, and Tony Busby does not get to, no matter how hard he tries, establish the time frame in which it was taken.
Again, sustain. Is this how the kitchen looked when you were in it?
Prior to the renovations, yes.
Okay, do you see the countertops?
I do.
Do you see the stove?
I do.
Do you see the cabinetry?
I do.
Okay. Do you know how often the Paxtons went and priced new stoves, new countertops, painting the cabinetry? Do you know?
Objection assumes facts not in evidence. We don't know that they did that at all.
I'm asking him, Your Honor. How can I establish if I don't ask him that?
Overruled.
Do you know how many times they did that?
I do not.
Wouldn't it be unfair to the Paxtons to suggest that this picture here...
Objection to relevance is the way it's phrased, Your Honor. It's inappropriate.
Do you know whether the countertops that we see in this picture, do you know whether they've ever changed?
I do not know if they've changed now.
Okay. In evidence is Exhibit 346 to 353. You mentioned Steam Clean as one of the contractors, right?
Yes, sir.
And you had to deal with them?
I believe I was copied on email correspondence.
Okay. And did you know that there was more work that the Paxtons wanted beyond what Steam Clean was going to do?
I wasn't that involved in the detail of the Steam team.
Okay. Did you talk to us about how you had some involvement with an insurance adjuster?
The involvement being that I showed him the home? Yes.
And the insurance company was USAA?
I believe that's correct.
Let's look at what's in evidence of AG Exhibit 410, second page. Just catch the first page first, Eric. Can you confirm with me, Mr. Wicker, Drew, that the date of this correspondence from USAA is September 16th, 2020?
I can.
And let's turn the second page. Do you see that the policyholder is Warren Paxton, your former boss?
Yes.
Okay. And you see there's a claim number there?
I do.
And do you see this explanation for the benefits and the payments and the additional payments that are laid out there?
That's what it appears to be, yes.
And how often did you hear General Paxton complain about how slow the insurance company was on his claim?
Objection, Your Honor. What's good for the goose is good for the gander. That's hearsay.
Exactly. They've been hearing from General Paxton all trial.
He's our party opponent, Your Honor, not his own. He cannot proffer statements for Ken Paxton on his behalf from the stand. We get to use them against him. He doesn't get to offer them for you.
Sustained.
Do you see here it says $32,000 total cash out to you for all other covered repairs? Do you see that?
I do.
Did you ever have any involvement in trying to convince the mortgage company to release that check to the Paxtons?
I don't recall that now.
Okay. Did you understand that there were more repairs being made that Ken Paxton was claiming were covered from a different contractor?
Objection assumes facts not in evidence and counselors testifying.
Did you know?
Sustained.
Did you know that there was a different contractor doing some of the work in the Paxton's home.
Objection, Mr. Busby. That's twice the judge has sustained the objection to facts not in evidence.
He just testified to it in direct that he dealt with Kevin Wood. That's in evidence.
That's because it was a direct relationship based on his rational perception of the facts.
Did you deal with Mr. Wood? Did you see Mr. Wood at the home?
I did deal with Mr. Wood, yes.
Did you know that he was doing repairs and renovations to the home?
Yes.
Did you know that he was in fact the second contractor that's being referred to in the USAA docs?
No, I've never seen these documents.
Objection, assumes facts not in evidence. He's introduced a second contractor when all we know is the first and Cupertino.
I'm trying to figure out how it would be that Nate Paul's paying for repairs when in fact USAA is paying for some of them. You have any idea about that?
General Paxton expressed to me that he was paying things out of his own pocket as well as insurance.
Exactly. You knew that, for instance, the sink that they put into the home, you know that sink was replaced, right?
Objection, assumes facts not in evidence.
I'm asking him, Your Honor, how can we put it in evidence if I don't ask the witness?
Overruled.
Silly objections. You know that they were trying to replace their sink, right?
No, sir, I do not know that.
Okay. Do you know what the sink looks like now?
No, sir.
Do you know who paid for the sink?
No, sir.
Your Honor, we're going to offer AG Exhibit 433, which is all the pictures.
Objection, Your Honor.
That Angela, let me offer the exhibit first. All of the pictures that Angela Paxton had from her phone, all of these, where they were at Lowe's and Home Depot, pricing repairs to their home that they paid for out of their own pocket.
Objection, Your Honor. Assumes facts not in evidence.
Excuse me, Counselor. Let him finish. Okay. You have plenty of time to object.
With an affidavit from Senator Paxton herself establishing that these are records that they keep, that they kept, and she confirms that they are what she say they are, and they're non-hearsay, they're mostly just pictures.
Your Honor, Mr. President, if I may respond.
Exhibit 433, all the pictures from Angela Paxton's phone.
I'm not calling Senator Paxton's credibility on this issue.
Excuse me 1 second. Let me ask you, do you object?
I do.
What basis?
I am not calling the affidavit itself into question. What I am saying is there is inadequate information in that packet to establish it as relevant. For example, there are about 300 pages of what looks like scrolling online shopping or photographs from catalogs from Home Depot and Lowe's. They have no point of relevance. You don't know when the pictures were taken or by whom. So while she can establish they are her records, we do not know what they imply. There is nothing to show us what they fairly and accurately depict or when it was taken.
That's what the affidavit does. The affidavit specifically does what she claims it doesn't do.
She does not claim the time frame or when the pictures were taken.
Right here, Your Honor.
Can I see the affidavit?
You may.
Further, Mr. President, I would point out that their business record affidavit has not been on file for 14 days, and no metadata is included, which would have been easily provided if they'd done a Celebrite dump of the cell phone. One other point of order, Mr. President. The defense has not followed the rules established by this body in order to have a senator testify, which is de facto what is happening by affidavit. I want to encourage everyone to realize I'm not questioning that she signed what she believes to be a valid affidavit. It's that it is not in compliance with the rules, and it does not tell us what it purports to depict.
Your Honor, our mission here, this is Article 10, our mission here is to find the truth. And they have alleged that Ken Paxton and Angela Paxton, a member of this body, were bribed, that someone else paid for their house repairs. The documents you have in your hand directly contradict that and in fact prove the opposite. Those are proved up by affidavit. The pictures fairly and accurately represent pictures they were taking when they were pricing at Lowe's and Home Depot. They also have pictures of the house itself as it was undergoing renovations, and I'll compare those pictures with the pictures of the home now to demonstrate that all the things Angela Paxton wanted, like a new sink, she got.
Objection, Your Honor. Counsel continues to testify on behalf of his client. It is inappropriate. I ask that we approach and that the testimony be stricken and the senator's asked to disregard. I am not attacking a senator here, but he has to follow the rules of evidence because this is a court and we follow the rules.
Come on up. Come on up. You're still under oath. Please be seated. You did an excellent job of speaking loudly in the mic, so continue. Mr. Busby?
Yes, sir. I want to make sure we're all on the same page about what we're attempting to do here. Eric, would you mind putting in front of our senators Article 10, please? Drew, help me here a little bit. Article 10 alleges constitutional bribery. Do you see that?
Yes, sir, I do.
It says, in the second paragraph, specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Did I read that right?
Yes, sir, you did.
You understand that's the allegation being made, right?
Yes, sir.
Now, you had told us about a conversation you heard at the Paxton's Terrytown home, right?
Yes, sir.
It was you, it was General Paxton, and it was a gentleman named Kevin Wood in the kitchen, correct?
That is correct.
Now, of course, you've told us all that you never saw Nate Paul at General Paxton's home, true?
That is correct.
And you knew that the Paxton's home had water damage, right?
Correct.
And you knew Kevin Wood was the contractor, right?
That is correct.
And you knew that the Paxtons had decided to do some additional renovations at the same time they were fixing the water damage, right?
Yes, sir.
And you say you were in the kitchen with General Paxton and Kevin Wood, and they were talking about redoing the countertops, right?
That is correct.
And the mention was that Angela wanted granite countertops, right?
That General Paxton and her had both decided they would like granite countertops, correct?
And you said that at some point the cost of that was mentioned to be $20,000.
Yes, sir.
Okay. And you can't tell us here whether the Paxtons actually got these $20,000 countertops, can you?
No, sir.
Now, one way we could figure that out is for all of us to go to the Paxtons' home right now, couldn't we?
Yes, sir.
I mean, Your Honor, we could right now, if the court would allow it, get on a bus and drive over to Terrytown and look at the Paxtons' countertops. Could we do that, Your Honor?
Objection relevance, Your Honor. He can bring in photographs if he chooses to that were taken at a current time period.
I'm going to overrule. You simply ask a question of something I could do.
Yes, sir. And we may make a motion in that regard, but maybe we can fix it in this way, Your Honor. We had previously looked at an exhibit put into evidence by the House Board of Managers. Let's look at House Board of Managers 703. And Eric, if you would, turn to the 4th page of this exhibit that's in evidence. And we can see here, can we not, that Kevin Wood has a email that's sent on July 4th, 2020. Do you see that?
Yes, sir.
And he attaches some pictures of the home at that point in time, right?
I can't see that, but I do see that there are attachments.
Okay, now let's turn over, Eric, if we could, to the page bait stamped 29672 within that exhibit. And pull that up so everybody can see. And try to bring that picture up so we all can see it, Eric. All right, now we can see what that kitchen looked like as of July of 2020, can't we?
Yes, sir.
I want you to look very carefully at it. Can you see the stove?
Yes, sir.
Can you see the countertops?
It's a little bit grainy, but yes.
And that's how the house looked when you were in that kitchen with General Paxton and with Kevin Wood, isn't that right?
It was mostly covered up by renovations, but yes.
Now, so this is, we'll call this the before, okay?
Yes, sir.
This was the before, the suggestion that we're going to make those countertops granite, right?
Yes.
And we're going to redo the cabinetry, right? That's another thing you mentioned.
Yes, sir.
All right, now let's go back, if we could, to the picture that's in evidence and marked as AG 371. And bring that up. Eric has the most stressful job in this trial. No pressure, Eric. Okay. Here we have a picture of that same kitchen. Is that true?
It would appear so, yes.
And you see the same countertops that you saw in the previous picture, don't you?
It would appear so, yes.
And you see the same cabinets as in the previous picture, right?
Again, it would appear so.
So the question The question is,
I'm going to object, Your Honor, to relevance. I don't believe this is in the packet that we're referencing. Mr. Busby could cite me if I'm incorrect.
I've already said this is in evidence at AG 371.
Overruled.
The question is, when was AG 371 taken, right?
Yes, sir.
Because if this picture was taken on August 22nd of 2023, then anybody with any common sense would know that nothing was done to the cabinets or the countertops, right?
That would be correct.
May I approach the witness, Your Honor?
Yes, you may.
Before we testify about it, just confirm with me that what you've been handed, which is now...
Objection, Your Honor, to publishing a document that's not in evidence that he has not attributed for the record.
I have not published anything at this point, Your Honor.
The picture is on the screen, Mr.
That's the picture AG 371. This is something different.
Overruled.
Now, take a look at what I've handed you, AG 1051, and would you confirm with me that the picture you're holding in your hands is the same picture that we see on the screen, which is AG 371?
It appears so, yes.
And do you see the exhibit you're holding in your hand has, in fact, the date and where the picture was taken?
It does.
Your Honor, we offer AG 151.
Have you shown it to the defense?
May I see a copy and the date that was referenced?
It's coming to both of us. We'd like to have one. Okay.
Give a copy to the other side.
Give it to them first. And you can give us a copy. Sir, you can give us a copy. Oh, that's the only one you have.
You have another copy?
Mr. President, I don't want to stave off his direct, but cross, but I think that I can clear something up if I could take Mr. Wicker on a brief for Dyer. I think he's been misled as to the date and time of the photograph he had originally identified.
Again, Your Honor, I'm asking this witness if he has now the date the picture was taken on a cell phone, the exact same picture that's already in evidence. It's not very hard. We're going to get to the truth here.
Overruled.
Tell us, sir, the date of the picture you have in your hand.
It states that it was Tuesday, August 22nd, 2023 at 4:50 p.m.
And where was the picture taken?
It says Austin, Terrytown.
Your Honor, we offer AG 1051.
Do you object?
I do, Your Honor. Objection hearsay. He hasn't established a proper predicate to make it relevant to this trial. It doesn't have an address, and Mr. Wicker cannot say that he fairly and accurately depicts something that he's actually seen.
Overruled.
Now, Eric, please publish for the ladies and gentlemen of this distinguished jury the picture of the Terrytown Paxton home that was taken in August of this year. Do you see there, sir, that the cabinets have never changed?
It would appear so, yes.
Do you see there, sir, that the countertops have never changed?
Mr. President, I'm sorry, I must insist. He's provided metadata, but without any source for it. I am not trying to impugn his character, but this is a court of law, and he has to establish the predicate for the information that's contained below. He has not done that, and he intends to rely upon it. It is hearsay.
It's in evidence already, Your Honor. You've ruled on it. It's in evidence.
Your Honor, with all respect to Mr. Busby, he's misleading you. The photograph is in evidence. The information contained beneath it is not. That's what he's asking you to do now.
Again, we can look back with the court reporter. I offered 1051. The court allowed it.
In that case, Mr. President, it is fully within your discretion to correct an error. I am not conceding that it is admitted, but if it were, in light of the fact that he cannot establish that anything beneath that photograph is true and he intends to dance upon it, I would ask that the court help correct that issue.
That picture, Your Honor, as you can tell, is the same picture that's in evidence. The only addition to it is now we know exactly when the picture was taken and where it was taken.
which establishes the exact issue, Your Honor. There is no one here who can establish whether or not this picture was in fact taken August 22nd, 2023, and any 12-year-old can create that graphic on a computer.
Your Honor, this lawyer is suggesting that me, an officer of this court, has somehow doctored a picture when I've offered to go over to the home right now and look at the kitchen and it'll look exactly like that. Why would somebody who has an obligation as a prosecutor to find the truth try to prevent the truth from coming out? This is an evidence. The picture's in evidence already. The court's allowed now the picture and evidence that shows when it was taken. I would allow.
I am not trying to impugn anyone's character. I am acting as a prosecutor and a rule follower, and I expect to do that here so no misimpressions are left with the court.
This is allowed in evidence.
Thank you, Your Honor.
Overruled.
Now, you care about the truth, don't you, Drew?
Yes, sir.
And you want the truth to come out, don't you?
I believe it has to.
Yes, it's important, isn't it?
Yes, sir.
And now we see that the picture of the Paxton home, we can see that there were no work done on the countertops, can't we?
Yes, we can.
We can see that there was no work done in the cabinetry, can't we?
Yes, sir.
Pretty clear, isn't it?
From those images, yes.
Accusing someone of bribery for accepting granite countertops and new cabinetry is a very serious allegation, isn't it?
I would agree.
And you understand that Mr. Paxton, General Paxton, has no obligation to prove anything, right? He's being accused.
Yes, sir.
He didn't have to prove anything, does he?
Yes, sir.
But we've proven that the countertops were not altered in any way, haven't we?
The countertops appear to have not been altered.
The cabinets have not been altered in any way, have they?
It would appear that way, yes, sir.
And in fact, we've created a comparison picture. It's exhibit 1052, AG 1052. May I approach? Can we agree, Drew, that 1052 that you're holding in your hands is a picture, the one on the left is the one we just looked at, right?
Yes, sir.
And the one on the right is the one we looked at from Kevin Wood, right?
That is correct.
And they're side by side on this exhibit, true?
That is correct.
And we know the one on the right was taken in July of 2020, right?
Yes, sir.
And we know the one on the left was taken years later, August 2023, don't we?
Yes, sir.
We offer 1052.
Do you have a copy of that? Would you please provide a copy?
To clarify, I see AG 371 and I see House Board of Managers 73 on 1052. Which one of these two photos is supposed to be 1051?
I'm not answering her questions, Your Honor. I've offered this exhibit.
Then I object to relevance.
This is a comparison, as I've laid out with the witness. He's established the relevance of this picture. It compares the one taken in years back in 2020 with the one taken last month. We'd offer it.
Overruled.
Will it be accepted, Your Honor?
What is the number again?
1052.
1052 is admitted into evidence.
Thank you, Your Honor. So can we agree, Drew, that your concerns now have been put to bed, at least with regard to the countertops and the cabinetry?
With regards to those two items, yes, sir.
I mean, now you're satisfied, right?
Yes, sir.
Okay. Now, I want to show you some other documents and evidence. I mean, it shouldn't be that a friend, a family member has to prove their innocence, should it?
In a court of law, my understanding is that they're supposed to provide evidence to answer the charges. The answer to your question is no, you're innocent until proven guilty.
Yeah. AG Exhibit 332. Thank you, Eric. This is an invoice. Can you tell us all the date of the invoice?
The date of the invoice is September 1st, 2020.
And the invoice is from whom?
Cupertino Builders.
And I just want you to keep that date in your mind, September 1, 2020. Can you do that for me, Drew?
Yes, sir.
All right, Eric, go to AG Exhibit 410. Can you see the date there on this USAA claims correspondence?
September 16th of 2020.
So here we are 15 days after that invoice that we saw previously.
Yes, sir.
And turn the page, Eric. And we can see as of that time, the claim being made with regard or with USAA is being administered?
Yes.
Okay. AG 428. Drew, this is a document that's in evidence from the state of Delaware. Do you see that?
I do.
And do you see it's a document related to Cupertino Builders?
I do.
And can we agree that that's the same entity that we saw in the September 1, 2020 invoice?
Yes, sir.
And would you look at the very bottom line that gives us the date that that company was incorporated in the state of Delaware?
It appears that the filing was April 16th of 2020.
So what we know is in April of 2020, Cupertino Builders was incorporated in the state of Delaware.
Yes, sir.
And we know that months later, it issued an invoice to the Paxtons for work on their home.
That's correct.
Go back to the invoice, please, Eric. Go back to AG 332, Eric. I just want to look at this invoice that was issued September 1, 2020, okay? Turn to the second page, Eric. Do you see the total amount invoiced to the Paxtons for the renovations of their home?
$121,000, $817.
Do you have a pen with you?
No, sir, I do not.
First the witness? Yeah. Drew, would you do me the favor of writing down the amount of that invoice on your Post-it note there? $121,617.
Yes, sir.
And we know, of course, that Cupertino Builders was a Delaware corporation as of the time this invoice was issued.
That is what it says.
Let's look now at AG Exhibit 48. And turn, Eric, if you would, to the Bates stamp EBT 184. These are some text messages between General Paxton and a guy that we might hear from in this case named Chip Loper, all right? And could you pull that text up, Eric? We saw that invoice was due on September 30th, 2020, right?
That is correct.
And now we have a text from General Paxton to his blind trust, or his trustee of his trust, instructing him to make a payment, don't we?
That is what the text message says, yes.
And confirm with me, if you would, that the amount that Chip Loper, the trustee, is being instructed to pay is exactly the amount that's on your Post-it note that you just wrote.
I can confirm.
Say it again.
I confirm that.
Exact, right?
Yes, sir.
Eric bring up AG Exhibit 47? So what we've seen so far, Drew, is we've seen an invoice that's due on September 30th, right?
Yes, sir.
We've seen a text from Mr. Paxton to his trustee instructing him to pay, right?
Yes, sir.
And we know those amounts are the same, true?
Yes.
And now what we have in front of us is a bank statement from Prosperity Bank, right?
That is what it says.
And would you please confirm with me, go to page, we're looking at AG 47, go to page 116, EBT 116. And would you confirm that the day after Mr. Paxton, General Paxton, sent the text to his trustee that a wire was made from Mr. Paxton's account of $121,617?
I can.
And is that the same number that you wrote on your Post-it note?
Yes.
And let's go to AG 333. Do you see here that this is another record from a bank, BBVA?
I do not see BBVA. Oh, yes, I do. Okay. At the very
Business Choice Checking account?
Yes, sir.
And can you confirm that that account received a wire in the exact same amount as you wrote on your Post-it note?
Yes.
And it matches to the letter, to the penny, the amount of the invoice?
Yes.
And the amount of the wire out of the Paxton's account?
I don't see where this says that this is the Paxton's account.
We saw the previous Paxton's account. What we've seen is the invoice, the wire out, and the wire in, haven't we?
Yes.
Okay. When you raised your concern, because, I mean, that's what you raised it first with some of the folks in the office. Is that how it went?
I sought advice from a trusted individual who brought me into the office first, yes.
Is that Brickman?
No, sir, that was Mark Rylander.
Okay, so you went to Rylander and said, look, I heard something that sounds a little weird. What do I do?
Yes.
Because you didn't know what to do about it.
No, sir.
And what he told you to do, hey, just raise it with General Paxton, right?
His advice was that if I was comfortable raising it with General Paxton, that I do so, and that I also informed Blake Brickman as my direct report.
Okay. And he told you that your understanding was just wrong, didn't he?
That is what General Paxton said, yes.
He also told you he appreciated you bringing that to his attention, right?
That is correct.
And you accepted that, didn't you?
Yes.
And it seemed logical, didn't it?
I still had some questions, but yes, I did take it at face value.
And he never told you not to tell anybody, did he?
No, sir.
I mean, he never said, hey, keep it on the down low, Drew, did he?
No, sir.
He told you specifically, Drew, I'm paying for these renovations, but I appreciate you sharing that with me, but that is not what this is, right?
Yes, sir.
And you took his word for it, didn't you?
I took his word for it.
Now, you don't have any personal knowledge about any relationship General Paxton may or may not have had with anyone named Laura Olson, do you?
I've only witnessed them together the one time.
So you don't have any personal knowledge about their relationship other than you saw a woman come out of an elevator, right?
I saw Laura Olson come out of an elevator, yes.
Okay. Now, these trusted people you mentioned in the office, you were talking to them often, weren't you?
On a daily basis.
Y'all were friends?
Yes.
Did you know they took General Paxton's name off the letterhead?
I don't know what
Objection, Your Honor. Facts not in evidence and proven to be false in the course of this trial.
Sustained. Did you ever discuss with them taking General Paxton's name off his own letterhead?
No.
Objection, Your Honor. Question calls for hearsay and it's facts not in evidence.
Sustained. Now, just so we're clear, you are not accusing or providing any evidence that General Paxton did anything wrong in this case, are you?
The only evidence that I bring to the table is what I overheard and what I've reported. That is it.
Pass the witness, Your Honor.
Watch your foot. I don't want to hit your foot there. That's all right. Your witness.
Thank you. Mr. Wicker, you sometimes ran personal errands for General Paxton, is that right?
That is correct.
When you did that, were you advised which service you were using, the campaign fund money or work money? Did you have to attribute where money was spent or your time was spent?
I wasn't compensated for most of those services, so no, I was not.
Okay, thank you. The second, because Mr. Busby asked you extensive questions, you told us that the damage was in the bedroom, correct?
Yes.
And did you see actual renovations anywhere in the home outside of the bedroom?
Yes.
Is it fair to say if you knew people were looking into your countertops and your cabinets, you might choose at that point not to get them upgraded?
Objection, speculation, Your Honor.
Sustained.
Okay. Do you know, in the course of working with the adjuster and looking at Steam Clean and those groups that work for the insurance side, or let me do this differently. Do you know that payments were made by insurance?
I do not know that firsthand, no.
But we've all taken as a given, I think, through the course of talking to Mr. Busby, that more further renovations were done, correct?
Yes, and that's what the document said.
Okay. I want to clarify something else, and I'm sorry to put you on the spot. When Mr. Busby was showing you pictures of the kitchen, do you have an independent memory now in regards to what those what the countertops looked like, or are you taking his word for it?
To the best of my recollection, those were the countertops.
I do not want to lead, so I'm going to ask you a question only because of a prior conversation. The answer doesn't really matter, but I want to clarify. Didn't you say redo the granite countertops when we first spoke? Meaning what was being changed may or may not be granite again?
That was a mistake on my part, and as I mentioned to both you and Mr. Busby, I had to amend that statement to be more consistent with other statements made to law enforcement.
I see. So you've already had a conversation specific about this with Mr. Busby?
I did.
Okay. Have you and I had this particular conversation?
To the best of my recollection, yes.
Okay. And so when you made that correction for yourself, it's not because you were lying the first time, right?
No.
Okay. What is the most relevant part of that conversation with Kevin Wood? The renovations, which we know took place, which people only know about because of you, or the state of the cabinets and countertops?
Objection, Your Honor. Leading, number one, and number two, I don't think it's appropriate to ask the witness what's most relevant. That's the court's job.
I think I've made the point. It's okay. I'll move on.
Sustained.
Thank you. How many times did you hear the phrase, "I'll have to check with Nate"?
3 times.
Over the course of one day or multiple days?
In the course of one conversation.
Thank you, sir. Do you have any question then that on 3 different occasions, the response to a question directed at Kevin Wood about financial impact of renovations was, "I'll have to check with Nate"?
That is correct.
Since you've already spoken to Mr. Busby, let me ask you a few questions about that. How did your conversation go? Did you call him or did he call you?
Whenever we were in preparing for this trial, every effort was made whenever the House team reached out to offer the same thing for the defense. And it was in response to that, in preparation for this testimony here today, that my counsel and I both reached out to Mr. Busby's team to have a conversation prior to me taking the stand.
It's an honorable and fair thing to do. Had you made prior efforts to speak to Mr. Busby or Paxton's team?
My legal counsel had, yes.
On your behalf?
Yes.
And at any point until the last week, did they take you up on that?
They did not.
He asked you a lot of questions about whether or not you overheard an agreement between Nate Paul and Ken Paxton. Do you recall that?
Yes.
Do most people who are working together stand on top of a mountain, hands on their hips, and say, "I'll do this for you if you'll give me X"?
Objection, Your Honor. It's an improper question. Leading and sustained. I mean, come on.
Do you understand that law enforcement and this investigative body can use circumstantial evidence to determine whether or not there's a conspiracy?
I'm sorry to interrupt. Objection, improper question. Speculation. Sustained.
Yes, Your Honor. Let me do this differently then. Do you have any memory of when the Paxtons moved back into their home?
This would have been probably August, September timeframe, if I had to guess.
Okay. May I approach the witness, Your Honor? For the record, I'm showing him what's marked as 698 and not in evidence as a document to refresh his recollection. Mr. Wicker, do you recognize that?
I do. If you can just give me 1 second to read.
Yes, sir.
Can I get a copy of that, Your Honor? We'd like to have a copy.
I mean, in candor, there are multiple copies over there, but I don't have them. May I take his and pass it around?
Yes, give it to the defense first. We'll stop the clock for a moment. Are you ready?
I am.
You can resume the clock.
Since we do have a copy for everyone, I'm going to change course, actually. This is a text message that's included in 698, which is a set of documents provided with a business records affidavit, which have been provided to defense, and they've had notice of it for over 14 days, at which point I would move to admit 698.
I have no objection to this, Your Honor.
The court will admit Exhibit 698 into evidence.
And would you publish? Thank you, Stacy. Who is this a conversation between?
This states to be a conversation between myself, Mark Rylander, and Jeff Mateer.
What is the date?
It appears to be July 19th of 2020.
Okay. And do you see any reference to when the Paxtons might be moving back into their home?
It appears that it was around that time frame. So, judging by the context here, he had been storing clothes at the AG's office, and we moved those back around that time frame.
Okay, so fair to say then the Paxton's home was at least renovated enough for them to return to it in the middle of July?
Yes.
And would it surprise you to know that nowhere in those Cupertino records is there an invoice or estimate at any time during June or July?
I did not see that.
Leading, Your Honor. I'm going to have to object to leading.
Sustained.
Next, let me ask you. Let's turn to item 683, which is already in evidence. And Mr. Wicker, I'm sorry to take advantage of you since you're on the stand, but I need to recap a couple of things Busby went through. Tell me, if you would, the date on this document.
September 30th of 2020.
This document has been admitted as what we refer to as the cease and desist letter. So notice to Brandon Kamek to stop working. Are you aware of that time frame in the office?
I am.
And do you know that Brandon Kamek reaches out to Ken Paxton to let him know their problems?
I learned this later, yes.
But does this email corroborate what you heard?
Objection, I'm sorry. He just said he heard it later. That's hearsay. Now she wants him to corroborate hearsay with something else improper.
Sustained.
Okay, let's look at the document itself. September 30th, cease and desist letter to Brandon Kamek. Let's look at item 130. Do you see the date on this letter?
September 30th, 2020.
Is that 1:30? Oh, yes, ma'am, please. Sorry, Stacy. Thank you. Do you see September 30th referenced on this document as well?
I do.
And in the records provided by Esther Blind Trust, this is the first conversation about payment to Cupertino. Would that surprise you?
I was not aware of Esther Blind Trust, so I'll take your word for it.
So, but September 30th, Brandon Kamek is notified that there's a problem. Ken Paxton finds out, and the first thing he does is tell the Esther Blind Trust to send $121,000 to someone else.
Okay.
I'm going to turn your attention to item 223. I think this is also not in evidence, so do not yet. It is in? I got thumbs up from the side. In that case, will you pull up item 223? I'm going to have you scroll down, Stacy, to the return. Do you recall General Paxton being out of town at the end of September, early October, as the whistleblowers are coming forward and law enforcement is being notified that they're concerned he's accepting bribes and misusing the office? These questions are no different than the way he phrases them.
If I could, without being interrupted. Your Honor, this is outside the scope. I just want to flag that for the court. I'm going to let her do this because I want to talk about a few of these things that are outside as well.
It is outside the scope, but he's not objecting, so he will be able to do the same.
Yes, Your Honor. If it would have been helpful, though, I took extensive notes. Mr. Busby opened up all of these doors for me. Yes, sir. Thank you.
You're both out of scope, okay? You're both free.
On October 1st, do you know where General Paxton was in regards to the office? Did he come in?
No, ma'am.
And I'm going to have Stacy scroll down a little. Are these texts between you and Jeff Mateer?
Can you scroll up? Yes.
And what is it that you understood on October 1st was happening with the general?
I really didn't have an understanding at that time.
Did you think anything about the fact that he wasn't there or didn't want you to let people know what he was doing?
Objection, Your Honor. Leading, and he's already said he doesn't know.
I'm going to read from a document because it is in evidence. Says he has a lot to do out of the office and that I'm to tell anyone that asks that I don't know where he is. Is he telling you to lie?
I don't know that he's asking me to lie, just to state that I don't know where he is.
Stacy, if you would please turn to Exhibit 131. Pause for a moment. In the upper left-hand corner, do you see that this account is affiliated with the Esther Blind Trust?
I do.
The same organization that was being told to make payment the day before by text, at least according to the documents and evidence before you.
Yes.
Do you see, scroll down for me. Do you see that same $121,000 payment, $617, being made as it was requested by Ken Paxton?
I do.
And do you see who the recipient is?
Cupertino Builders, LLC.
Miss Stacy, if you'll pull up 703 for me, please. I'd like to see page 21. All right, Mr. Wicker, do you see who is supposed to be the count holder on these documents? It's under business choice checking, specifically choice.
Cupertino Builders, LLC.
And do you see the first line in the transaction sheet?
It shows an incoming wire in the amount of $121,000, 617.
Consistent with Cupertino being paid for remodeling or doing work at Ken Paxton's house, if that's what he has alleged, correct?
Yes, ma'am.
Let's turn to page 3. These are the same records that include Kevin Wood, the contractor who you personally met, who helped facilitate whatever upgrades Ken Paxton might want, a person whose email address suggests he is Nate at World Class, and an individual named Raj Kumar. Is that correct?
Yes, ma'am.
Stacy, may we see the face of the business record affidavit? Do you see before you that the business records we've been referencing and that are already admitted belong to Cupertino Builders?
Yes.
Would it surprise you to know that, as Mr. Busby pointed out, it's when they were in Delaware and before they opened a Texas affiliate? Would you have any reason to be surprised by that?
Objection leading, Your Honor. Sustained.
Do you also see that the individual otherwise referred to as Raj Kumar is in here named, I'm gonna butcher it, frankly, on the second page? Narsima Raju Sigaraju.
I do see that.
It was a valiant effort. I saw your smile. Next, Stacy, may we see page 16? Is this the same invoice Mr. Busby showed you a moment ago?
It appears to be, yes.
The same invoice that he splashed in his press conference for representation of General Paxton?
Objection, Your Honor. Improper question. She's talking about the press conference? I mean, that's not proper. I'm going to sustain, rephrase.
Stacy, if you would for me, please turn to page 22. Now, Mr. Wicker, in all of the records before you, if there had been payments or estimates or supplies or timelines or communication in regard to payment in any way, in regards to Ken Paxton and Cupertino, don't you think Mr. Busby would have pointed it out?
Objection, Your Honor. Leading. Sustained.
Then the very last thing I would like to ask you is this. In regards to the document, the invoice we had just looked at, this document is the metadata that was provided by Cupertino. It is already admitted into evidence. Please tell me what date that invoice was created.
October 1st, 2020 at 7:50 p.m. Central Standard Time.
After the whistleblowers, after he knows that you're aware of the renovations, after a cease and desist, after directing payment, only after all of those things does he get the first piece of documentation that would in any way credit that it was valid.
Objection, leading. Sustained.
I guess I'll end where the defense began. There are no coincidences in Austin. But the next piece, I think...
Objection to the sidebar. We've had a lot of sidebars in this... a little bit of sidebar. I'll give you a sidebar. They've had a few. One sidebar. Overruled. You're even now on sidebars, okay?
The very last piece, I wish I could have ended there, but I need to get in the Uber records we discussed yesterday. The court had already said that they could be admitted after extensive arguments between both sides. I just failed to offer on the record for their admission.
Go ahead.
House moves to admit item. Sorry. 700.
700 will be... Take care of this? We've already settled that, right? 700 yesterday. Okay, 700 will be admitted into evidence. Your Honor, can we be heard on that? I think we have... I didn't know this would not be the right witness for this, but can we be heard on those records?
We spoke extensively and the court ruled yesterday.
Your Honor, we saw... apologize.
I'm going to object to using the time, and may we approach?
Okay. We'll stop the clock for a moment. Approach.
Okay, Victor?
This is some exciting testimony. I'm enjoying what I'm seeing right now. And it's...
Ask you this, Victor, we haven't talked about this. We've asked some of our not to be.
Questions or the lack...
Court will come back to order. Where were we? Ms. Epley, were you up here? I think you were.
So when we last left, and you can restart the clock, you were asking to admit 700.
Yes, Your Honor.
There was an objection. We've looked at the two documents. I had ruled that in yesterday. We see that they are similar, and so 700 is admitted into evidence.
Thank you, Mr. President. Pass the witness.
Eric, would you do me the service of putting on the screen what's in evidence, House Exhibit 571?
Objection, Your Honor. I don't believe this document has been admitted.
We offer 571 if it's not in evidence.
I'd ask that he take it off the screen, Your Honor.
Take it off the screen for now, Eric. We all know Eric.
We love Eric.
And everyone knows Stacy.
It's actually in evidence, I'm told.
We're checking. You don't have it? We'll check. Is this the House or AG's?
House Board of Managers Exhibit 571.
That is, Ms. Epley, it is in evidence according to our records.
Thank you, Your Honor.
Very good. Thank you.
All right.
Pull it on the screen, Eric, and make it big, and make sure you capture the time and date of this text. Get the date too, Eric. I'm gonna need somebody to confirm the date. Penley 5. As we're getting this date, can you see there that there's a text sent from Jeff Mateer to General Paxton where he tells the general that yesterday each of the individuals on this text made a good faith report of violations of law?
I can.
Do you know what date that was done?
I do not.
Okay. If this text was sent on October 1st, because we know they went to the FBI on September 30th, that means they were sending this text the day after, correct?
Yes.
On October 1st, 2020. Make sense?
Yes.
So on October the 1st, 2020, Jeff Mateer, along with several other individuals, sent this text to General Paxton, right?
That is what it appears to be, yes.
Now let's look back now, if we could, Eric, at the date and time that the general instructed his trustee to wire the money to pay for his home renovations. You heard the suggestion, I'm sure, Drew. You heard they suggested he only did that because he knew that his people had went to the FBI?
Objection, compound. I don't understand the question.
Overruled. Yes. You heard that suggestion, didn't you, Drew? That the general learned that a few of his subordinates went to the FBI and therefore he hurriedly sent a text to pay for his house repairs? You heard that?
That was the insinuation in the last line of questioning, yes.
That's what she was insinuating, wasn't it?
That is what I understood, yes.
But the truth is, if we look at AG Exhibit 48 and we go to EBT 184, could you just tell us all, so we'll be clear about how the timing actually was? What was the time and date of when the general instructed his trustee to pay for his home renovations?
September 30th.
And that's also the same date that the invoice was due, right?
That is what the invoice said was due, yes.
Okay, and can we agree that September 30th, 2020 is before October 1, 2020?
Yes, sir.
Now, when we talked previously, I failed to ask you something that's real important. First, did these folks, how many times did you interview with these folks over there to the right?
I've spoken with them 3 times in preparation for this.
Okay, and the only reason you spoke to me is because you felt it would be fair to let me have a chance to talk to you as well after you had talked to them.
Anytime they reached out, I reciprocated and extended the same offer.
Okay. Did they ever show you any of the documents I showed you today?
Not to my recollection, no.
They didn't show you the bank wire showing that General Paxton and Angela Paxton paid for their renovations?
Not to my recollection.
They didn't show you the text message to the trustee instructing the payment?
Not to my recollection.
They didn't show you the document showing that the wire was actually received by the contractor?
Not to my recollection.
You ever wonder why they didn't do that?
Objection, Your Honor. Question calls for speculation.
Sustained. There was a suggestion that you delivered some kind of document to Nate Paul. Remember that suggestion?
Yes.
You said it was a manila envelope?
Yes.
You had told us that you picked up an envelope from Vassar that had a CD taped to it?
I don't recall that it was taped.
It was inside of it?
No, sir, it was on the exterior.
On the exterior of the envelope?
Yes.
You know for sure you didn't deliver that envelope to Nate Paul, don't you?
Not that envelope, no.
Okay, let's be clear. Whatever Vassar gave you that was checked out, you didn't check anything out, did you?
No, sir, there were signatures on the document, but I don't recall checking anything out.
Right. Vassar gave you something that you gave to the general, right?
That is correct.
And that particular document had a CD on the outside of the envelope.
That is correct.
And that certainly was not the envelope delivered to Nate Paul, was it?
Objection. Question calls for speculation and lack of foundation based on Drew Wicker's previous testimony.
Sustained. Did the document or the envelope that you delivered to Nate Paul, did it have a CD on the exterior?
It did not have a CD on the exterior.
Okay. And just so we're clear, you never met Nate Paul in the dark of night in an alleyway and delivered anything, did you?
No, sir. It was in the afternoon.
In the light of day?
Yes.
It wasn't a secret at all, was it?
No, sir.
You did hear some conversations between Nate Paul and General Paxton, didn't you?
Yes.
Let's focus on what you heard. One of the things that was discussed was whether the raid by the federal agents.
Objection. Normally I wouldn't mind, but since I tried to elicit this exact testimony and don't want to waste the senator's time with a second redirect, I must object to hearsay.
She already asked this question, Your Honor. I'm just clarifying what she asked this young man.
I did ask it, and he objected despite me being absolutely certain it would come in. And at this point, he doesn't have the same exception because Ken Paxton is not his party opponent.
Sustained. Sir, you know that the focus of the conversation was whether the raid was just. Isn't that true?
Objection. Question calls for hearsay.
Sustained. You know that the discussion that they had was whether the FBI had followed the rules, right?
Objection. Question calls for hearsay.
Sustained. You know that Mr. Paxton, General Paxton's discussion was whether the feds had violated the law. Isn't that right?
Objection. Question calls for hearsay.
Again, Your Honor, we've heard, he talked all about what Ken Paxton has said, and I'm entitled to explore that, exactly what was said.
He successfully shut down this entire line of questioning, whether he should have or shouldn't have, and he shouldn't be given the latitude now because he does not have an exception to hearsay.
Overruled. You know that what your boss was saying was whether Nate Paul had been unfairly targeted, right?
In the discussions that I was privy to, Nate Paul did most of the talking.
Whether he had been unjustly targeted, right?
That was the concern that he expressed.
Because you know sometimes the legal system gets politicized, don't you?
Objection. Relevance.
He was asked this by the Board of Managers, Your Honor.
Overruled.
You know that sometimes the legal system gets politicized, don't you?
Yes, sir.
And Mr. Paxton, General Paxton's concern was whether there had been a miscarriage of justice. Isn't that right?
Objection. Question calls for speculation.
He said it in his own words, Your Honor.
He can't say that in his own words, Your Honor.
Sustain.
Now, you knew that General Paxton had some distrust of DPS, didn't you?
Objection, relevance, and hearsay.
Overruled.
You knew that, didn't you?
I did.
You never heard General Paxton say he was going to do anything for Nate Paul. Isn't that true?
He never stated that he would take any action directly on his behalf, no.
Now, there was some suggestion about something that you delivered in a manila envelope, right?
Yes, sir.
Was it like this one?
Yes, sir.
Just like this?
Very, very similar, if not the same.
You don't know what was inside of it?
No, sir, I did not look.
You have no evidence to offer about what was in the envelope?
No,
Objection
again,
asked
I
and
did
answered.
not.
You do know, of course, that it was a couple of pages at most, right?
What I stated was that I do not recall the thickness of the document.
Was it this thick?
Again, sir, I do not recall.
You can't say that it was anything near this thick, can you?
Objection, Your Honor. Inconsistent with his prior testimony, he's mischaracterizing the evidence. Mr. Wicker used his fingers to show roughly, 2 centimeters to an inch in thickness, which is consistent with what is in Tony Busby's hands.
I appreciate all the speaking objections you ask us not to do, but I'd like to finish up so we can get on down the road.
Overruled, go ahead.
Now, could it be, let me ask you, did you ever exchange texts with Nate Paul?
I don't recall any text exchanges, no.
May I approach the witness, Your Honor?
You may.
Would your text refresh your recollection?
If there are any, yes.
Now, you got a chance to look at the document without testifying what's in the document. Does that refresh your recollection?
Yes.
Okay. You had told us that packet, not a packet, the manila envelope you delivered was sometime in the summer, maybe even the fall, right?
No, sir. The testimony that I provided was summer.
Summer, June, perhaps, right?
Yes, sir. Earlier in the day, I stated that it was likely May or June.
And that text you had that you were exchanging with Nate Paul was in June of 2020. Isn't that true?
Yes.
And you exchanged text with Nate Paul before you delivered an envelope just like this one, didn't you?
Objection, Your Honor.
I'm asking the man a question. I'm entitled to an answer.
Overruled.
You exchanged text with him before you delivered an envelope just like this one. Isn't that true?
Objection, Your Honor. It assumes facts, not evidence. Drew Wicker has been very clear about the timeline, and Mr. Busby.
Overruled.
Didn't you?
I don't recall whether or not this text message occurred before delivery or after.
Can we agree that you were texting Nate Paul about Dick Weekly?
That is what the text messages show, yes.
Can we agree that you delivered to Nate Paul information about an event Dick Weekly was holding because Dick Weekly was trying to get Nate Paul to donate money to Texans for lawsuit reform?
No, sir.
You don't remember that?
No, sir, I do not.
Can we agree that that text that you're holding in your hand confirms that you were texting information about Dick Weekly to Nate Paul?
It does.
Your Honor, with that, I pass the witness.
The briefest of redirects, please, Mr. President.
Get one.
You're back up.
May I proceed?
You may.
Is the conversation you had with Dick Weekly, if it existed at all, something that would have to be delivered by hand to Nate Paul?
No.
What was it? What was the construct of the conversation?
The conversation that I'd had with Dick Weekly was with General Paxton on his Dick Weekly's back porch, in which we were engaging in a fundraising conversation. I do not recall Nate Paul having been mentioned, and if it was any information tied to TLR, I don't see why that couldn't have been sent via email, if that's the question.
So completely made up in regards to this, to your knowledge?
Objection leading, and also, Your Honor, I'm just curious, if we're going to keep questioning the witness, you're going to get extra turns like this?
You'll get one more cross and then we're done, because this is the first time we've gone to 2 redirects, and you'll have a chance to recross.
All right, guys, it's been a long day. From what we can gather, a number of senators have left the building and deliberations have concluded for the night. The clock has been taken down. It was somewhere around 8 hours, I believe, is how long that they have been deliberating. She's got it back up. A little over 8 hours. We are being told that they will be back tomorrow at 9 a.m. and then it'll be another potentially long day. Lieutenant Governor Patrick had said they would deliberate until as late as 8 o'clock tomorrow, and then starting at noon on Sunday, and then, if necessary, sequestering them if they cannot come to a verdict on Sunday. So I will be back tomorrow. I will have Bernadine Steptoe, our WFA political producer, and Bud Kennedy with the Fort Worth Star-Telegram will be coming back, and we'll also have Matt Yarbrough coming back tomorrow. He's once worked in the Attorney General's office, and so we'll be back here on to watch and see what the Senate jurors decide. Thank you for watching us. See you tomorrow.